هذا وين احط هذا؟ احط في خمسة خيل عندي.
ليه بدك تطفي قبل ما ياكل الكاس؟ ها؟
او اسمعي هنا حط خمسة خيل. ها؟ حط خمسة خيل.
معك جنزير له؟
تبعي.
في جنزير. خذ جنزير. الصبح بلاش الاسم اللي قلت مسوي جبته ولا لا؟ والله مسوي من هنا قبل 3 شهور. نايم جوا. الله وين راح العاود؟
لا صاروا 3 أيام هذا.
هسه الاخبار جديد؟ في شيء بالاخبار جديد؟
حاج كان 5 دقايق المفروض يعني. ضبط الموضوع. شنو قاعد قدم
هي راح على الرحله الخطه تبع المنار بس يطلع مديرهم تمام بده يجيب له مفتاح من البلس وهذا دخلك على حمام الغيبه جاب حمام الكفر هذا تحت هذا احلى لا هذا مدولنا ابو اسماعيل رفيقنا لبنان ليش تأجلت لبكره؟ مين اللي بأجل؟ اللي بده يشتغلها بدنا عده بس بدي وقت عده حط زي شحن اجيب ازاز زين زين
شو السنة هو؟
والله هو من الوضع العسكرية هو ضربة عماد حجر 50 مناطق 50 زلزلة ده بالقمع كل يوم بسحبها على الإسلام كل يوم بدأت من بس ما هو عماد تيست معاه اشتغل من قبل نهار تبع تبع المعبر ما توقعوها أكثر والله ولا حاجة زي كتاف العون زي كتاف العون زي كتاف العون
هو اللي قاعد يدير ويرفع عرض يعني تعرف ليش تفكر كذا اللي قاعد يدير عارف
لو جاب لنا اياهم لو جاب لنا اياهم المهندس علاء كان اجنبي كثير يعني انت تتخيل عالم ضرب قاعد جوا في شيء قاعد ولع سيجاره واحيانا يمكن ولع سيجاره
يمكن حرقه هو
يمكن حرق الجهاز هو لسه شغال
يقول لهم في مشكله
ايوه الحين هيك مضغوط هي حاجه بتعمل تشكله انا مستني هو اسماعيل ودي شعر ما في وجهها لا ماليش على الكارت ايش باقي
كل اصحابه يعني انا افتخر الحين انا اول سؤال سالته والله ايش بضربه اول ما دخلت
زي برميل وين بنس وين بنس هيا الدجا بكون في المنطقة يا عم اقول على اللي عندكم على اقول لك بنطلون شلموني لهم هذا على الوحيد وعلى توليد يا عم قولوا لي بنطلون ترينجو بلوز وكلح
انا على جاري انا بالحاره
احلى حاجه على ايش
ساعه
شوف حاجه السوالف
يصير
الدكتور هيجي لك لا
عملية ميلاد غزة
شكل ولا شيء. لا لا وين الكلبة؟ وين الجزء؟ وين الجزء؟ والله دلع كاس كرتون مو بشكل. هاي الساعة 9 تعال على 9:30. أمجد أمجد تعال تعال.
جانا تصريح.
والله احنا محررين دير البلع. يوسف يوسف ريان يوسف
هاتيه مع السباك
ماجد ولا كمون يا زلمه
والله هاي في الشاب تبع السيارة اللي بخش هيو تمام؟ ابو اسماعيل بيقولوا له هاي بده يخش على الحمام هيو بتطلع من جوا قول له انا ابو اسماعيل وهو ابو اسماعيل اسمه قول له بدي اخش
مش داخل غير انا ورد عليك.
وين ايش يا كوت؟ وينه؟
سيبك من الهبل دور الصلاة اللي على الجروب هذول.
في واحد هو اللي بضرب هذا اللي بضرب.
يا عم هذا الزلمه طلع فيستك يا عمي.
قلت لك من البداية
دي
Boostlet. Let's outlet.
اصبر اشوف.
هنا على المجازر.
شاي يابا. شاي 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 شاي.
شوفوا الكاميرات. ما تكرر مع فواسير وخلص اقول لك تصالح مع نفسك
ولعته شحدها منه واحد قبل شوي.
هذا واحدة من 50 ولعة. سيجارتين وين؟
ابو اسماعيل اقول له
كان تيلي ايه ولا ايش فيه؟ ايش فيه النظام؟
سامع شو بقول له؟ بقول له بعد ما فكرت
شفتك وانت
الشيء الوحيد الحلو فيها العسل
ودي رفيقك تعال بدي اياه.
يا راجل الله يرحم ابوك. ابوك وين استشهد؟ ابوك استشهد في عشان ايش؟ عشان تنزل السرعه، وانت شكلك حتلحق ابوك عشان جاب الغاز. واحد لابتوب السيارة؟ لا كل حاجة على عشرة ارفع الحرام ولبس منزل ابو ايوب المسطح فاضي الظاهر.
شايف ايش يعني حياة
الحق شغل الاسعاف
كونتينر حياة يا رب يقدر
وأجهزة مراقبة سريعة.
تعال محمود
طبعا من خلال 6 ساعات 8 ساعات نقدر نطلع الشمال. زي الاصحاب ونطلع والله لا نوصل لمرحله تنسيق النسيق. يقول لك الخواجات رنين على ميوب الفضه قالوا لهم الضاع شاطين الضاع. رنين عليه. شوف خاطين.
فكرة العالم ثاني. وين
ايش مالك يا شيخ عساك بخير.
والله شو اسمه
صحيح الفوز صرباية بس اختفى مراية. معاك سرور معاك ورا نجقة
عن جد يا علي.
ايه ايه ليش جاي ليش عساك بخير؟ وين بشوف شاري لك
كنا
شاري لك
قبل مناش بس خلاص.
ايش مالك؟
اليوم لقينا بنت بعد اسبوع.
لا هي كيف؟ وين ما في الفرن؟
اليوم اجت الجزء قلت اليوم
كل كذابين. شوف الشارع. اعطيها الاغنية. اسحب. لا احد بضغط ايده اقول له ابو عرب بشد عليك قرنية. ليه بقصد عليك ليه؟ ليه بدي اياها بصير؟ لا يا راجل. شوفك بتطفيل هيك ها؟
Mr. Sauer?
Mr. Chief Justice, and may it please the court. Without presidential immunity from criminal prosecution, there can be no presidency as we know it. For 234 years of American history, no president was ever prosecuted for his official acts. The framers of our Constitution viewed an energetic executive as essential to securing liberty. If a president can be charged, put on trial, and imprisoned for his most controversial decisions as soon as he leaves office, that looming threat will distort the president's decision-making precisely when bold and fearless action is most needed. Every current president will face de facto blackmail and extortion by his political rivals while he is still in office. The implications of the court's decision here extend far beyond the facts of this case. Could President George W. Bush have been sent to prison for obstructing an official proceeding or allegedly lying to Congress to induce war in Iraq? Could President Obama be charged with murder for killing U.S. citizens abroad by drone strike? Could President Biden someday be charged with unlawfully inducing immigrants to enter the country illegally for his border policies? The answer to all these questions is no. Prosecuting the president for his official acts is an innovation with no foothold in history or tradition and incompatible with our constitutional structure. The original meaning of the executive vesting clause, the framers' understanding and intent, an unbroken historical tradition spanning 200 years, and policy considerations rooted in the separation of powers all counsel against it. I welcome the court's questions.
Mr. Sauer, to your last point, could you be more precise as to the source of this immunity?
The source of the immunity is principally rooted in the executive vesting clause of Article 2, Section 1.
And how does that happen?
The source of it, Justice Thomas, I think is, as you described in your separate opinion in Civitovsky, for example, that the executive vesting clause does not include only executive powers laid out explicitly therein, but encompasses all the powers that were originally understood to be included therein. And Marbury against Madison itself provides strong evidence this kind of immunity, a broad principle of immunity that protects the president's official acts from scrutiny, direct sitting in judgment, so to speak, of the Article 3 courts. That matches the original understanding of the executive.
So how exactly would we determine what an official act is?
I point the court to two cases for that. Obviously, Fitzgerald against Nixon is the best guidance that the court gives, where the court adopted the outer perimeter test. And this court engaged in analysis there that's very instructive here, where it looked at the level of specificity at which the acts are described. In that case, a civil case. Here it would be the indictment.
Well, what if you have, let's say, the official act is appointing ambassadors, and the president appoints a particular individual to a country, but it's in exchange for a bribe. Somebody says, I'll give you $1 million if I'm made the ambassador to whatever. How do you analyze that?
That, I think, would fall under this court's discussion in Brewster, where the court held, with respect to legislative acts, that bribery is not an official act, which also matches the common law background. So the way that this court in Brewster kind of sliced at the joint was to say accepting the bribe and the agreement to sex the bribe are not official acts. That's private conduct.
Okay, it's not.
An appointment would be essentially an unrestrictable power of this court that Congress couldn't directly regulate.
It's not, accepting the bribe isn't an official act, but appointing an ambassador is certainly within the official responsibilities of the president. So how does your official acts or the official acts order boundary come into play when it's going to be official, assuming that the president is innocent? But the whole question is whether he's going to be found innocent or guilty.
Again, I think Brewster and Johnson do address that, or very persuasively at least, in a slightly different context. Brewster and Johnson say the indictment has to be expunged of all the immune official acts. So there has to be determination what's official, what's not official.
Well, you expunge the official. You say, okay, we're prosecuting you because you accepted $1 million. They're supposed to not say what it's for, because the what's for part is within the president's official duties?
There has to be, we would say, independent source of evidence for that. And keep in mind that this indictment charges what this court has described as unrestrictable powers of the president. So the premise, the logical premise of this indictment is that Congress, by passing vague and general criminal statutes, has purported to directly regulate the president's exercise of things like the exercise of the appointment and removal power, things like his ability to speak directly to the American public, core exercises of his authority under the Recommendations Clause to recommend to Congress, members of Congress, the measures he thinks necessary and expedient. So you have an indictment in this case that goes right to the heartland of the president's powers, that alleges a whole series of official acts and tries to tie them together by saying, well, there's a private aim or a private purpose in that case, and that's a situation which, of course, could be alleged in virtually any indictment.
Counsel, it can be alleged, but it has to be proven. Malum in se is a concept long viewed as appropriate in law, that there's some things that are so fundamentally evil that they have to be protected against. Now, I think, and your answer below, I'm going to give you a chance to say if you stay by it. If the president decides that his rival is a corrupt person and he orders the military or orders someone to assassinate him, is that within his official acts that for which he can get immunity?
It would depend on the hypothetical, but we can see that could well be an official act.
It could, and why? Because he's doing it for personal reasons. He's not doing it like President Obama is alleged to have done it, to protect the country from a terrorist. He's doing it for personal gain. And isn't that the nature of the allegations here? That he's not doing these acts in furtherance of an official responsibility. He's doing it for personal gain.
I agree with that characterization of the indictment, and that confirms immunity, because the characterization is that there's a series of official acts that were done for an unlawful.
No, because immunity says even if you did it for personal gain, we won't hold you responsible. How could that be?
That's an extremely strong doctrine in this court's case law in cases like Fitzgerald.
Well, we go back to Justice Thomas's question, which was, where does that come from? There are amici here who tell us that the founders actually talked about whether to grant immunity to the president. And in fact, they had state constitutions that granted some criminal immunity to governors. And yet, they didn't take it up. Instead, they passed an impeachment clause that basically says you can't remove the president from office except by a trial in the Senate, but you can impeach him after. So, or you can impose criminal liability. We would be creating a situation in which we would be saying, this is what you're asking us to say, which is that a president is entitled not to make a mistake, but more than that, a president is entitled for total personal gain to use the trappings of his office. That's what you're trying to get us to hold, without facing criminal liability.
Your Honor, I would say three things in response to that. First, the doctrine that immunity does not turn on the allegedly improper motivation or purpose is something that this court has reaffirmed in at least 9 or 10
That's
cases.
absolute immunity, but qualified immunity does say that whatever act you take has to be within what a reasonable person would do. I'm having a hard time thinking that creating false documents, that submitting false documents, that ordering the assassination of a rival, that accepting a bribe, and countless other laws that could be broken for personal gain, that anyone would say that it would be reasonable for a president or any public official to do that?
Your Honor, as this court said very persuasively, in Fitzgerald, the allegation that this particular act would be done for an unlawful purpose or was unlawful could be made in every case. And therefore, if that were the doctrine, that the allegation of improper purpose is what deprives the objective acts of their immunity, then the immunity would have no purchase. And that's reflected in many of the other court's cases.
Isn't the work, though, of the improper motive, at least in the absolute immunity context, to tell us what are official acts and what are not? I mean, I'd understood that even in the first of all, your ask is absolute immunity, isn't it?
That's our principal position.
That's your position is you want the same kind of doctrine that we've applied in other contexts when we say an official has absolute immunity. And my understanding is that when we say that, we mean for their official acts. Is that right?
Yes.
Okay, so any official acts, then in that world, the real decision-making from the court standpoint is whether or not something is an official act or not, correct?
That is an important determination by all means.
I mean, that's the determination in the absolute immunity world, because if you determine that it's an official act, then the principle is that you get immunity for it, correct?
That is correct.
All right, so my question, and I think the Chief Justice may have asked this at the beginning, is how do you determine what, or maybe Justice Thomas, how do you determine what is an official act? And when we're talking about the kinds of scenarios that Justice Sotomayor brought up, one could say that when the president is using the trappings of his office to achieve a personal gain, then he's actually not acting officially, even if the doctrine was absolute immunity. So what do you say about that?
Two things in response to that. First, to the last point, that allegation that this was really motivated by an improper private purpose could be made in every single case.
No, I understand that, but it would have to be made. I'm just trying to assess. Even if we had the doctrine of absolute immunity, that same allegation and the facts related to it would come in because the person would be arguing that he was not acting in his official capacity. He wasn't doing something official. He was doing it personal, correct?
I agree. The objective, or I'm not sure I agree, but the point I would make in response to that is in Fitzgerald against Nixon, this court emphasized that would result in an intrusive discussion or determination of the president's personal motives for every official act. And again, this is not just in the case of the presidency.
All right, can I just ask you another quick question before my colleagues take it over here? At the beginning of your analysis, when you were giving your opening statements, you were talking about you suggested that the lack of immunity and the possibility of prosecution in the presidential context is like an innovation. And I understood it to be the status quo. I mean, I understood that every president from the beginning of time, essentially, has understood that there was a threat of prosecution, if for no other reason than the Constitution suggests that they can be prosecuted after impeachment. The Office of Legal Counsel has said forever that presidents are amenable to a threat of prosecution, and they have continued to function and do their jobs and do all the things that presidents do. So it seems to me that you are asking now for a change in what the law is related to immunity.
I would quote from what Benjamin Franklin said at the Constitutional Convention, which I think reflects best the founders' original understanding and intent here, which is at the Constitutional Convention, Benjamin Franklin said, "History provides one example only of a chief magistrate who was subject to public justice, criminal prosecution, and everybody cried out against that."
No, I understand, but since Benjamin Franklin, everybody has thought, including the presidents who've held the office, that they were taking this office subject to potential criminal prosecution, no?
I don't. I see the opposite. I see all the evidence going the other way. Marbury against Madison, Mississippi against Johnson discussed this broad immunity principle that naturally.
So what was up with the pardon? What was up with the pardon for President Nixon?
I think
if everybody thought that presidents couldn't be prosecuted, then what was that about?
Well, he was under investigation for both private and public conduct at the time, official acts and private conduct. And I think everyone has properly understood that the president, since like President Grant's carriage riding incident, everyone has understood that the president could be prosecuted.
Counsel, on that score, there does seem to be some common ground between you and your colleague on the other side, that no man's above the law, and that the president can be prosecuted after he leaves office for his private conduct. Is that right?
We agree with that.
And then the question becomes, as we've been exploring here today a little bit, about how to segregate private from official conduct that may or may not enjoy some immunity. And I'm sure we're going to spend a lot of time exploring that. But the D.C. Circuit in Blazing Game, Chief Judge there, joined by the panel, expressed some views about how to segregate private conduct for which no man is above the law from official acts. Do you have any thoughts about the test that they came up with there?
Yes, we think in the main that test, especially if it's understood through the lens of Judge Katz's separate opinion, is a very persuasive test. It would be a great source for this court to rely on in drawing this line. And it emphasizes the breadth of that test. It talks about how actions that are, plausibly connected to the president's official duties are official acts. And it also emphasizes that if it's a close case or it appears there's considerations on the other side, that also should be treated as immune. Those are the aspects of that we'd emphasize as potentially guiding the court's
discretion. And that left open, in that case, the possibility of further proceedings and trial.
Exactly right. And that would be a very natural course for this court to take in this place. The court can and should reverse the categorical holding of the D.C. Circuit that there's no such thing as official acts, especially when it comes to...
But you'd agree further proceedings would be required?
That is correct. There would have to be, and I would point the court to Anderson against Creighton, where the court said there'd be kind of two stages to these further proceedings. There's looking at the indictment itself, or in that case it was a complaint, but look at the charging document itself and see whether on the face of it this is alleging official acts, and if not, or it can't be determined, then there'd be a factual proceeding. And all that, under Mitchell against Forsyth and so forth, would have to occur before any other proceedings in the district.
Mr. Sauer,
go ahead. Mr. Sauer, you began by explaining why you believe that immunity from criminal prosecution is essential for the proper functioning of the presidency. But my question is whether the very robust form of immunity that you're advocating is really necessary in order to achieve that result. So just to take one possible alternative, suppose the rule were that a former president cannot be prosecuted for official acts unless no plausible justification could be imagined for what the president did, taking into account history and legal precedent and the information that was provided to the president at the time when the act was taken. Would that be sufficient, or if it is insufficient, why would it be insufficient?
That might be a much better rule than what emerged from the lower courts here. We think it would be insufficient because, again, that long line of cases talking about using the president's motives and the intrusive consideration of the president's motives as transforming acts to official and unofficial would come into play. And of course, once you can make that allegation, all of a sudden you've opened the door. You no longer have a per se clear bright line rule. You have a determination in every single case.
Well, what if it were not? What if it did not involve any subjective element? It was purely objective. You would look objectively at the various relevant factors.
That sounds to me a lot like Blazing Game, and especially viewed through the lens of Judge Katz's separate opinion, and that may not be different than what we're proposing to the court today.
Well, Blazing Game had to do with the difference between official conduct and private conduct, right?
That's correct. I understood the court to be asking that.
No, this would apply, and just a possibility. I don't know whether it's a good idea or a bad idea, or whether it can be derived from the structure of the Constitution or the vesting clause or any other source. But this would be applied in a purely objective, on purely objective grounds when the president invokes an official power in taking the action that is at issue?
Yes, I believe the reason I think of blazing game is because it talks about an objective, context-specific determination to winnow out what's official and what is purely private conduct. And again, with a strong degree of deference to what.
I'm sorry. If I understood Justice Alito, he's suggesting not that. He's suggesting whether, even if it is an official act, whether you still grant immunity if that act is not plausibly viewed as within the realm of law. He can correct me if I'm wrong.
That was the question.
That, I think, would be a superior rule than the categorical denial that emerged in the trial court here. I do think it would
I'm not quite sure why he used the word plausible, because that seems to negate, might as well give absolute if you're saying plausible, because anybody could argue plausibility. We don't even require plausible, we require reasonable in qualified immunity. So, well,
I mean, one might argue that it isn't plausibly legal to order SEAL Team 6, and I don't want to slander SEAL Team 6 because seriously, they're honorable officers, and they are bound by the Uniform Code of Military Justice not to obey unlawful orders. But no, I think one could say that it's not plausible that is legal, that action would be legal. And I'm sure I've thought of lots of hypotheticals. I'm sure you've thought of lots of hypotheticals where a president could say, I'm using an official power, and yet the president uses it in an absolutely outrageous manner.
That, if we're an objective determination, may well be an interesting approach to take.
So apply it to the allegations here. What is plausible about the president assisting in creating a fraudulent slate of electoral candidates? Assuming you accept the facts of the complaint on their face, is that plausible that would be within his right to do?
Absolutely, Your Honor. We have the historical precedent we cite in the lower courts of President Grant sending federal troops to Louisiana and Mississippi in 1876 to make sure that the Republican electors got certified in those two cases, which delivered the election to Rutherford B. Hayes. The notion that it's completely implausible, I think, just can't be supported based on the face of this indictment, or even
knowing that the slate is fake. Knowing that the slate is fake, that they weren't actually elected, that they weren't certified by the state. He knows all those things.
The indictment itself alleges, I dispute that characterization. The indictment affixes the word label to the so-called fraudulent electors. It affixes the word fraudulent, but that's a complete mischaracterization. On the face of the indictment, it appears that there was no deceit about who had emerged from the relevant state conventions, and this was being done as an alternative basis. But I want to address a more higher level point, a fundamental point, which is that, as Justice Alito's question indicated, there's a whole series of structural checks other than criminal prosecution that are designed to deter these kind of, outlandish scenarios or extraordinarily obviously illegal things. And that's been viewed in this court's opinions going all the way back to at least Martin
Where
against
do you
Mott.
think the D.C. Circuit went wrong in how it determined what was official versus what's personal?
Well, I read the opinion below in this particular case as adopting a categorical view. It does not matter is the logic of their opinion, because there is no immunity for official acts, and therefore, that's the end of the story. I don't really think they went wrong in blazing game in the civil context when they engage in the same determination with respect to what's official and what isn't official. There, we agree with most of what that opinion says.
And for some official acts that are not within the Article 2 exclusive power, and so official acts but not within the Article 2 exclusive power, even for those, I assume you would think that a clear statement has to be required, a clear statement in the statute covering the president if the president's official acts are going to be criminalized.
Absolutely. Obviously, the issue is, at the highest possible level when it comes to the unrestrictable powers, like as in this indictment, the allegation.
Well, I'm assuming the exclusive powers are walled off and can't be prosecuted before there's a lot of official powers that are not exclusive to the president under his Article 2 authority. But for those, I understood you to be saying at a minimum there would need to be a clear statement in the statute referencing the president so that the president's on notice and can conduct himself or herself accordingly.
That's absolutely correct, and that'd be consistent both with Franklin and Public Citizen in cases, a long series of other clear statements.
Can I follow up on that?
Because go ahead.
Go ahead.
So you concede that private acts don't get immunity?
We do.
Okay. So in the special counsel's brief on pages 46 and 47, he urges us, even if we were to decide or assume that there was some sort of immunity for official acts, that there were sufficient private acts in the indictment for the case to go back and the trial to begin immediately. And I want to know if you agree or disagree about the characterization of these acts as private. Petitioner turned to a private attorney who was willing to spread knowingly false claims of election fraud to spearhead his challenges to the election results. Private?
As alleged, I mean, we dispute the allegation, but
Of course.
Sounds private to me.
Sounds private. Petitioner conspired with another private attorney who caused the filing in court of a verification signed by petitioner that contained false allegations to support a challenge.
That
Private.
also sounds private.
3 private actors, 2 attorneys, including those mentioned above, and a political consultant helped implement a plan to submit fraudulent slates of presidential electors to obstruct the certification proceeding, and petitioner and a co-conspirator attorney directed that effort.
You read it quickly. I believe that's private. I don't want to.
So those acts you would not dispute. Those were private, and you wouldn't raise a claim that they were official.
As characterized, what we would say, Your Honor, if I may, what we would say is official is things like meeting with the Department of Justice to deliberate about who's going to be the acting Attorney General of the United States.
Sure.
Communicating with the American public, communicating with Congress about matters of enormous
Thank you. Thank you.
Thank you, counsel. And what is the consequence in terms of going forward with your acknowledgement that those are private acts as opposed to official acts?
If you look at the indictment here, there's a bunch of acts that we think are just clearly official. There may be allegations that mostly relate to what the government has described here as private aim or private end, and the court should remand or address itself, but remand for a Brewster-like determination, which is what's official and what's private. The official stuff has to be expunged completely from the indictment before the case can go forward, and there has to be a determination, at least on remand, of what's official, a 2-stage determination of what's official and what's private.
Well, if you expunge the official part from the indictment, how do you, I mean, that's like a one-legged stool, right? I mean, giving somebody money isn't bribery unless you get something in exchange. And if what you get in exchange is to become the ambassador to a particular country, that is official, the appointment. It's within the president's prerogatives. The unofficial part is I'm going to get $1 million for it. So if you say you have to expunge the official part, how does that go forward?
This particular indictment, where we say virtually all the overt conduct is official, we don't believe it would be able to go forward. I mean, there could be a case where it would, but if you look at even the government's brief in this case divides up the indictment into things that, other than the electors' allegations, don't really they haven't disputed that they are official acts, but what they do is say, well, we tie it all together by characterizing it as done, and these are the allegations that the court just referred to, by an improper private aim or private end. Again, that's their words, and that just runs loggerheads, dead set against this court's case law, saying you don't look at, when immunity determinations, the improper motivation or purpose.
Thank you. Justice Thomas?
Mr. Sauer, in assessing the official acts of a president, do you differentiate between the president acting as president and the president acting as candidate?
Yes, we do, and we don't dispute, essentially, the blazing game discussion of that.
Okay.
But of course, that has to be done by objective determinations, not by looking at what was the purpose of what you did this. And that's the most important point there.
Did you, in this litigation, challenge the appointment of special counsel?
Not directly. We have done so in the Southern District of Florida case, and we totally agree with the analysis provided by Attorney General Meese and Attorney General Mukasey. And it points to a very important issue here, because one of their arguments is, of course, that we should have this presumption of regularity. That runs into the reality that we have here an extraordinary prosecutorial power being exercised by someone who was never nominated by the president or confirmed by the Senate at any time. So we agree with that position. We hadn't raised it yet in this case when this case went up on appeal.
Justice Alito?
When you say that the official act should be expunged from the indictment. That in itself would not achieve very much unless evidence of those official acts were precluded at trial. So is that what you're saying, that the prosecution should not be permitted at trial to prove the official acts as part of the conspiracies that are alleged?
Absolutely, and we think that's just the clear implications of Brewster and Johnson and their discussion of this in a very analogous context.
Thank you.
Justice Sotomayor?
I'm a little bit confused by that. If you have a scheme to defraud or a scheme to accept bribery, there's evidence from which you can infer that scheme, and one of it is that the appointment actually happened. It's an official act. You wouldn't expunge that as evidence. You would instruct the jury that there's no liability for the actual appointment, that the liability is for accepting the bribe. Similarly here, I don't think the indictment is charging that the obstruction occurred solely because of conversations with the Justice Department. They're saying you look at all of the private acts and you look in the context of some of the public acts, and you can infer the intent, the private intent from them. So I'm not sure that I understand why your problems couldn't be taken care of at trial with an instruction, if we believe, if the court were to find, I'm not even sure how they could, but if it were to find that some public acts could not be the basis of criminal liability.
I think the best thing I can say to that is, and I think this ties into the Chief Justice's question about a one-legged stool, Brewster and Johnson in subsequent cases like Heltowski versus Meaner essentially say that this is a one-legged stool problem. It will be difficult for some of these prosecutions to proceed, and that is the implications of official immunity, which is dictated in the Constitution here by the Executive Vesting Clause.
Justice Kagan?
Can I continue on in Justice Barrett's vein a little bit and ask you about some of the allegations of the indictment and whether they're official acts or not in your view? So the defendant signed a verification affirming false election fraud allegations made on his behalf in a lawsuit filed in his name against the Georgia governor.
I don't think we've disputed that that's official. I'm sorry, that is unofficial.
That's unofficial. Same for the defendant called the chairwoman of the Republican National Committee, asked her to gather electors in targeted states, falsely represented to her that such electors' votes would be used only if ongoing litigation in one of the states changed the results in the defendant's favor.
We have taken the position that that is official.
That's official?
Yes.
Why would that be official?
Because the organization of alternate slates of electors is based on, for example, the historical example of President Grant is something that was done pursuant to and ancillary and preparatory to the exercise of the core recommendation clause power. So when President Trump
couldn't he have taken this action just in the status of a candidate?
The fact that he could have done so doesn't demonstrate that he did do so in this case, and based on the allegations, we think it's clear he did not, that this was done in an official capacity.
The defendant asked the Arizona House Speaker to call the legislature into session to hold a hearing based on their claims of election fraud.
Absolutely an official act for the president to communicate with state officials on a matter of enormous federal interest and concern, attempting to defend the integrity of a federal election, to communicate with state officials and urge them to view what he views as their job under state law and federal law. That's an official act.
Well, attempting to defend the integrity of the election, I mean, that's the defense. The allegation is that he was attempting to overthrow an election.
Essentially, exactly right. And neither allegation of what the purpose is should make a difference as to whether it's immune. That is extremely strong precedent from this court.
Does it strike you as odd that your understanding of immunity goes way beyond what OLC has ever claimed for a former president?
I view the OLC opinions here as strongly supporting us, because any time a congressional statute basically got anywhere near touching the president's prerogatives, they've said, oh, we're going to interpret the statute narrowly to avoid that. So
well, that's a different question. I mean, what OLC has always said is that sitting presidents get immunity, but former presidents, no. Now, there might be a different argument made about whether a statute or whether a statute as applied to particular conduct is properly available against the president. But that's a very different argument than the immunity claim that you're making here, which OLC has definitively not supported.
I don't know if I put it that way. I don't recall an opinion directly addressing it, but more fundamental to us, Your Honor, is in fact the language of cases like Marbury and statements like made by Benjamin Franklin at the Constitutional Convention, statements of George Washington talking about the massive risk of factional strife and how that could destroy the republic and erect a new government on the ruins of public liberty. That's what we rely on principally here. I cite the OLC opinions because, of course, what you see there is a very strong trend that if there's any statute that might trench in any way on the president's prerogatives, which they interpret it to avoid that.
If a president sells nuclear secrets to a foreign adversary, is that immune?
That sounds like, similar to the bribery example, likely not immune. Now, if it's structured as an official act, he would have to be impeached and convicted first before...
What does that mean if it's structured as an official act?
Well, I don't know in the hypothetical whether or not that would be an official act. You'd probably have to have more details to apply the Blazing Game analysis or even the Fitzgerald analysis that we've been talking about.
How about if a president orders the military to stage a coup?
I think that, as the Chief Justice pointed out earlier, where there is a whole series of, sort of guidelines against that, so to speak, like the UCMJ prohibits the military from following a plainly unlawful act. If one adopted Justice Alito's test, that would fall outside. Now, if one adopts, for example, the Fitzgerald test that we advanced, that might well be an official act, and he would have to be, as I'll say in response to all these kinds of hypotheticals, has to be impeached and convicted before he can be criminally prosecuted. But I emphasize to the court that...
Well, he's gone. Let's say this president who ordered the military to stage a coup. He's no longer president. He wasn't impeached. He couldn't be impeached. But he ordered the military to stage a coup, and you're saying that's an official act.
I think it would depend
That's immune.
I think it would depend on the circumstances whether it was an official act. If it were an official act, again, he would have to be impeached.
Well, what does that mean, depend on the circumstances? He was the president. He is the commander-in-chief. He talks to his generals all the time, and he told the generals, I don't feel like leaving office. I want to stage a coup. Is that immune?
If it's an official act, there needs to be impeachment and conviction beforehand because the framers viewed that kind of
If it's an official act, is it an official act?
If it's an official act, it's impeachment.
Is it an official act?
On the way you've described that hypothetical, it could well be. I just don't know. You'd have to, again, it's a fact-specific, context-specific determination.
That answer sounds to me as though it's like, yeah, under my test, it's an official act, but that sure sounds bad, doesn't it?
Well, it certainly sounds very bad, and that's why the framers have a whole series of structural checks that have successfully, for the last 234 years, prevented that very kind of extreme hypothetical. And that is the wisdom of the framers. What they viewed as the risk that needed to be guarded against was not the notion that the president might escape, a criminal prosecution for something, sort of very, very unlikely in these unlikely scenarios. They viewed much more likely and much more destructive to the republic the risk of factional strife discussed by George Washington.
The framers did not put an immunity clause into the Constitution. They knew how to. There were immunity clauses in some state constitutions. They knew how to give legislative immunity. They didn't provide immunity to the president. And, not so surprising, they were reacting against a monarch who claimed to be above the law. Wasn't the whole point that the president was not a monarch and the president was not supposed to be above the law?
I would say two things in response to that. Immunity, they did put an immunity clause in a sense. They put in the executive vesting clause, which was originally understood to adopt a broad immunity principle that's set forth in the very broad language of Marbury against Madison. And also, they did discuss and consider what would be the checks on the presidency. And they did not say, we need to have criminal prosecution. Right there at the Constitutional Convention, Benjamin Franklin says, we don't have that. That's not an option. Everybody cried out against that as unconstitutional. The structural check we're adopting is impeachment. And they're very clear on that in pages 64 to 69 of the second volume of Farrand.
Thank you.
Justice Gorsuch?
Just returning to the Chief Justice's hypothetical about the ambassador sale and bribery. Congress has a statute that specifically names the president and says he can be criminally prosecuted for bribery, presumably after he leaves office. Outside the core areas that Justice Kavanaugh was talking about, when Congress speaks clearly, couldn't a statute like that, Congress provide a statute like that would allow all manner of evidence to come in to prove the case?
I think our position is that would have to be an unofficial act, purely private conduct for that prosecution to go forward.
All right, but outside the core areas of executive power, if there is a clear statement from Congress that something is unlawful and it applies to the president, I'm struggling to see why in that case, perhaps, the evidence could come in.
Yeah, the strongest possible case, in our view, is what you've described as kind of the core executive powers, the unrestrictable powers within the meaning of SELA law. But again, the holding of, for example, Brewster and Johnson that we've relied on doesn't turn on how central it is of a legislative act. It just says if it's an official act, which here we would say applies basically the outer perimeter test of Fitzgerald against Nixon, that doesn't come in.
What would happen if presidents were under fear that their successors would criminally prosecute them for their acts in office, whether they're engaged in drone strike, all the hypotheticals? I'm not going to go through them. It seems to me like one of the incentives that might be created is for presidents to try to pardon themselves. Do you have any thoughts about that?
That is, didn't think of that until Your Honor asked it. That is certainly one incentive that might be creative. What we think is most important.
We've never answered whether a president can do that. Happily, it's never been presented to us.
And if the doctrine of immunity remains in place, that's likely to remain the case for those very issues. As Fitzgerald, I think, very powerfully emphasized, the real concern here is there going to be bold and fearless action? Is the president going to have to make a controversial decision where his political opponents are going to come after him the minute he leaves office? Is that going to unduly deter? Is that going to dampen the ardor of that president to do what our constitutional structure demands of him or her, which is bold and fearless action in the face of controversy?
And perhaps if he feels he has to, he'll pardon himself every 4 years from now on.
But that, as the court pointed out, wouldn't provide the security because the legality of that is something that's never been addressed.
Now, one of the checks and balances, in addition to impeachment that you've discussed, is subordinate liability. You don't contest that everybody following an unlawful order beneath the President of the United States can be immediately prosecuted, do you?
I'm sorry, if the court is asking whether they
could be... If the President gives an unlawful order, call in the troops, all the examples we've heard, every subordinate beneath him faces criminal prosecution, don't they?
That is what Gouverneur Morris said explicitly at the Constitutional Convention, that is, coadjutators could be prosecuted. There is an important caveat, because, of course, there would have to be a statute that would govern that for them to be prosecuted.
Oh, we've got lots of statutes. The criminal law books are replete. But, I mean, do you agree, is that one check that's available?
Absolutely. And again, the only caveat that I was making is if that statute was doing what Marbury says you can't do, which is going after the subordinates to restrict, for example, a core executive function, the Franklin Clear Statement Rule might be triggered, and you might not be able to go after that president. So I don't think Congress can say, well, we can't go after the president directly, but we're going to criminalize the way that the president speaks to Congress under the exercise of the Recommendations Clause, and therefore we're going to put in a criminal statute that says if you provide false information to Congress in carrying out the president's recommendation powers, you can be immediately prosecuted. That would at least be a very difficult question. But the fundamental point of drawing that distinction between the president himself and his coadjutators, in the word of Gouverneur Morris of the Constitutional Convention, is an excellent distinction.
Justice Kavanaugh?
Just follow up on the OLC opinions question. As you read them, and I think I read them, they articulate a clear statement rule as to this court's cases for covering official acts. And your point, I think, but I just want to underscore this, is that none of the statutes alleged here or cited here have a clear statement covering the president, therefore meaning that the president can't be charged for any official acts under these statutes.
That's absolutely correct. They're extended way beyond. I mean,
that's separate from the question what's official versus what's personal. But for that bucket that is official, there's no clear statement period.
That's right. And as to purely private conduct, we don't think the clear statement rule would be invoked. But as to official acts, these statutes, the ones charged in the indictment, are just way far afield from purporting to criminalize in clear terms the president's official acts.
And then, just to clarify this, the president's not above the law, the president's not a king. The founders thought that. I think your point in response to that is the president is subject to prosecution for all personal acts, just like every other American for personal acts. The question is acts taken in an official capacity.
That's correct. And even those, of course, if there was an impeachment and conviction, could be prosecuted on our view. And we'd emphasize the whole series of structural checks in addition to that, which deter those and have successfully deterred presidential misfeasance for 234 years.
Then on the source of immunity, it's not explicit in the Constitution, but also executive privilege is not explicit in the Constitution, yet in United States versus Nixon, the court unanimously said that the Article II executive power in the Constitution encompassed executive privilege, and the same principle presumably would apply to executive immunity being encompassed within that executive power as historically understood.
That's absolutely correct, and there's a very telling passage in Free Enterprise Fund where this court talked about how there's a letter from James Madison to Thomas Jefferson at the time of the founding where Madison said, hey, as to the removal power, they did not expressly take this away, so the 1789 Congress understood that it was left in place. So if the original understanding of the executive vesting clause is broad enough to encompass that, it would have to be expressly taken away, which is the opposite of the presumption that they're advancing here.
And then lastly, I think you've acknowledged in response to others' questions that some of the acts in the indictment are private, and your view is that some are official. Is it your position then that that analysis of which is which should be undertaken in the first instance by the D.C. Circuit or the district court?
Most likely the district court under the logic of Anderson.
Thank you.
Justice Barrett?
So, Mr. Sauer, you've argued that the impeachment clause suggests or requires impeachment to be a gateway to criminal prosecution, right?
Yes, I think that's the plain meaning of that second phrase in the clause.
Okay, so there are many other people who are subject to impeachment, including the 9 sitting on this bench, and I don't think anyone has ever suggested that impeachment would have to be the gateway to criminal prosecution for any of the many other officers subject to impeachment. So why is the president different when the impeachment clause doesn't say so?
Someone very important has made the opposite suggestion as to the president himself, which is Solicitor General Bork, which is reaffirmed in the OLC opinions on this, where Solicitor General Bork in 1973, as to the issue of the vice president, reviewed the historical materials, and he said the sequence is mandatory only as to the president. That is DOJ's view of the original understanding of the impeachment judgment clause, which is exactly our position. The sequence is mandatory only as to the president. Keep in mind that the criminal prosecution of a president prior to impeachment contradicts, in our view, the plain language of the Constitution, but also hundreds of years of history, and what DOJ admits is the framers' intent. And so we say that that practice, whatever its validity, should not be extended to this novel context where it clashes with the constitutional structure.
What if the criminal conduct isn't discovered until after the president is out of office? So there was no opportunity for impeachment.
We say the framers assume the risk of under-enforcement by adopting these very structural checks. As Justice Scalia said in Morrison against Olson, the separation of powers prevents us from righting every wrong, but it does so that we do not lose liberty.
Okay, and the special counsel makes a point that I think is a pretty compelling one. You admit that if the president were successfully impeached, that he could be criminally prosecuted after impeachment, right?
Assuming the prosecution was for the same conduct of which he was convicted, not impeached, he must be convicted. That word conviction is right there in the clause.
Okay, granted. But you also say that these criminal statutes, unless they explicitly mention the president, don't apply to him. So how can you say that he would be subject to prosecution after impeachment while at the same time saying that he's exempt from these criminal statutes?
Well, there are statutes, as they concede, where Congress has purported to do so.
2 or 3.
They haven't done a comprehensive review. I think it looks like all they did was text search for president in 18 U.S. Code. Again, under Franklin, that's a very telling indication that the word president is not in the statute. Isn't necessarily a magic word requirement, so to speak. But more fundamentally than that, they concede there are statutes that exist. In addition to that, much impeachment could occur as a result of private conduct. So the impeachment judgment clause does do significant work by authorizing the subsequent prosecution of a president there, because what the framers, if you look at what they're discussing in the thing, or in the Constitutional Convention, is principally concerns about private conduct, which of course we concede are not immune.
Okay, so just to pick up Justice Kagan's example of a president who orders a coup, let's imagine that he is impeached and convicted for ordering that coup, and let's just accept for the sake of argument your position that that was official conduct. You're saying that he couldn't be prosecuted for that even after conviction in an impeachment proceeding if there was not a statute that expressly referenced the president and made it criminal for the president.
There would have to be a statute that made a clear statement that Congress purported to regulate the president's conduct.
Okay, thank you.
Justice Jackson?
So I think I now understand better your position. In your discussions with Justice Kavanaugh, it became clear that you are saying that for the private acts of a president, there's no immunity, but for the official acts of the president, there is immunity. Is that your position?
I agree with that.
All right. So one thing that occurs to me is that this sort of difficult line drawing problem that we're having with all of these hypotheticals, is this a private act or a public act, is being necessitated by that assumption. Because of course, if official acts didn't get absolute immunity, then it wouldn't matter. We wouldn't have to identify which are private and which are public, correct?
That, in fact, is the approach of the D.C. Circuit. There's no determination that needs to be
right,
made.
But I'm just making, so to the extent we're worried about, like, how do we figure out whether it's private or public, we have to understand that we're only doing that because of an underlying assumption that the public acts get immunity. So let me explore that assumption. Why is it, as a matter of theory, and I'm hoping you can sort of zoom way out here, that the president would not be required to follow the law when he is performing his official acts? Everyone else, there are lots of folks who have very high-powered jobs, who make a lot of consequential decisions, and they do so against the backdrop of potential criminal prosecution if they should break the law in that capacity. And we understand and we know, as a matter of fact, that the President of the United States has the best lawyers in the world. When he's making a decision, he can consult with pretty much anybody as to whether or not this thing is criminal or not. So why would we have a situation in which we would say that the president should be making official acts without any responsibility for following the law?
I respectfully disagree with that characterization. The president absolutely does have responsibility. He absolutely is required to follow the law in all of his official acts. But the remedy for that is the question: could he be subject to personal vulnerability, sent to prison for making a bad decision after he leaves office?
But other people who have consequential jobs and who are required to follow the law make those determinations against the backdrop of that same kind of risk. So what is it about the president? I mean, I've heard you say it's because the president has to be able to act boldly, make kind of consequential decisions. I mean, sure, but again, there are lots of people who have to make life and death kinds of decisions, and yet they still have to follow the law, and if they don't, they could be sent to prison, et cetera, et cetera. So
I say two things in response to that,
yes.
Both from Fitzgerald. That's the very sort of inference or reasoning that this court rejected in Fitzgerald.
No, but let me just, Fitzgerald was a civil situation in which the president actually was in a different position than other people because of the nature of his job, the high-profile nature, and the fact that he touches so many different things. When you're talking about private civil liability, anybody on the street can sue him. We could see that the president was sort of different than the ordinary person when you say, should he be immune from civil liability from anybody who wants to sue him? But when we're talking about criminal liability, I don't understand how the president stands in any different position with respect to the need to follow the law as he is doing his job than anyone else.
He is required to follow the law. And what
But he's
Fitzgerald
not
said is
if there's no criminal if there's no threat of criminal prosecution. What prevents the president from just doing whatever he wants?
All the structural checks that are identified in Fitzgerald and a whole series of this court's cases that go back to Martin against Mott, for example, impeachment, oversight by Congress, public oversight. There's a long series of them. Fitzgerald directly addresses this in the civil context, and we think that language naturally ports.
I'm not sure that's much of a backstop. And what I'm, I guess, more worried about, you seem to be worried about the president being chilled. I think that we would have a really significant opposite problem if the president wasn't chilled. If someone with those kinds of powers, the most powerful person in the world, with the greatest amount of authority, could go into office knowing that there would be no potential penalty for committing crimes. I'm trying to understand what the disincentive is from turning the Oval Office into, the seat of criminal activity in this country.
I don't think there's any allegation of that in this case. And what George Washington said is, what Benjamin Franklin said is, we view the prosecution of a chief executive as something that everybody cried out against as unconstitutional. And what George Washington said is, we're worried about factional strife, which will.
No, let me put this worry on the table. If the potential for criminal liability is taken off the table, wouldn't there be a significant risk that future presidents would be emboldened to commit crimes with abandon while they're in office? It's right now the fact that we're having this debate because OLC has said that presidents might be prosecuted. Presidents from the beginning of time have understood that that's a possibility. That might be what has kept this office from turning into the kind of crime center that I'm envisioning. But once we say, no criminal liability, Mr. President, you can do whatever you want, I'm worried that we would have a worse problem than the problem of the president feeling constrained to follow the law while he's in office.
I respectfully disagree with that because the regime you've described is the regime we've operated under for 234 years. There has not been an expectation based on 234 years of unbroken political.
All right, let me ask you another question. Let me ask you another question about this clear statement line of questioning. First of all, I didn't see you argue that below. I don't know, I understand that you have that set of in your briefs here, but did you argue before the D.C. Circuit something about a clear statement with respect to statutes?
Yes, in our separately filed motion to dismiss based on statutory grounds, we extensively argued not just this clear statement rule, but a whole panel.
Right, but that's not the question presented in this case. The question presented in this case comes out of your motion for immunity. So to bring in now an argument that you didn't raise below, it seems to me you forfeited it, no?
I believe it's fairly included within the question presented, especially because the court expanded the question presented from what either of the parties submitted.
But not to statutory interpretation. I mean, that argument goes to statutory avoidance, constitutional avoidance, statutory interpretation. You asked for immunity, which is a totally different thing.
I think they're very closely related logically. The question is does immunity exist and to what extent does it? And the argument is immunity at least exists to the extent that it raises a grave constitutional question. That triggers the clear statement rule. That's a really tight logical relationship. But that's totally circular. You use that argument to avoid constitutional questions. You are asking us a constitutional question here. So it doesn't even make sense to talk about clear statement and rule the way that it's come up in the context of an immunity question. But let me ask you this about it. I had one more question. So what is the argument that the President of the United States, who you say is bound by the law, is not on notice that he has to do his job consistent with the law? I mean, to the extent that the clear statement rule comes in at all, it's about the person not being on notice. So I guess I don't understand why Congress, in every criminal statute, would have to say, and the President is included. I thought that was the sort of background understanding, that if they're enacting a generally applicable criminal statute, it applies to the President just like everyone else. So what is the clear statement that would have to be made in this context? Under Franklin and under Public Citizen, Congress has to speak clearly before it interferes with the president's powers, and we have here an indictment that seeks to criminalize objective conduct that falls within the heartland of core executive authority.
Thank you.
Thank you, counsel. Mr. Dreeben?
Mr. Chief Justice, and may it please the court. This court has never recognized absolute criminal immunity for any public official. Petitioner, however, claims that a former president has permanent criminal immunity for his official acts unless he was first impeached and convicted. His novel theory would immunize former presidents for criminal liability for bribery, treason, sedition, murder, and here conspiring to use fraud to overturn the results of an election and perpetuate himself in power. Such presidential immunity has no foundation in the Constitution. The framers knew too well the dangers of a king who could do no wrong. They therefore devised a system to check abuses of power, especially the use of official power for private gain. Here, the executive branch is enforcing congressional statutes and seeking accountability for petitioners' alleged misuse of official power to subvert democracy. That is a compelling public interest. In response, petitioner raises concerns about potential abuses, but established legal safeguards provide layers of protections, with the Article III courts providing the ultimate check. The existing system is a carefully balanced framework. It protects the president, but not at the high constitutional cost of blanket criminal immunity. That has been the understanding of every president from the framing through Watergate and up to today. This court should preserve it. I welcome the court's questions.
Mr. Dreeben, does the president have immunity, or are you saying that there's no immunity, presidential immunity, even for official acts?
Yes, Justice Thomas, but I think that it's important to put in perspective the position that we are offering the court today. The president, as the head of the Article II branch, can assert as applied Article II objections to criminal laws that interfere with an exclusive power possessed by the president or that prevent the president from accomplishing his constitutionally assigned functions. That is the constitutional doctrine that currently governs the separation of powers. What petitioner is asking for is a broad blanket immunity that would protect the president, a former president, from any criminal exposure absent impeachment and conviction, which has never happened in our history. And we submit that is not necessary in order to assure that the president can perform all of the important tasks that the Constitution reposes in him.
Over in not so distant past, the presidents or certain presidents have engaged in various activity, coups or operations like Operation Mongoose when I was a teenager, and yet there were no prosecutions. Why? If what you're saying is right, it would seem that that would have been ripe for criminal prosecution of someone.
So, Justice Thomas, I think this is a central question. The reason why there have not been prior criminal prosecutions is that there were not crimes. And I want to explain why there are layers of safeguards that assure that former presidents do not have to lightly assume criminal liability for any of their official acts. At the outset, there is a statutory construction principle that is applicable here. It arises when there is a serious constitutional question about applying a criminal statute to the president's acts. It is not, and I'm sure that we will discuss this, that no statute can apply to the president in his official capacity absent a designation of the president in it. But there is a principle that if there is a serious constitutional question, courts will strive to construe the statute so that it does not apply to the president. In addition to that, the president, I think has been mentioned earlier, has access to advice from the Attorney General, and it would be a due process problem to prosecute a president who received advice from the Attorney General that his actions were lawful, absent the kind of collusion or conspiracy that itself represented a criminal violation, which I don't really see as being a realistic option. And then if I could say one more thing, because you raised the question about potential overseas taking of life. And the Office of Legal Counsel has addressed this quite specifically. There is a background principle of criminal law called the public authority exception to liability, and it is read into federal law unless Congress takes specific action to oust it, which it never has done as far as I am aware. And in a case in which the president sought to engage in overseas activity that would result in the taking of life, OLC did not say the federal murder statute doesn't apply. That would be the thrust of my friend's argument on clear statement. Instead, OLC went through an extensive analysis on why the public authority defense would prevent it from being considered a violation of law to go after a terrorist, for example.
Counsel, the Court of Appeals below, whose decision we're reviewing, said, quote, a former president can be prosecuted for his official acts because the fact of the prosecution means that the former president has allegedly acted in defiance of the laws. Do you agree with that statement?
Well, I think it sounds tautologically true, but I want to underscore that the obligation of a president is to take care that the laws are faithfully executed.
Well, I think it sounds tautologically true as well, and that, I think, is the clearest statement of the Court's holding, which is why it concerns me. As I read it, it says simply, a former president can be prosecuted because he's being prosecuted.
Well, I would not suggest that that's either the proper approach in this case or certainly not the government's approach. A prosecution does, of course, invoke federal criminal law. The allegations have to be presented to a grand jury, which votes upon the indictment.
Well, that's what I mean, shortly after that statement in the court, that court's opinion, that's what they said. But there's no reason to worry because the prosecutor will act in good faith, and there's no reason to worry because a grand jury will have returned the indictment. Now, you know how easy it is in many cases for a prosecutor to get a grand jury to bring an indictment, and reliance on the good faith of the prosecutor may not be enough in the some cases. I'm not suggesting here. So if it's tautological, and those are the only protections that the Court of Appeals below gave, and that is no longer your position, you're not defending that position, why shouldn't we either send it back to the Court of Appeals or issue an opinion making clear that that's not the law?
Well, I am defending the Court of Appeals judgment, and I do think that there are layered safeguards that the court can take into account that will ameliorate concerns about unduly chilling presidential conduct. That concerns us. We are not endorsing a regime that we think would expose former presidents to criminal prosecution in bad faith, for political animus, without adequate evidence. A politically driven prosecution would violate the Constitution under Waite versus United States. It's not something within the arsenal of prosecutors to do. Prosecutors take an oath, the Attorney General takes an oath. So I don't want to overstate Your Honor's concern with potentially relying solely on good faith. But that's an ingredient, and then the courts stand ready to adjudicate motions based on selective prosecution, political animus. This court relied on those very protections in the Vance case just 2 years ago.
But what concerns me is, as you know, the Court of Appeals did not get into a focused consideration of what acts we're talking about or what documents we're talking about because of its adoption of what you termed, and I agree quite correctly, as a tautological statement, because the fact of prosecution was enough to take away any official immunity. The fact of prosecution, they had no need to look at what courts normally look at when you're talking about a privilege or immunity question.
Well, I think I would take issue, Mr. Chief Justice, with the idea of taking away immunity. There is no immunity that is in the Constitution unless this court creates it today. There certainly is no textual immunity. We do not submit that that's the end of the story. United States versus Nixon wasn't a textually based case. Neither was Nixon versus Fitzgerald. We endorse both of those holdings. But what is important is that no public official has ever had the kind of absolute criminal immunity that my friend speaks of, even with respect to the speech or debate clause. It's very narrow. It's focused on legislative acts. It's not focused on everything that a congressman does. And it responds to a very specific historical circumstance that basically involved the two other branches potentially harassing legislators and preventing them from doing their jobs. That's why it ended up in the Constitution. Nothing like that ended up in the Constitution for the presidents, and that's because one of the chief concerns of the framers was the risk of presidential misconduct. They labored over this. They adopted an impeachment structure that separated removal from office as a political remedy from criminal prosecution. This departed from the British model. The British model was you get impeached and criminally prosecuted and convicted in the same proceeding. The framers did not want that. They wanted a political remedy in case a president was engaging in conduct that endangered the nation. He could be removed. He can't be prosecuted while he's a sitting president. That's been the longstanding Justice Department position.
Mr. Dreeben, you dispute the proposition that a former president has some form of immunity. But as I understand your argument, you do recognize that a former president has a form of special protection, namely that statutes that are applicable to everybody must be interpreted differently under some circumstances when they are applied to a former president. Isn't that true?
It is true because, Justice Alito, of the general principle that courts construe statutes to avoid serious constitutional questions, and that has been the longstanding practice of the Office of Legal Counsel in the Department of Justice.
All right, so this is more, I think, than just a quarrel about terminology, whether what the former president gets is some form of immunity or some form of special protection, because it involves this difference, which I'm sure you're very well aware of. If it's just a form of special protection, in other words, statutes will be interpreted differently as applied to a former president, then that is something that has to be litigated at trial. The former president can make a motion to dismiss and may cite OLC opinions, and the district court may say, well, that's fine, I'm not bound by OLC, and I interpret it differently, so let's go to trial. And then there has to be a trial, and that may involve great expense, and it may take up a lot of time, and during the trial, the former president may be unable to engage in other activities that the former president would want to engage in, and then the outcome is dependent on the jury, the instructions to the jury, and how the jury returns a verdict, and then it has to be taken up on appeal. So the protection is greatly diluted if you take the form, if it takes the form that you have proposed. Now, why is that better?
It's better because it's more balanced. The blanket immunity that petitioner is arguing for just means that criminal prosecution is off the table unless he says that impeachment and conviction have occurred. Those are political remedies that are extremely difficult to achieve in a case where the misconduct occurs close to the end of a president's term. Congress is unlikely to crank up the machinery to do it, and if the impeachment trial has to occur after the president has left office, there's an open question about whether that can happen at all. So
you're arguing against the most far-reaching aspects of Mr. Sauer's argument, right?
That is correct, and let me turn then to why.
Well, what about, to unpack it a little more, do you agree that there's some aspects of Article 2 presidential power that are exclusive and that Congress cannot regulate and therefore cannot criminalize?
Absolutely.
Okay. For other official acts that the president may take that are not within that exclusive power, assume for the sake of argument, this question, that there's not blanket immunity for those official acts, but that to preserve the separation of powers, to provide fair notice, to make sure Congress has thought about this, that Congress has to speak clearly to criminalize official acts of the president by a specific reference. That seems to be what the OLC opinions suggest. I know you have a little bit of a disagreement with that, and what this court's cases also suggest.
So, Justice Kavanaugh, I'd like to take all of those in turn, because I don't think this court's cases speak that broadly. I definitely don't think that the Office of Legal Counsel opinions stand for this broad proposition that unless the president is specifically named, he's not in the statute. And I don't think that that's necessary in order to afford adequate protection for the president's valid Article 2 functions.
When you said unless, sorry to interrupt, but I want to just get this out and you can incorporate it in the answer. You said unless there's a serious constitutional question.
Correct.
Well, it's a serious constitutional question whether a statute can be applied to the president's official acts. So wouldn't you always interpret the statute not to apply to the president, even under your formulation, unless Congress had spoken with some clarity?
I don't think across the board that a serious constitutional question exists on applying any criminal statute to the president.
The problem is the vague obstruction and 371, conspiracy to defraud the United States, can be used against a lot of presidential activities historically with a creative prosecutor who wants to go after a president.
Well, let me try to backtrack a little bit.
That's what we're talking about historically, is the risk that, and going forward, the risk. So you can take all of that.
I think that the question about the risk is very serious, and obviously it is a question that this court has to evaluate. For the executive branch, our view is that there is a balanced protection that better serves the interest of the Constitution, that incorporates both accountability and protection for the president. And I want to go through the protections that do exist, but perhaps it's worth returning at the outset to the statutory construction question that you raised. The Office of Legal Counsel has said the offense of bribery, of course, applies to the president. It does not name the president. Justice Gorsuch, Section 201 does not specifically name the president.
I would assume that's personal. So,
well, I think that
that's what Brewster said.
Bribery statute 607 says the president. I've got it in front of me, and so there is that.
Well,
let me just back up, though, just a second to what was a quick exchange with Justice Kavanaugh that I just want to make sure I understand.
Yeah.
Did you agree that there are some core functions of the executive that president conduct that Congress cannot criminalize?
Yes.
Is that a form? I mean, we can call it immunity, or you can call it they can't do it, but what's the difference?
We call it an as-applied Article 2 challenge.
Okay. Can we call it immunity just for shorthand's sake? So I think we are kind of narrowing the ground of dispute here. It seems to me there is some area you concede that an official acts that Congress cannot criminalize. And now we're just talking about the scope.
Well, I don't think it's a just, but I think it's a very significant gap between any official act and the small core of exclusive official acts.
I got that, but I want to explore that, okay? So, for example, let's say a president leads a mostly peaceful protest sit-in in front of Congress because he objects to a piece of legislation that's going through. And it, in fact, delays the proceedings in Congress. Now, under 1512C2, that might be corruptly impeding an official proceeding. Is that core and therefore immunized, or whatever word, euphemism you want to use for that? Or is that not core and therefore prosecutable?
Well,
without a clear statement that applies to the president?
It's not core. The core kinds of activities that the court has acknowledged are the things that I would run through the Youngstown analysis. And it's a pretty small set, but things like the pardon power, the power to recognize foreign nations, the power to veto legislation, the power to make appointments, these are things that the Constitution specifically allocates to the president. Once you get out...
A president then could be prosecuted for the conduct I described after he leaves office?
Probably not, but I want to explain the framework of why I don't think that would be prosecution that would be valid. First, I think you need to run through all of the sort of normal categories of analysis. Is there a serious constitutional question that's posed by applying that statute to the president? If so, then you may well default to it does not apply, at least on that fact
I thought
pattern.
you said it, that was my question.
Yes,
and
I
you
understand.
said it fell outside that core, we'll call it immunity for simplicity's sake.
Yes, I understand. But there's a separate category.
Okay, so why couldn't he be prosecuted for leading a civil rights protest in front of the Capitol that delays a vote on a piece of important legislation?
So I think what you need to do is run through all of the very president-specific protective layers of analysis. So one of them is whether the statute would be construed not to apply to his conduct, even if it's not part of that small core of things that Congress can't regulate at all. If it operates to prevent the president from fulfilling his Article 2.
He could have given speeches against it. He did.
Yes.
But he did something more, and it corruptly impeded and sought to influence an official proceeding.
Well, so I don't know. We're starting with the layers, I think, of protection, and we're now down through whether the statute would be construed to apply to him. Then there'd be a question of whether—
Assume it does.
I will assume it. Then there's a question of whether he has the state of mind necessarily
Assume
to
he
violate
does. Okay. Nobody knows what corrupt intent means. We've been around that tree
we will
twice
probably
already.
find out.
And maybe it means that he knows that he was doing wrong, is what the government told us.
Right.
He knows he's doing wrong. He knows he shouldn't be up there blocking a congressman from—
Well, let me get to the next layer then, which is that the president does have access to the Attorney General to provide legal advice and regularly gets legal advice from the Attorney General on the lawful scope of the president's activities. And we could go down two tracks here. One is that the Attorney General advises him that as an incident of his Article 2 authority and in carrying out the functions of the presidency, he can lawfully participate in that protest. It's kind of the First Amendment analog to the president's official powers, which the court is exploring in other cases. Alternatively, the Attorney General could advise him, I'm sorry, Mr. President, there's nothing in the language of this statute that carves you out. I don't see a serious constitutional question in it because you don't have to do that. And I would advise you not to violate the criminal law.
And then he could be prosecuted.
No.
No. If he gets a negative opinion from the Attorney General, he still couldn't be prosecuted?
I'm going to assume that most presidents are not going to take
Well, but if he gets one and does it anyway, then he could be prosecuted.
Well, so then if we are down at that level, I think what we are really asking is whether the president is subject to the criminal law. And our answer is yes, he is subject to the criminal law.
Mr. Dreeben, can we go back to the bribery statute? I, like you, understand that the only thing that is covered by that is the president is barred from soliciting or receiving funds in any room or building in the United States.
That is correct. And it's an extremely
official building. It's a very limited mention of the president.
And it really, I think,
so, as I understand this, there's two very limited provisions mentioning the president is included.
That's right.
There's a whole number of provisions that exclude the president, many, many, many more that exclude the president, correct?
It's a kind of small number on both sides of the fence,
Justice Barrett made the point that if we say a president can't be included in a criminal law unless explicitly named, then that would bar the Senate from impeaching him for high crimes or misdemeanor, because that means that he's not subject to the law at all, correct?
So I think—
that's a tautology you can't escape.
Justice Sotomayor, what I think that Justice Barrett was saying, and we would agree with it, is that under my friend's position, after impeachment, he could be prosecuted. But under his statutory construction approach, there'd be nothing to prosecute him for.
Exactly. That's the point, which is if he's not covered by the criminal law, he can't be impeached for it, for violating it. All right. Now, could we go further on this clear statement rule? The situations, and you mentioned it earlier, in which we have looked to see if the president is covered is contextual, correct?
Correct.
And what are the factors that generally we'll look at? I'm thinking specifically about whether the APA covers the president.
Correct.
And what we did there was analyze what powers were being given to in the lawsuit, and et cetera. We looked at words, we looked at structure, we looked at separation of powers issues relating to our case law that said you can't direct the president to do anything, and this would have been a subterfuge for that, correct?
All correct.
All right. So I don't know why two of my colleagues, how they would fashion a clear statement rule that would say when the law says any person can't accept the bribe, that permits the president to do it.
So I agree, Justice Sotomayor, that the way that this court has interpreted statutes that do carve out the president, Justice Kavanaugh asked about this, was very context specific. The Franklin case basically involved a holding that we are highly unlikely to say that the president is an agency, something that the government said would be a peculiar understanding of agency, when the effect of it would be that we would review the president's decisions under statutes for abuse of discretion, which is a very extraordinary thing to do. I think even going back to Marbury, this is perhaps a point on which I agree with my friend. Marbury says discretionary acts of the president are not the kind of thing that the court reviews.
All right, could I go back to your brief? And going back to what some of my colleagues have asked you, there appears to be some narrowing principles to the concept that the president is subject to all criminal laws in all situations.
Correct.
You agree that if it affects core powers, then he would not be subject to any laws that attempted to limit those core powers,
that is
correct? You're defining core powers as those specified by Article 2.
That is essentially correct, yes.
All right. And the only words in the Constitution is that that have to do with the president and law is that he shall take care that the law be faithfully executed, correct?
That is right.
Hard to imagine that a president who breaks the law is faithfully executing the law, correct?
He has to execute all of the laws.
Well, Mr. Dreeben, do you really, I mean, the presidents have to make a lot of tough decisions about enforcing law, and they have to make decisions about questions that are unsettled, and they have to make decisions based on the information that's available. Do you really, did I understand you to say, well, you know, if he makes a mistake, he makes a mistake. He's subject to the criminal laws just like anybody else? You don't think he's in a special, a peculiarly precarious position?
He's in a special position for a number of reasons. One is that he has access to legal advice about everything that he does. He's under a constitutional obligation he's supposed to be faithful to the laws of the United States and the Constitution of the United States. And making a mistake is not what lands you in a criminal prosecution. There's been some talk about the statutes that are issued in this case. I think they are fairly described as malum in se statutes, engaging in conspiracies to defraud the United States with respect to one of the most important functions, namely the certification of the next president.
Well, I don't want to dispute the particular application of 371, conspiracy to defraud the United States, to the particular facts here, but would you not agree that that is a peculiarly open-ended statutory prohibition, in that fraud under that provision, unlike under most other fraud provisions, doesn't require any impairment of a property interest?
It's designed to protect the functions of the United States government, and it's difficult to think of a more critical function than the certification of who won the election.
Yeah, I'm not, as I said, I'm not discussing the particular facts of this case, but it applies to any fraud that interferes seriously with any government operation, right?
So what the government needs to show is an intent to impede, interfere, or defeat a lawful government function by deception, and it has to be done with scienter. These are not the kinds of activities that I think any of us would think a president needs to engage in order to fulfill his Article 2 duties, and particularly in a case like this one. I want to pick up on something that the court said earlier about the distinction between a public official acting to achieve public ends and a public official acting to achieve private ends. As applied to this case, The president has no functions with respect to the certification of the winner of the presidential election. It seems likely that the framers designed the Constitution that way because at the time of the founding, presidents had no two-term limit. They could run again and again, and were expected potentially to want to do that. So the potential for self-interest would explain why the states conduct the elections. They send electors to certify who won those elections and to provide votes, and then Congress in a extraordinary joint session certifies the vote. And the president doesn't have an official role in that proceeding. So it's difficult for me to understand how there could be a serious constitutional question about saying you can't use fraud to defeat that function. You can't obstruct it through deception. You can't deprive millions of voters of their right to have their vote counted for the candidate who they chose.
Thank you, counsel. Justice Thomas? Justice Alito?
Could we just briefly review the layers of protection that you think exists? And I'm going to start with what the D.C. Circuit said. So the first layer of protection is that attorneys general and other Justice Department attorneys can be trusted to act in a professional and ethical manner, right?
Yes.
How robust is that protection? I mean, most of the vast majority of attorneys general and Justice Department attorneys, and we both served in the Justice Department for a long time, are honorable people, and they take their professional ethical responsibilities seriously. But there have been exceptions, right? Both among attorneys general and among federal prosecutors.
There have been rare exceptions, Justice Alito, but when we're talking about layers of protection, I do think this is the starting point. And if the court has concerns about the robustness of it, I would suggest looking at the charges in this case.
Well, I want to talk about this in the abstract, because what is before us, of course, does involve this particular case, which is immensely important. But whatever we decide is going to apply to all future presidents. So as for attorneys general, there have been two who were convicted of criminal offenses while in office. There were others. A. Mitchell Palmer's one that comes to mind, who is widely regarded as having abused the power of his office. Would you agree with that?
I would, but they are two officials in a long line of attorneys generals who did not, and in departments of justice that are staffed by multiple people who do adhere to their office. And Justice Alito, if I could just, the point that I wanted to make about this case does go to the general proposition. The allegations about the misuse of the Department of Justice to perpetuate election fraud show exactly how the Department of Justice functions in the way that it is supposed to. Petitioner is alleged to have tried to get the Department of Justice to send fraudulent letters to the states to get them to reverse electoral results.
Yeah,
the Department of Justice
I understand that, Mr. Dreeben, but as I said, this case will have effects that go far beyond this particular prosecution. So moving on to the second level of protection that the D.C. Circuit cited, federal grand juries will shield former presidents from unwarranted indictments. How much protection is that?
Well, it affords two levels of protection. One is the probable cause finding requires evidence. I think some of the fears about groundless prosecutions aren't supported by evidence, and they're not going to get out of the starting gate.
I mean, there's the old saw about indicting a ham sandwich.
Yes, but I think Justice
you had a lot of experience in the Justice Department. You come across a lot of cases where the U.S. attorney or another federal prosecutor really wanted to indict a case and the grand jury refused to do so.
There are such cases. Yes. But I think that the other
Every
level
once in a while there's an eclipse, too.
Well, I think that's for the most reason is prosecutors have no incentive to bring a case to a grand jury and secure an indictment when they don't have evidence to prove guilt beyond a reasonable doubt. It's self-defeating.
All right, then the third level is that former presidents enjoy all the protections afforded all criminal defendants, right? And we've discussed that. And that may be true at the end of the day, but a lot can happen between the time when an indictment is returned and the time when the former president finally gets a vindication, perhaps on appeal. Isn't that correct?
It is correct, Justice Alito, but I think that we should also consider the history of this country. As members of the court have observed, it's baked into the Constitution that any president knows that they are exposed to potential criminal prosecution. My friend says after impeachment and conviction, we don't read the impeachment judgment clause that way, but it's common ground that all former presidents have known that they could be indicted and convicted. And Watergate cemented that understanding. The Watergate smoking gun tape involved President Nixon and H.R. Haldeman talking about and then deciding to use the CIA to give a bogus story to the FBI to shut down a criminal investigation.
I mean, Mr. Sauer and others have identified events in the past where presidents have engaged in conduct that might have been charged as a federal crime, and you say, well, no, that's not really true. This is page 42 of your brief. So what about President Franklin D. Roosevelt's decision to intern Japanese Americans during World War II? Couldn't that have been charged under 18 U.S.C. 241, conspiracy against civil rights?
Today, yes, given this court's decision in Trump versus United States, in which Trump versus Hawaii, excuse me, where the court said Korematsu is overruled. I mean, President Roosevelt made that decision with the advice of his Attorney General. That's a layer of safeguard.
Is that really true? I thought Attorney General Biddle thought that there was really no threat of sabotage, as did J. Edgar Hoover.
So I think that there is a lot of historical controversy, but it underscores that occurred during wartime. It implicates potential commander-in-chief concerns about the exigencies of national defense that might provide an as-applied Article II challenge at the time. I'm not suggesting today, but the idea that a decision that was made and ultimately endorsed by this court, perhaps wrongly, in the Korematsu case, would support criminal prosecution under 241, which requires under United States versus Lanier that the right have been made specific so that there is notice to the president. I don't think that would have been satisfied.
All right, well, we could go through other historical examples. I won't do that. Let me just touch briefly on a couple of other things. One is the relevance of advice of counsel, and I wasn't clear what your answer is. So if the president gets advice from the Attorney General that something is lawful, is that an absolute defense?
Yes, I think that it is under the principle of entrapment by estoppel. This is a due process doctrine that we referred to in our brief, our reply brief in Garland versus Cargill this term at page 19, where we cited authority of this court that if a authorized government representative tells you that what you are about to do is lawful, it would be a root violation of due process to prosecute you for that.
Won't that give presidents an incentive to be sure to pick an attorney general who will reliably tell the president that it is lawful to do whatever the president wants to do if there's any possibly conceivable argument in favor of it?
So I think the constitutional structure protects against that risk. The president nominates the attorney general, and the Senate provides advice and consent. And these are the sort of structural checks that have operated for 200 years to prevent the kind of abuses that my friend fears going forward as a result of this once-in-history prosecution.
On the question of whether a president has the authority to pardon himself, which came up earlier in the argument, what's the answer to that question?
I don't believe the Department of Justice has taken a position. The only authority that I'm aware of is a member of the Office of Legal Counsel wrote on a memorandum that there is no self-pardon authority. As far as I know, the department has not addressed it further, and of course this court had not addressed it either.
Well, when you addressed that question before us, are you speaking in your capacity solely as a member of the special counsel's team, or are you speaking on behalf of the Justice Department, which has special institutional responsibilities?
I am speaking on behalf of the Justice Department, representing the United States.
Now, don't you think we need to know the answer to at least to the Justice Department's position on that issue in order to decide this case? Because if a president has the authority to pardon himself before leaving office. And the D.C. Circuit is right that there is no immunity from prosecution. Won't the predictable result be that presidents on the last couple of days of office are going to pardon themselves from anything that they might have been conceivably charged with committing?
I really doubt that, Justice Alito. I mean, it sort of presupposes a regime that we have never had except for President Nixon and, as alleged in the indictment here, presidents who are conscious of having engaged in wrongdoing and seeking to shield themselves. I think the political consequences of a president who asserted a right of self-pardon that has never been recognized, that seems to contradict a bedrock principle of our law that no person shall be the judge in their own case. Those are adequate deterrents, I think, so that this kind of dystopian regime is not going to evolve.
All right, let me end with just a question about what is required for the functioning of a stable democratic society, which is something that we all want. I'm sure you would agree with me that a stable democratic society requires that a candidate who loses an election, even a close one, even a hotly contested one, leave office peacefully if that candidate is the incumbent.
Of course.
All right. Now, if an incumbent who loses a very close, hotly contested election knows that a real possibility after leaving office is not that the president is going to be able to go off into a peaceful retirement, but that the president may be criminally prosecuted by a bitter political opponent, will that not lead us into a cycle that destabilizes the functioning of our country as a democracy? And we can look around the world and find countries where we have seen this process, where the loser gets thrown in jail.
So I think it's exactly the opposite, Justice Alito. There are lawful mechanisms to contest the results in an election. And outside the record, but I think of public knowledge, petitioner and his allies filed dozens of electoral challenges, and my understanding is lost all but one that was not outcome determinative in any respect. There were judges that said in order to sustain substantial claims of fraud that would overturn an election result that's certified by a state, you need evidence, you need proof. And none of those things were manifested. So there is an appropriate way to challenge things through the courts with evidence. If you lose, you accept the results. That has been the nation's experience. I think the court is well familiar with that.
Thank you.
Justice Sotomayor?
A stable democratic society needs the good faith of its public officials, correct?
Absolutely.
And that good faith assumes that they will follow the law.
Correct.
Now, putting that aside, there is no fail-safe system of government, meaning we have a judicial system that has layers and layers and layers of protection for accused defendants in the hopes that the innocent will go free. We fail routinely, but we succeed more often than not. In the vast majority of cases, the innocent do go free. Sometimes they don't, and we have some post-conviction remedies for that. But we still fail. We've executed innocent people. Having said that, Justice Alito went through step by step all of the mechanisms that could potentially fail. In the end, if it fails completely, it's because we've destroyed our democracy on our own, isn't it?
It is, Justice Sotomayor, and I also think that there are additional checks in the system. Of course, the constitutional framers designed a separated powers system in order to limit abuses. I think one of the ways in which abuses are limited is accountability under the criminal law for criminal violations. But the ultimate check is the goodwill and faith in democracy. And crimes that are alleged in this case that are the antithesis of democracy, that subvert it, undermine that.
An encouragement to believe words that have been somewhat put into suspicion here, that no man is above the law either in his official or private acts?
I think that is an assumption of the Constitution.
Justice Kagan?
Mr. Dreeben, I want to go through your framework and make sure I understand it. So first, on the small category of things that you say have absolute protection,
yes,
that they are core executive functions,
yes,
what are those small categories?
Pardon power.
Pardon, veto.
Veto, foreign recognition, appointments. Congress cannot say you can't appoint a federal judge who hasn't received, a certain diploma, or hasn't achieved a certain age. There are a few other powers.
Is Commander-in-Chief?
Commander-in-Chief is on the list, but I want to add to my answer on that Congress has substantial authority in the national security realm. Congress declares war, it raises armies, it has power over the purse. That's more of
that may be viewed as not really in that core set of functions, which nobody has any power but the president over.
Yes, I think that there may be some aspects, like directing troops on the field, in which the president's power is completely unreviewable.
Okay. Now, in the next category, where we've left the core set behind,
yes,
but we're still in the world of official actions, and that's where you say there are various statutory construction rules that might come into play.
Correct.
But you have characterized those as something different from just saying, oh, look, the statute doesn't say the president, therefore it doesn't apply to the president.
That's right.
So I wanted to give you an opportunity to say, how that would look, how that analysis would look in a given case. And in the course of responding to that, I'm sort of thinking of something like the OLC opinion, which says bribery. The president can be tried and convicted of bribery, even in the part of the bribery statutes that do not say the president. Why is that true?
That is true because there is no serious constitutional question that the president needs to engage in bribery in order to carry out his constitutional functions. And the Office of Legal Counsel pointed out that bribery is enumerated in the impeachment clause. So it falls outside of anything that could be viewed as inherent in the need of Article 2 to function.
Do you think the premise of that OLC opinion was that the bribery was simply not official?
No.
Or is the premise that the bribery was official and still the president could be prosecuted for it?
I think that bribery is the kind of hybrid that illustrates the abuse of public office for private gain that we think is paradigmatic of the kinds of things that should be not held to be immune. In a bribery case, the public official cannot extract the bribe without the official power to offer as the quid or the pro, I guess the quo, actually. So it really is a crime that can only be committed by public officials who misuse their power. And it was one of the things that was most mistrusted. Many of the acts that are charged in this indictment or that would violate federal criminal law similarly involve the misuse of official power for private gain.
So if you were to say what the line is in this category, like when it is that the statute should be understood as precluding presidential prosecution, and when it is that the statute should be understood as allowing it, what general principles should guide?
So the general principles, I think, kind of emerge from looking at what the Office of Legal Counsel has done. So, for example, with respect to a federal statute that prohibited appointments to courts of people within certain degrees of consanguinity, the Office of Legal Counsel said this infringes on a very important appointment power of the president, the power to appoint federal judges. It cannot be presumed that Congress intended to do that because it would raise a very serious constitutional question. The president is out. Then there are categories of statutes where the president is in, like, for example, the grassroots lobbying statute. The Office of Legal Counsel wrote an opinion about that, and it said, for the president or other public officials to go out into the world and to promote their programs, that can't be what Congress intended to prohibit. What it did intend to prohibit is using federal funds to gin up an artificial grassroots campaign that gave the appearance of emerging from the people, but it was really top down. And the Office of Legal Counsel said the president and officials who carry out the president's mandates are subject to that statute. So that's a more nuanced one. And then the third example that I will give you is the statute that would permit prosecution for contempt of Congress. The Office of Legal Counsel concluded that a good faith assertion of executive privilege as a reason for not providing information to Congress would preclude prosecution because Congress cannot be deemed to have altered the separation of powers in such a manner. I think OLC probably would have gone on to say if Congress tried to do it, it would be deemed unconstitutional. But again, this was a statute that did not specifically name the president. There are only two that do that. So the entire corpus of federal criminal law, including bribery offenses, sedition, murder, would all be off limits if it were taken to the extent that some of the questions have suggested. And for the general principle, does it raise a serious constitutional question? And if so, to what extent? Can it be carved out individually? And there may be some instances where the statutes here could be carved out and a particular act could be found to be protected. Or does the statute across the board in such a wide range of applications, somewhat analogous to overbreadth analysis, infringe on the president's power so that we're going to say that the president is just out?
Now, that set of issues, they seem important and may occasionally be difficult. They also seem not really before us in the way Justice Jackson suggested earlier. What do you do you think they are before us? We should just clear it up. Here it is. We have a case. What else could we do? How should we deal with this? That there are these lingering issues that go beyond the question of whether there's the kind of absolute immunity that the former president is invoking.
So I think the court has discretion to reach that issue, even though Justice Jackson is totally right. It was not raised in the district court, and it was not raised in the Court of Appeals. And the analysis that I would use to get there is a fusion of a couple of principles. One is the court has often resolved threshold questions that are a prerequisite to an intelligent resolution of the question presented. So in a case like United States versus Grubbs, for example, the court reached out to decide whether anticipatory warrants are valid under the Fourth Amendment before turning to the question whether the triggering condition for an anticipatory warrant had to be in the warrant. So that's one principle. And then a precedent that bears some analogy to this is Vermont Natural Resources Agency versus United States ex rel Stevens. It was a key TAM case, and the first question was whether a state agency was a person within the meaning of the False Claims Act, and the second question was whether if the state agency was, 11th Amendment immunity kicked in, and the court wrote an analysis of why it could reach both questions. The reaching the person question didn't expand the court's jurisdiction, and it made sense as a matter of constitutional avoidance to do that. There are some considerations that cut against this, and I want to be clear that for overall government equities, we are not wild about parties who raise an immunity case that can be presented to a court on an interlocutory appeal and then smuggling in other issues. So we would want to guide the court not to have an expansive approach to that issue. But the final thing that I would say about this is part of our submission to this court is that the Article 1 branch and the Article 2 branches are aligned in believing that this prosecution is an appropriate way to enforce the law. Congress by making the law, the current executive by deciding to bring it. And since a building block of that submission is that Congress actually did apply these criminal laws to official conduct, the court may wish to exercise its discretion to resolve that issue.
Okay, I have one last set of questions, which has to do with the official unofficial line.
Yes.
And you heard Mr. Sauer's responses to both Justice Barrett's questions and my questions about what he thinks counts as official here and what he thinks counts as unofficial here. And I'm just wondering what you took from his responses and also how you would characterize what is official and what is not official in this indictment.
So I think petitioner conceded that there are acts that are not official that are alleged in the indictment, and we agree with him on all of that. I think I disagree with him on everything else that he said about what is official and what is not. organizing fraudulent slates of electors, creating false documentation that says, I'm an elector, I was appointed properly, I'm going to send a vote off to Congress that reflects that petitioner won rather than the candidate that actually got the most votes and who was ascertained by the governor and whose electors were appointed to cast votes. That is not official conduct. That is campaign conduct. And I think that the D.C. Circuit in the Blassingame case did draw an appropriate distinction. A first-term president who's running for re-election can act in the capacity as office seeker or office holder. And when working with private lawyers and a private public relations advisor to gin up fraudulent slates of electors, that is not any part of a president's job. So
there's an allegation in the indictment that has to do with the removal of a Justice Department official. Is that core protected conduct?
We don't think that that's core protected conduct. I don't think that I would characterize that episode quite that way. We do agree that the Department of Justice allegations were use of the president's official power. In many ways, we think that aggravates the nature of this offense. Seeking as a candidate to oust the lawful winner of the election and have oneself certified with private actors is a private scheme to achieve a private end, and many of the co-conspirators alleged in the indictment are private. But for an incumbent president to then use his presidential powers to try to enhance the likelihood that it succeeds makes the crime, in our view, worse. And so in the Department of Justice episode, it occurs very late in the election cycle after many other schemes had failed. And at that point, the petitioner is alleged to have tried to pressure the Department of Justice to send false letters to the states claiming that there were serious election irregularities and that they should investigate who they certified as the president. None of this was true. The Department of Justice officials all said, this is not true. We are not going to do that. And at that point, petitioner is alleged to have threatened to remove the Department of Justice officials who were standing by their oath and replace them with another person who would carry it out. We're not seeking to impose criminal liability on the president for exercising or talking about exercising the appointment and removal power. No, what we're seeking to impose criminal liability for is a conspiracy to use fraud to subvert the election, one means of which was to try to get the Justice Department to be complicit in this. The case would have been no different if petitioner were successful and he had actually exercised the appointment and removal power and it had gone through and those fraudulent letters were sent. It would have made the scheme more dangerous, but it would not have changed the crime.
And how do we think about things like conversations with the vice president? In other words, things that if you say it that way, it's clear that they would fall under executive privilege, but how does that relate to the question that we're asking here?
So this is one of the most difficult questions for the Department of Justice, and I want to explain why that is. If we are operating under a Fitzgerald versus Nixon lens and looking at this the way that we look at things when there is a private lawsuit filed against the president, we take a very broad view of what the outer perimeter of official presidential action is in order to be as protective of the president against private lawsuits that, as this court explained in Nixon versus Fitzgerald, can be very deleterious to the president's conduct of business. So if we were putting this under a Fitzgerald lens, we would then have to answer to the question, was he acting in the capacity as office seeker, or was he acting in the capacity as office holder? And if you run through the indictment, you can find support for those two characterizations. And the Department of Justice has not yet had to come to grips with how we would analyze that set of interactions.
Thank you.
Justice Gorsuch?
If you did, though, I just wanted to confirm, I thought I heard you thought that the Blassingame framework was the appropriate one. Is that right?
Largely, yes, Justice Gorsuch. We agree with the idea of the distinction between office holder and office seeker. We also agree that if it's objectively reasonable to view the activities as those of office holder, then the Fitzgerald immunity kicks in. I think we would look more at the content of the actual interaction in order to make that determination than Blasingame suggested, at least on the facts of that case, might be appropriate.
Can you give me an example of what you have in mind? I'm just trying to understand what nuance you're suggesting.
So Blasingame adopted a generally very favorable pro-government framework that we endorse in private civil cases. Yeah. Okay, not here, because we don't think that Fitzgerald applies in the criminal context.
Well, I understand that,
okay.
but putting that aside, the distinction between official act and private office seeker,
yes,
their test is, you think, good enough for government work?
On this one, the department hasn't taken a next step since the Blasingame decision, but let me offer a few thoughts that Justice Gorsuch I think might clarify it. The Blasingame decision focused on objective contextual indications to try to see whether the president was acting as a campaigner as opposed to an office holder. Yeah. I think that decision can also be made by looking at what the president actually said. And let me illustrate that with an allegation that I think my friend talked briefly. In one of the interactions between petitioner and a state official, petitioner is alleged to have said, all I needed you to do is to find me 11,000 votes and change. I think if you look at that content, it's pretty clear that petitioner is acting in the capacity as office seeker, not as president, and we would look at that content.
Okay, but the test, I'm just focused on the legal test.
Correct.
I'm not hearing any objections to it.
Other than I think that the D.C. Circuit placed more content consideration off limits than I would.
Okay, all right. And then I wanted to understand on the core immunity, or whatever word we use, that it seems to me that we're narrowing the ground of dispute here considerably. Do we look at motives, the president's motives for his actions? I mean, for example, he has lots of war powers, as we've discussed, but he might use them in order to enhance his election, his personal interests. Is that a relevant consideration when we're looking at core powers?
So I am thinking of this more as looking at the objective of the activity as opposed to the kind of subjective motive in the sense that Your Honor is talking about. I think that there is a lot of concern about saying an electoral motive to be reelected such.
Every first-term president, everything he does can be seen through the prism, by critics at least, of his personal interest in reelection.
Yes.
And so you wouldn't want that. I think you would say personal motivations off limits with respect to the core powers.
Probably, well, with respect to the core powers, we think those are just things that can't be regulated at all, like the pardon power and veto.
Right, regardless of motive.
Correct.
Regardless of motive.
That's right.
Okay.
That is right.
All right, so then we're in the non-core powers where we're fighting over. What role do motives play there? I mean, one could remove an appointee that, well, first of all, maybe ask this first, is removing an appointee, a presidential appointee, a core power or a non-core power in your world?
So here I might need to differentiate between the principal officers that this court in cases like Myers and Seal of Law has regarded as having a constitutional status of being removable at will from inferior officers where Congress does have some regulatory latitude to impose restrictions on removal.
Sure.
And
let's put that aside. Yeah, I understand that.
Putting that aside, yes, appointing a principal officer is a core power. I am not prepared to say that there is no potential criminal regulation to say you can't do it for corrupt purposes, to enrich yourself, for example.
Well, bribery, all right, but that's what I was wondering. Do motives come into the core power analysis or not? And now I'm hearing, I thought I heard no, and now I'm hearing maybe.
I think maybe might be a little bit more appropriate because it's not involved in this case. The department has not had to take a position on exactly how these core powers would be resolved under an as-applied constitutional analysis. None is involved in this case.
And I guess I'm wondering, and I'm not concerned about this case so much as future ones too, but these non-core powers and maybe core powers where a president is acting with at least in part a personal interest in getting reelected. Everything he does, he wants to get reelected. And if you're allowing in motive to color that, I'm wondering how much is left of either the core or non-core powers.
So I would be fine with carving that out and deeming that to be something that's intrinsic in our electoral system. We're not talking about applying criminal law to somebody who makes an announcement that this program will be good for the United States, and somebody could come along and say, well, you really did it to get reelected. Leaving aside whether any of that violates a criminal law, I know that the next question is assume that it does. I'm doubtful that it in fact does, because I don't think criminal laws generally operate on motives as opposed to objectives and purposes. But
well, all right, intentions. I mean, you can frame a motive as an intention, and intention as a motive, as you well know, every day of the week. So let's put that aside.
I understand. Well, putting that aside, that really, to me, falls in a very different category, and it is also possible.
So there's some motives or intents that are cognizable, and others that aren't. I mean, it's awkward, right? When we look back at like the injunction, back to Marbury in the early cases, you can't enjoin a president.
Yeah.
Also meant you couldn't hold him in contempt. Right? A sitting president. For sure.
Just Gorsuch, can I try one more time?
Well, let me just spin this out just a second, right? And it didn't matter what the president's motives were. We're not going to look behind it.
Right.
And same thing in Nixon. We said, gosh, Nixon versus Fitzgerald, that's something courts shouldn't get engaged in because presidents have all manner of motives. And again, I'm not concerned about this case, but I am concerned about future uses of the criminal law to target political opponents based on accusations about their motives, whether it's re-election or who knows what corrupt means in 1512, right? We don't know what that means. Maybe we'll find out sometime soon. But the dangerousness of accusing your political opponent of having bad motives, and if that's enough to overcome your core powers or any other limits, reactions, thoughts?
Yeah, so I think that you're raising a very difficult question.
That's the idea, right? I mean,
that is the idea.
Testing the limits of both sides' arguments.
And I'm going to say something that I don't normally say, which is that's really not involved in this case. We don't have bad political motive in that sense.
I understand that. I appreciate that, but you also appreciate that we're writing a rule for the ages.
Yes, and I think I would start by looking at the statutes and then seeing what restrictions they do place on the president's conduct. And for example, the statute that prohibits fraud to defeat the lawful functions of the United States. The statute defines what the purpose is that the defendant has to have in mind. It has to be to defeat something that the United States is doing, and it has to be by deception. I don't think that that gets us into the realm of motive hunting in the area where we are as concerned, I think, as the court would be about doing something that would undermine the presidency and the executive branch. And 1512c2, we may have different views on the clarity and the scope of that statute. I think if the court does interpret corruptly as involving a consciousness of wrongdoing and elevates that to consciousness of illegality, then we're in a different realm. Wanting to get reelected is not an illegal motive, and you don't have to worry about prosecuting presidents for that.
Yeah. Okay. Thank you, Mr. Dreeben.
Justice Kavanaugh?
As you've indicated, this case has huge implications for the presidency, for the future of the presidency, for the future of the country, in my view. You've referred to the department a few times as having supported the position. Who in the department? Is it the president, the attorney general?
The Solicitor General of the United States. Part of the way in which the special counsel functions is as a component of the Department of Justice. The regulations envision that we reach out and consult, and on a question of this magnitude that involves equities that are far beyond this prosecution as the questions of the court.
So it's the Solicitor General?
Yes.
Okay. Second, like Justice Gorsuch, I'm not focused on the here and now of this case. I'm very concerned about the future. And I think one of the court's biggest mistakes was Morrison versus Olson. I think that was a terrible decision for the presidency and for the country, and not because there were bad people who were independent counsels, but President Reagan's administration, President Bush's administration, President Clinton's administration were really hampered, in their view, all three, by the independent counsel structure. And what I'm worried about here is that was kind of, let's relax Article 2 a bit for the needs of the moment. And I'm worried about the similar kind of situation applying here. That was a prosecutor investigating a president in each of those circumstances, and someone picked from the opposite party, the current president, and usually was how it worked. And Justice Scalia wrote that the fairness of a process must be judged on the basis of what it permits to happen, not what it produced in a particular case. You've emphasized many times regularity, the Department of Justice. And he said, and I think this applied to the independent counsel system, and it could apply if presidents are routinely subject to investigation going forward. One thing is certain, however, it involves investigating and perhaps prosecuting a particular individual. Can one imagine a less equitable manner of fulfilling the executive responsibility to investigate and prosecute? What would the reaction be if, in an area not covered by the statute, the Justice Department posted a public notice inviting applicants to assist in an investigation and possible prosecution of a certain prominent person? Does this not invite what Justice Jackson described as picking the man and then searching the law books or putting investigators to work to pin some offense on him? To be sure, the investigation must relate to the area of criminal offense specified by the statute, but that has often been, and nothing prevents it from being very broad. I paraphrased at the end because it was referring to the judges.
Yes.
That's the concern going forward, is that the system will, when former presidents are subject to prosecution, and the history of Morrison versus Olson tells us it's not going to stop. It's going to cycle back and be used against the current president or the next president and the next president and the next president after that. All that, I want you to try to allay that concern. Why is this not Morrison v. Olson redux if we agree with you?
Well, first of all, the independent counsel regime did have many structural features that emphasized independence at the expense of accountability. We don't have that regime now, but even under that regime, Justice Kavanaugh, I think if you look at Lawrence Walsh's report on Iran-Contra, I think this goes to a very fundamental point for the court to consider. Judge Walsh said, I investigated these matters. The proof did not nearly come close to establishing criminal violations. So we've lived from Watergate through the present, through the independent counsel era with all of its flaws, without these prosecutions having gone off on a runaway train.
Well, I think President Reagan, President Bush, and President Clinton, whether rightly or wrongly, thought contrary to what you just said.
I think nobody likes being investigated for a crime, but it didn't result in the kind of vindictive prosecutions that I think Your Honor is raising as a possibility.
Yeah.
We have a different system now. I think there was a consensus throughout Washington that there were flaws in the independent counsel system. It lapsed. We now are inside the Justice Department with full accountability resting with the Attorney General. So the special counsel regulations now don't operate the way that the independent counsel regulations do. And this court would have something to say about it, I think, if the independent counsel statute were revived. I'm not sure that anybody is in favor of that.
Right. Now, I was just saying this is kind of the mirror image of that, is one way someone could perceive it. But I take your point about the different structural protections internally. And like Justice Scalia said, I do not mean to suggest anything of the sort in the present case. I'm not talking about the present case, so I'm talking about the future. Second, another point, you said, talked about the criminal statutes. It's very easy to characterize presidential actions as false or misleading under vague statutes. So President Lyndon Johnson, statements about the Vietnam War. Say something's false. Turns out to be false that he says about the Vietnam War. 371 prosecution?
So
after he leaves office?
I think not, but this is an area that I do think that merits some serious and nuanced consideration. Statements that are made by a president to the public are not really coming within the realm of criminal statutes. They've never been prosecuted. I realize that the court can say, well, what if they were? And then I think you get to what I would regard as a hard constitutional question that would probably guide the court away from trying to resolve today, although I do think it's very different from our case and distinguishable in important ways. But you're dealing here with two branches of government that have a paramount interest in the integrity and freedom of their interactions with each other. On the one hand, the president, of course, should be very free to send usually his cabinet officials and sub-cabinet officials to testify to Congress, to provide them with the information needed to enact legislation and to make national policy. And we're very concerned about anything that would trammel that. On the other side of the equation, Congress has a compelling interest in receiving accurate information, and at the very least, not information that is intentionally and knowingly false. That would pollute the legislative process.
How about, I think it came up before, President Ford's pardon. Very controversial in the moment.
Yes.
Hugely unpopular, probably why he lost in '76.
Yes.
Now looked upon as one of the better decisions in presidential history, I think, by most people. If he's thinking about, well, if I grant this pardon to Richard Nixon, could I be investigated myself for obstruction of justice on the theory that I'm interfering with the investigation of Richard Nixon?
So this would fall into that small core area that I mentioned to Justice Kagan and Justice Gorsuch of presidential responsibilities that Congress cannot regulate.
How about President Obama's drone strikes?
So the Office of Legal Counsel looked at this very carefully and determined that, number one, the federal murder statute does apply to the executive branch. The president wasn't personally carrying out the strike, but the aiding and abetting laws are broad. And it determined that a public authority exception that's built into statutes and that applied particularly to the murder statute because it talks about unlawful killing did not apply to the drone strike. So this is actually the way that the system should function. The Department of Justice takes criminal law very seriously. It runs it through the analysis very carefully with established principles. It documents them, it explains them, and then the president can go forward in accordance with it. And there is no risk of prosecution for that course of activity.
Thank you for your answers.
Justice Barrett?
Mr. Dreeben, I want to pick up with that public authority defense. So I'm looking at the OLC memo that David Barron wrote that you cited in your briefs. And he describes the public authority defense citing the Model Penal Code. There are a few different definitions, but I'll just highlight this one. Justifying conduct which is required or authorized by the law defining the duties or functions of a public officer, the law governing the armed services or lawful conduct of war, or any other provision of law imposing a public duty. That sounds a lot like dividing a line between official and private conduct. I think it's narrower, and I recognize it's a defense, not an immunity. But when you look at the definition of it, are you acting within the scope of authority conferred by law or discharging a duty conferred by law? I think it's narrower than Blasingame, narrower than Nixon versus Fitzgerald, but that's what it sounds like to me. Do you agree or disagree?
You know, Justice Barrett, I certainly understand the intuition that when you act outside of your lawful authority, you've kind of gone on a frolicking detour, you're no longer carrying it out. I don't really think that that quite works for presidential activity. The only way that he could have implemented the orders is by exercising his commander-in-chief authority over the armed forces or his authority to supervise the executive branch. Those seem like core executive acts to me. There is such a possibility as an unlawful executive act.
I'm not sure that I understand your answer. I mean, I was thinking, it seemed to me that in your briefs and today, when you referred to the public authority defense, you said that's one of the built-in protections and why immunity is not necessary. Because in some of these instances, when the president takes such actions that, you know, the court's been asking you, might this result in criminal prosecution, you say, well, he could raise this public authority defense. And so I'm saying, isn't this public authority defense, if raised, doesn't it sound like a defense that says, well, I was authorized by law to discharge this function?
And therefore, I acted lawfully.
Therefore, I acted lawfully and
Yes.
am not criminally liable.
Correct.
Does that involve a look into motives? Kind of gets to what Justice Gorsuch was asking you. Could you say I was acting within the scope of my authority by granting a pardon, removing a cabinet officer, but then the public authority defense might not apply because you had a bad motive in doing so?
No, I don't think so, Justice Barrett. I think that it operates based on objective facts disclosed to counsel. Counsel then provides the advice, in this case, the Department of Justice, and it's an objectively valid defense. It's a complete defense to prosecution.
So what would be so bad? I mean, one thing that strikes me as different, well, one thing that's obviously different between the public authority defense and immunity is an interlocutory appeal and having it resolved at the outset. What would be so bad about having a question like that resolved at the threshold, having it be an immunity? The same kind of question that could be brought up as a defense later, but have it be brought up at the threshold as an immunity, and then an interlocutory appeal would be available, and it would be a freedom from standing trial, but not a get-out-of-jail-free card.
Yes, I understand that, and I think that if the court believed that that was the appropriate way to craft presidential protections, it has the authority to craft procedural rules that implement its Article 2 concerns. That said, public authority we're calling it a defense, but under many statutes it's actually an exception to liability itself. And what you're really talking about is trying the general issue. And generally in criminal cases, even cases that involve First Amendment issues like threat statutes, the jury is the determinant of the facts. And I have a little bit of difficulty with the idea of trying the whole public authority issue separately to the judge and having that go up on interlocutory appeal with review of facts before you could ever get it forward into a criminal case. That said, if I would prefer a regime in which the court altered some of the procedural rules surrounding the president than a total, absolute blanket immunity that takes away the possibility of criminal prosecution, even if it was a core violation of the statute in the teeth of Attorney General advice and has no overriding public purpose.
You think it has to be a jury question? And I mean, let's see, I wasn't necessarily proposing actually treating it as a defense that was done at the outset and then subject to interlocutory appeal. I was proposing, what about an immunity doctrine that drew from the public authority defense that the Department of Justice thinks would otherwise apply? So just go with me on that for a minute. Why would it be so bad for it not to be a jury question? I mean, it seems to me that some of these Article 2 concerns would be exacerbated by having it go to a jury rather than a judge.
So I think some of them are judge questions that could be resolved on the face of the indictment. If the Department of Justice ever returned an indictment that said the issuance of this pardon or this series of pardons constituted obstruction of justice, I have a little difficulty hypothesizing it, but a motion could be made on the face of the indictment that says Article 2 precludes Congress from regulating these activities. The indictment needs to be dismissed. And if the court wished to attach to that kind of a rule interlocutory appeal, then that would be a lesser safeguard than the one that my friend is proposing here. Other kinds of defenses, though, really do intersect with the general issue. And for those, I have a much greater time seeing how the court could implement that. And would there be costs in going to trial? Yes. There is no perfect system here. We are trying to design a system that preserves the effective functioning of the presidency and the accountability of a former president under the rule of law. And the perfect system that calibrates all of those values probably has not been devised. I think that the system that we have works pretty well. Maybe it needs a few ancillary rules. It is different from the radical proposal of my friend.
I agree. Let me ask you about state prosecutions, because if the president has some kind of immunity that's implicit in Article 2, then that immunity would protect him from state prosecutions as well. A lot of the protections that you're talking about are internal protections that the federal government has, protections in the Department of Justice, which obviously are not applicable at the many state and local jurisdictions across the country. What do you have to say to that?
So that raises a supremacy clause issue, and the court would run a supremacy clause analysis that would probably start with basic principles like McCulloch versus Maryland. The states do not have the authority to burden federal functions, and would then kind of move through in Nagel, where the court said that a state murder prosecution of a federal official guarding a Supreme Court justice and who fired a shot was not permissible. If the court thought that you needed a more categorical rule for the states, I think the supremacy clause certainly leaves it within the court's prerogative to determine that the president, unlike all other officials, deserves more of a robust federal defense than what I have just described.
But it would still be a defense in the states. It wouldn't be, I mean,
well,
that's my point. Like, you know, it's one thing to say, well, the president, they're not going to be these prosecutions that are politically motivated, the things that Justice Kavanaugh was referring to that might be the danger of this system, one thing that we have to worry about. That might not carry the day, but, you know, that's a concern. It's totally different when you take it outside of the Department of Justice and its structures, and then you throw it out elsewhere. The idea across the states, the idea of an immunity, I think, has a lot more purchase if you're talking about something that protects the former president from standing trial and the state and local level.
So I don't know that you would have to design a system in which the president would have to stand trial at the state and local level. It's certainly within the court's authority as a matter of supremacy clause law to find an immunity. But we have been talking here about, at some length, on the distinction between official acts and private acts.
Yeah.
That will have to be determined by some sort of a process. Any immunity defense that the court announces can still be met by a state assertion that we're prosecuting private conduct. You're going to have some process. I think having some legal process is not a reason to cast aside a nuanced system that actually looks at what protections are necessary as opposed to what would provide the absolute maximum insulation for former presidents, even if we acknowledge that it's highly prophylactic.
Totally agree, and I wasn't actually contrasting the absolute immunity rule. I was saying that if there was some sort of official private, there are consequences towards about making immunity. Okay, and since you bring up the private acts, this is my last question. So I had asked Mr. Sauer about on page 46 and 47 of your brief.
Yes.
You say, even if the court were inclined to recognize some immunity for a former president's official acts, it should remand for trial because the indictment alleges substantial private conduct.
Yes.
And you said that the private conduct would be sufficient?
Yes.
The special counsel has expressed some concern for speed and wanting to move forward. So, you know, the normal process, what Mr. Sauer asked, would be for us to remand if we decided that there were some official acts immunity, and to let that be sorted out below. It is another option for the special counsel to just proceed based on the private conduct and drop the official conduct?
Well, two things on that, Justice Barrett. First of all, there's really an integrated conspiracy here that had different components as alleged in the indictment. Working with private lawyers to achieve the goals of the fraud, and as I said before, the petitioner reaching for his official powers to try to make the conspiracies more likely to succeed. We would like to present that as an integrated picture to the jury so that it sees the sequence and the gravity of the conduct and why each step occurred. That said, if the court were to say that the fraudulent elector scheme is private, reaching out to state officials as a candidate is private, trying to exploit the violence after January 6th by calling senators and saying, please delay the certification proceeding, is private campaign activity, we still think, contrary to what my friend said, that we could introduce the interactions with the Justice Department, the efforts to pressure the vice president, for their evidentiary value as showing the defendant's knowledge and intent, and we would take a jury instruction that would say, you may not impose criminal culpability for the actions that he took. However, you may consider it insofar as it bears on knowledge and intent. That's the usual rule with protected speech, for example, under Wisconsin versus Mitchell. My friend analogizes this to the speech or debate clause, but we don't think the speech or debate clause has any applicability here. It's a very explicit constitutional protection that says senators and representatives shall not be questioned in any other place. So it carries an evidentiary component that's above and beyond whatever official act immunity he is seeking. And the last thing I would say on this is we think that the concerns about the use of evidence of presidential conduct that might otherwise be official and subject to executive privilege is already taken care of by United States versus Nixon. That balances the president's interest in confidentiality against the need of the judicial system for all available facts to get to the truth. And once that has been overcome, we submit that evidence can be used even if culpability can't rest on it.
Thank you.
Justice Jackson?
Just to pick up where Justice Barrett left off, I think I heard you say that even if we decide here something, a rule that's not the rule that you prefer, that is somehow separating out private from official acts and saying that that should apply here, there's sufficient allegations in the indictment, in the government's view, that fall into the private acts bucket that the case should be allowed to proceed.
Correct.
Because in an ordinary case, it wouldn't be stopped just because some of the acts are allegedly immunized, even if people agree that some are immunized. If there are other acts that aren't, the case would go forward.
That is right.
All right. Going back to the clear statement argument, I'm struggling with that argument because my understanding was that when a charged criminal statute is read narrowly in the presidential context to not apply to the president, a constitutional question is being avoided. So that you're doing that to avoid having to deal with the constitutional question. So what is the constitutional question that is being avoided in those kinds of situations?
A serious one. This is just an application of this court's ordinary construction of criminal statutes, that if there is an available interpretation that would avoid a serious constitutional question, the court's preference is to
right, and the nature, I guess I'm going at, my understanding is that what is being avoided in that situation is the question of whether a former president or, can be held criminally liable for doing the alleged act that is being asserted in that statute consistent with the Constitution. So we look at the statute, it's got some elements in it, and we are saying, well, geez, if this statute and those elements apply to the president's conduct in this situation, we'd have to answer the question, can the president be held liable consistent with the Constitution for that behavior? Is that right?
So the first step in that analysis, I just want to...
Yes,
yes,
please.
But the first step is there ambiguity? And these statutes apply to any person. They apply to whoever. There's no ambiguity in those phrases. This court in Nardone versus United States concluded that similar words, any person, apply to government officials.
All right, well, let's just assume that I guess I'm just trying to get at, we're avoiding a constitutional question if we do that in the ordinary case. And what's confusing to me about this case is that we're not being asked to avoid the constitutional question. In fact, the question of whether or not the president can be held liable consistent with the Constitution or does he have immunity is the question that's being presented to us. So I don't understand how the clear statement kind of analysis even works. It seems completely tautological to me for us to hold that presidents cannot be prosecuted under any criminal statute without a clear statement from Congress to avoid the question of whether or not the Constitution allows them to be prosecuted. We'd have to have a reason, right? I mean, we'd have to have a rationale for applying the clear statement rule.
I think the court would have to have some rationale that's not evident in either the existing doctrine or the text. And just one data point for the court in thinking about how the clear statement rule works. In United States versus Sun Diamond, a case about gratuities that the court is probably familiar with, Justice Scalia wrote an opinion for a unanimous court in which he used a hypothetical about what would happen if the president received a sports replica jersey at a typical White House event. Would that violate Section 201C? And the court offered a construction that it had to be for because an official act to avoid that problem. I think if there was such a well-received understanding that presidents are not included in general federal criminal law, unless the president is specifically named, which he is not in Section 201, Justice Scalia would have thought of that, and some member of the court would have reacted, and none did.
All right, let me go on to ask about what you take the petitioner's position to be in this case, because we've had a lot of talk about drawing the lines Justice Kavanaugh, Justice Gorsuch suggested that we should be thinking about blasting game, and that within the, first we have private versus official, and then within official now we have something about core acts versus other acts as we try to figure out, you know, at what level the president is going to have immunity. But I took the petitioner's argument in this case not to be inviting us to engage in that kind of analysis. I thought he was arguing that all official acts get immunity. And so I didn't understand us to be having to drill down on which official acts do. And so my question is, why isn't it enough for the purposes of this case, given what the petitioner has argued, to just answer the question of whether all official acts get immunity?
That is enough, and if the court answers that question the way that the government has submitted, that resolves the case. I want to make a clarification that I may have left the court with some uncertainty about. The official act analysis that my friend is talking about is the Fitzgerald versus Nixon outer perimeter test, which is extremely protective of the president. It's not looking at core versus ancillary. It's saying everything the president does is a target for private civil lawsuits. That is not a great thing, and therefore they are all cut off.
That's an absolute immunity kind of concept, right? Anything that's official in the outer perimeter is not subject to liability.
That is right.
And so we don't have to then go, well, okay, we have the bucket of official, now let's figure out which within that might be subject to liability, not on the theory of absolute immunity, correct?
Neither on the theory of absolute immunity or on our theory. On his theory, everything's protected. On our theory, there is no immunity. But this is where I would draw the distinction. There are as-applied constitutional challenges that you run through the Youngstown framework and this court's customary method of analysis, and you determine whether there's a infringement of Article 2.
So what you're saying is even if we reject the absolute immunity theory, it's not as though the president is, you know, doesn't have the opportunity to make the kinds of arguments that arise as at the level of, you know, this particular act or this particular statute has a problem in retrospect. I think I hear you saying we should not be trying to, in the abstract, set up those boundaries ahead of time as a function of sort of blanket immunity, allow each allegation to be brought, and then we would decide in that context.
Yes, with the additional note that petitioner has never made that argument, and I think it would be up to a district court to decide whether to go that route at this point in the litigation. He's put all of his eggs in the absolute immunity basket.
All right, and if we invite, you know, if we see the question presented as broader than that, and we do say let's engage in the core official versus not core and try to figure out the line, is this the right vehicle to hammer out that test? I mean, I'd understood that the most, if not all, but most of the allegations here, there's really no plausible argument that they would fall into core versus not, such that they are immune.
We don't think there are any core acts that have been alleged in the indictments that would be off limits as a matter of Article 2.
So if we were going to do this kind of analysis, try to figure out what the line is, we should probably wait for a vehicle that actually presents it in a way that allows us to test the different sides of the standard that we'd be creating, right?
I don't see any need in this case for the court to embark on that analysis.
All right, the final sort of set of questions that I have to do with what I do take as a very legitimate concern about prosecutorial abuse, about future presidents being targeted for things that they have done in office. I take that concern. I think it's a real thing. But I wonder whether some of it might also be mitigated by the fact that existing administrations have a self-interest in protecting the presidency, that they understand that if they go after the former guy, soon they're going to be the former guy, and they will have created precedent that will be problematic. So I wonder if you might comment on whether some of the caution from the Justice Department and the prosecutors and whatnot comes from an understanding that they will soon be former presidents as well.
I think absolutely, and I would locate this as a structural argument that's built into the Constitution itself. The executive branch, I think as this court knows, has executive branch interests that it at times asserts in opposition to Congress so that the proper functioning of the president is protected. And I believe that that value would be operative and is operative in anything as momentous as charging a former president with a crime.
And I would also say, I think, and ask you to comment on, presidents are concerned about being investigated, evaded, and prosecuted, and it chills to some extent their, ability to do what they want in office. And that's a concern on one side, but can you comment on the concern about having a president unbounded while in office, a president who knows that he does not have to ultimately follow the law because there is really nothing more than, say, political accountability in terms of impeachment? I mean, we have amicus briefs here from Professor Lederman, for example, who says, a president would not be prohibited by statute from perjuring himself under oath about official matters, from corruptly altering, destroying, or concealing documents to prevent them from being used in an official proceeding, from suborning others to commit perjury, from bribing witnesses or public officials. And he goes on and on and on about the things that a president in office with the knowledge that they have no criminal accountability would do. I see that as a concern that is at least equal to the president being so worried about criminal prosecution that he, is a little bit limited in his ability to function. So can you talk about those competing concerns?
So, Justice Jackson, I think it would be a sea change to announce a sweeping rule of immunity that no president has had or has needed. I think we have also had a perfectly functioning system that has seen occasional episodes of presidential misconduct. The Nixon era is the paradigmatic one. The indictment in this case alleges another. For the most part, I believe that the legal regime and the constitutional regime that we have works, and to alter it poses more risks.
Thank you.
Thank you.
Thank you, counsel. Rebuttal, Mr. Sauer?
I have nothing further, Your Honor.
Thank you, counsel. Counsel, the case is submitted.
The Honorable Court is now adjourned until Thursday, the 9th of May at 10 o'clock.
The tension here at Cape Canaveral.
Sending astronauts to space is a lot more fun than not sending astronauts to space.
T-minus 1 minute and counting.
And NASA should know.
Ignition.
For decades, the country that landed 6 crews of astronauts on the surface of the moon was the undisputed leader among spacefaring nations. But since 2011, after the last of the great American space shuttles flew, the U.S. has been completely unable to launch its own astronauts aboard its own rockets from its own soil.
One final time.
Instead, we have become a grounded nation, a humbled nation, reduced to hitching rides aboard Russia's Soyuz rocket at $80 million a seat. That all changes now. When a SpaceX Falcon 9 rocket and Crew Dragon spacecraft leave the launch pad at Cape Canaveral carrying astronauts Bob Behnken and Doug Hurley on May 27th, an entirely new chapter in space travel will begin. The launch marks the beginning of the age of commercial crew flights, a great democratization of the space game, with private companies designing and building glittering 21st century rockets using 21st century technology and selling their services to NASA, leaving the space agency free to focus on its longer-term dreams of sending astronauts to the moon and Mars. SpaceX is not the only company that will be part of this grand new enterprise. In position to fly soon is Boeing's Starliner spacecraft, which will tag team with SpaceX in getting crews to and from the International Space Station. It is altogether fitting that the upcoming launch will take place from Cape Canaveral's Pad 39A, the same pad from which Apollo 11 launched, carrying the first crew of humans to the surface of the moon. Just as a new era began then, so too is one beginning now. America, once grounded, is flying again. This afternoon, as we broadcast live from Kennedy Space Center in Florida, I'm Jeffrey Kluger at the Time Magazine headquarters in New York. It has been 9 years since the final flight of the final space shuttle, which means it's been 9 years since the United States has had the capability to launch its own astronauts aboard its own rockets from its own soil. That's the longest America has been grounded since Alan Shepard became the first American in space 59 years ago this month. In that time, America launched 6 one-person Mercury missions, 10 two-person Gemini missions, 15 three-person Apollo missions, and 135 missions of the Space Shuttle. Every single one of those spacecraft had something in common that they do not have in common with today's flight. They were effectively designed by NASA and then built to order by a company it hired to do the job. The SpaceX Crew Dragon vehicle that will take astronauts Bob Behnken and Doug Hurley to space today will be the first privately designed and built rocket and spacecraft ever to fly human crew. History will be made by the mere fact that America is getting back into the space game, and more history will be made by the fact that that feat will be achieved in so different a way. We have what's known as an instantaneous launch window at Cape Canaveral today, and what that means is when this rocket takes off, this rocket can take off at 3:22, period. It can't take off at 3:22 and a half, it can't take off at 3:22 and a third. That's because it has to rendezvous with the International Space Station, which is currently in an orbit with a 51.6 degree inclination to the equator. That's a pretty high inclination. At 250 miles of altitude, the spacecraft will launch from an entirely different orientation. Basically, that means 19 hours of chasing the space station before the crew catches up with it. It'll take only 12 minutes to get to space. It'll take a full day almost before the crew actually docks. Bad weather scrubbed the launch last week or on Wednesday, and there is a lot that can go wrong when it comes to the weather. NASA has a whole series of rules dictating when spacecraft will be grounded. You don't launch within 10 nautical miles of an attached thunderstorm. You don't launch within 3 nautical miles of thunderstorm debris clouds. You don't launch within 5 miles of disturbed weather. You don't launch within 10 miles of cumulus clouds. There's rule after rule after rule intended to keep the crews safe. Now, this isn't to say that people haven't launched in dangerous conditions before. They have. The Apollo 12 crew, which launched in November of 1969, was actually struck by lightning barely a minute after it got off the pad, causing the entire electrical system to drop out. So that was a cautionary tale. The shuttle Challenger was, of course, America's great tragedy in 1986 when Challenger blew up on liftoff, and a great deal had to do with flying in cold weather when the O-rings that sealed the solid fuel in the solid fuel boosters on either side of the spacecraft became brittle and burned through, causing the explosion that claimed the crew's life. So weather is a critical issue in any launch, and it will be an issue in today's launch, as disappointing as it was on Wednesday when the spacecraft did not launch on time. We have to be prepared for possible disappointment again today. Safety is paramount in a launch like this, especially in a first test of a first spacecraft with a first new crew flying it. And Doug Hurley will be wearing an entirely new generation of spacesuits today. The suits that were designed were actually designed in part by a Hollywood costume designer, Jose Fernandez, who designed some of the costumes for Batman versus Superman and the Avengers. Fernandez has told the press that Elon Musk, the head of SpaceX, said, quote, "When people put this spacesuit on, I want them to look better than they did without it, like a tuxedo." It is a one-piece suit. It effectively is a spacecraft all by itself, a self-contained life support system for the astronauts. They can slip into it easily, and it plugs directly into the life support systems of the suit. We now have some interesting footage from SpaceX describing how the suits were designed by the people who designed them.
I think one of the things that was important in the development of the suit was to make it easy to use, something that the crew just has to literally plug in when they sit down, and then the suit kind of takes care of itself from there. So the suit is really kind of one part of the bigger Dragon system. It's really part of the vehicle. So we think of it as kind of a suit-seat system. So the seat that the crew is in and the suit are in a lot of ways working together. And so it made sense that we were designing Dragon in-house to also design the suit.
Our spacesuit is completely designed in-house. It's built here in Hawthorne, California, in the same building as the rocket and the capsule. The spacesuit is custom-made for each crew member, and that is to optimize the fit for the crew member.
We definitely wanted to innovate, and we wanted it to look inspiring, but first and foremost, we wanted it to be safe and reliable. The spacesuit's primary purpose is to protect the crew in the unlikely event that the cabin were to depressurize. But the suit does a number of additional things. It provides cooling and communication to the crew inside of the suit, provides them hearing protection, and the outer layer of the suit is flame resistant, so it provides flame protection as well. When the crew gets in the capsule, they get in their seats and they plug the suit into the umbilical that's attached to the seat. And the umbilical is providing everything that the suit needs. So it provides the avionics or electronics for communications, is providing the air to cool the suit, and then it also provides gas when needed to pressurize the suit. So it's really a single point that lets the suit do all the things that it needs to do. We designed the helmet in-house. The helmet serves a number of different functions. Obviously, it's protecting the crew's head and it's retaining gas like the rest of the suit, but it also houses the microphones as well as the valves that are regulating pressure in the suit. We had to design the gloves so that they would work with the touchscreens, but the gloves also still had to do a number of other things like the rest of the suit. So all of those things had to come together within the glove. It'll be obviously really amazing to see Bob and Doug in their flight suits, and I think one of the things that's cool about the suit is it's not just a piece of hardware, it's not just a suit, it's a very personal thing. It's Bob's suit and it's Doug's suit. And so seeing the two of them in their suits using it in flight will be just a really amazing thing.
Känn Hallon-effekten med ett billigt mobilabonnemang.
We're looking at a shot now inside the Launch Control Headquarters at Kennedy Space Center. There are actually three active mission controls operating today. There is the Launch Control Center here at KSC at the Kennedy Space Center. There is a Launch Control Center at the SpaceX headquarters in Hawthorne, California. And, of course, there is Mission Control in Houston, which will take over the flight the moment the engine bells clear the tower. As soon as the spacecraft is free of the gantry, it is basically Houston's bird to fly in cooperation with the crew in Hawthorne, California. What we're seeing now is the area around the crew walkout facility. Down that small gangway you see right in the back, this is the ramp and the doorway through which historic crews have passed before. The first, right here we have the first crew to go to the first moon landing, Buzz Aldrin, Neil Armstrong, and Michael Collins. This is the Apollo 11 crew. This is the first crew to fly the space shuttle, Bob Crippen and John Young, in 1981. This, tragically, is the Challenger crew at their walkout on the way to their flight. This, similarly, is the Columbia crew, the crew that was lost in 2003 when their spacecraft broke up on re-entry. There have been many more successful missions coming out of these doorways over the course of decades than there have been these periodic tragedies. And we see Bob Behnken and Doug Hurley. This is from last Wednesday during their walkout, wearing the new SpaceX spacesuits. They are climbing into a gull wing Tesla, and one of Elon Musk's companies, on their way to the launch pad. We are told that on that flight, on that drive to the pad last Wednesday, their audio track included AC/DC, the Blues Brothers, and the Star Spangled Banner to get them into a patriotic mood. The look at the pad right now is not enormously promising. The cloud cover obviously suggests that there could be some weather delays again today. Of course, a weather delay effectively means a scrub because, as we said, we have a 3:22 p.m. instantaneous launch window. It slams shut at 3:22, and at that point, the crew would have to wait again until tomorrow at 3 p.m. What we're seeing here is the swing arm attached to the Crew Dragon spacecraft. That swing arm runs from the gantry, that scaffolding that stands next to the rocket, and provides the crew access to the spacecraft itself. The large building we were just looking at was the vehicle assembly building, where the rocket is, as the name suggests, assembled and uprighted. Again, we are back on the pad here. The sight of the flag waving as briskly as it was in the breeze is not necessarily the best indicator of ideal weather, as is this cloud cover. But for now, all systems are still considered go, and the flight is still a go for 3:22 p.m.
Det finns hushåll i Sverige. Förra året var det som flyttade. Flyttade till Norrbotten, flyttade till Södermalm. Vem du än är, hur du än bor. Välkommen till Ikano Bank.
We are seeing now astronauts Bob Behnken and Doug Hurley walking through those same historic doors, getting ready to be transported to the pad. That's Bob Behnken on the right, Doug Hurley on the left. Doug is the overall spacecraft commander. Bob is the commander of the crew activities, particularly rendezvous and docking. You notice that in the space game, everybody gets the name commander in their title. Nobody wants to be seen as the subordinate. Back in the days of the Gemini program, they were called not pilot and co-pilot, but the command pilot and the pilot for the same reason. These are the astronauts, of course, saying goodbye to friends and family. You note that in this time of quarantine especially, there's no physical contact. This has been going on since long before the COVID era. There have been crew quarantines as far as long ago as the Gemini program. The crew climbing into this Tesla Gullwing will be attached to the seats through the same life support system that attaches them to the seats in the spacecraft. This allows oxygen and other life-sustaining systems to begin running through the suits. Think of each of these suits as a freestanding independent spacesuit. They are now getting primed for the suits to be able to sustain them once those helmets are closed. Basically, once those helmets are closed, the crew will have breathed fresh air for the last time until they return to Earth. It will be canned air on their way up, on their time aboard the station, and on their way down. They now begin a 9-mile ride out to the launch pad. One more goodbye to family and friends, and then off they go for that ride to the pad, which is close to the last time we will see them live until they return to Earth, anywhere from a month from now to 3 months from now. Typically the ride to the launch pad has taken place in a sort of RV, a recreational vehicle, a climate-controlled van in which the crew sat together. This caravan of Teslas is the kind of advertising money can't buy, but they are also sweet machines, and they are in keeping with the technology that's on display today, which is Elon Musk's two key companies. So it is only fitting that they will drive to a SpaceX space capsule spacecraft in a Tesla car. The one astronaut who has gone to the pad before in a the distance, the mileage to the launch pad is a function of the fact that what the astronauts will be flying aboard today is essentially a 76,000 gallons of highly explosive fuel in a 229-foot rocket. That is a very dangerous machine, and all flights are observed. The viewing stands are about 3.5 miles from the launch pad itself. The somewhat circuitous route that the crew has to travel via NASA roadways to get them out to the pad is about 9 miles, which is why we see this long motorcade. During the days of the Apollo program, the Saturn V rocket, had it exploded on a launch pad, would have produced the greatest non-nuclear explosion ever engineered by human beings. So there was a 3-mile sort of no-go footprint stomped around the rocket. There was an absolute absence of any other human life aside from the astronauts themselves and the key pad crew technicians and the hundreds of thousands of people who watch those launches, watch from that 3-mile distance. Here we're seeing the motorcade approaching closer to the pad. Once it arrives, the crew will board the elevators that will take them up the gantry and to the spacecraft level at the top of the Falcon 9 rocket.
Be on the pointy end of the rocket, getting a chance to go up to space. It's just a momentous moment.
And they're listening to some tunes too, I heard, right, Lauren?
Yeah. There are at least 3 songs on their playlist that are super interesting. The first is AC/DC's Back in Black. You know that one.
Yeah, well, who doesn't?
Right. Another one that they're listening to is the elevator music from the Blues Brothers film, The Girl from Ipanema.
Oh,
Leland.
Okay.
Got another career.
That's enough.
Career
That's
number
enough.
3.
That's right. NFL, astronaut, musician. Yep.
And, of course, they are also listening to the Star Spangled Banner, the Army French horns version.
Now, we didn't have tunes in the Astrovan.
No?
And I know that the Tesla has a really kicking stereo system. Is that still the custom stereo system that's in the Tesla?
I haven't been in this one, so I don't know what they're rocking, but I'm sure it's pretty cool.
And again, just for some perspective, they left the operations and checkout building just a minute ago, and so it's about a 9-mile drive from there to the launch pad. It takes them around 20 minutes, kind of depends on how quickly they're trucking.
The other thing sometimes that you hear as you're in the convoy is the helicopter, the Huey helicopter flying overhead, and it's kind of also, you're thinking military, you're thinking really important things, and it's a moment that also kind of solidifies in you that, hey, something big is about to happen, and that whoop, 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 the sound of that Huey is in your head, and it feels good that all these people are helping you get there safely.
Yeah, I think we heard that actually coming by
We did.
this building earlier, because we were talking, and I was like, I hope that's what I think it is.
And it was pretty low because it was pretty loud.
You could feel it,
I
too.
did. I could feel it.
I took this drive yesterday in my rental car, and granted it wasn't in a Model X, and I'm not an astronaut, but driving to 39A, that same route, and trying to put myself, imagine myself in that headspace, it was pretty awesome. I got to figure out how to get on Falcon 9.
Lauren, we're all astronauts. We're in space.
That is true.
You just got to get on the rocket.
Yeah, well, Leland, there's a big group of people that want you there.
I think we should, listen to them.
Yeah, I'm all for it.
I think we should.
Maybe we should make that a poll question.
Yeah. Well, we should all maybe go to space. What do you think?
I am on board. I mean, not literally right now, but I would like to be on board.
Lauren, would you go with us?
Absolutely.
Okay, poll question.
We have so many people watching online, sending well wishes to Bob and Doug. I mean, it started early this week as we were ramping up for Wednesday, and I feel like it's just been this buildup of momentum because, we were following along Wednesday, and now we're all following along Saturday, and we have people watching from home that hopefully don't have to work today and can really tune into what's going on here.
And we, as astronauts, truly appreciate all the support, all the social media feeds, and we think about, our families. We saw Megan and Karen there with their sons, wishing Doug and Bob well wishes.
Convoy is now approaching Launchpad 39A, the historic pad from which Apollo 11 launched, from which nearly all of the lunar flights launched, and which is now leased to SpaceX for the launch of the Falcon 9 rocket and ultimately the Falcon Heavy rocket. We see well-wishers on the side of the road. We see the waving. We see the farewells. This is the critical moment when the crew will begin to take leave of the Earth, take leave of these ground-based vehicles, and become a part of the machine that's going to take them to space. When they arrive, there will be a short walk from the cars to the elevators that will take them up to the top of the gantry level, through the swing arm, and over to their spacecraft, which will be their home for the next 20-some hours. About 24 hours from right now, the crew will be rendezvousing with the International Space Station. As we said before, it'll take them only 12 minutes to get to space, but it will take them 19 minutes to catch up with the ISS, the International Space Station. And when they board, they will be aboard the station for anywhere from a month to 3 months. We hear these helicopters overhead now. You can see these, the NASA logo on the back of the Teslas is the 1970s worm logo, it was called, because of its squiggly sort of sine wave design The worm logo has been taken out of mothballs and is being put back to use, along with a more traditional NASA blue round logo that is nicknamed the meatball. On what we're looking at right here, toward the left, what that structure that looks like a water tower is exactly that. It is a water tower that dispenses hundreds of thousands of gallons of water to cool the launch pad shortly after the engines light. The larger structure in the middle is the gantry that holds the elevator and other support structures. And at the top of the gantry, off to the right, you see that swing arm, which will be the gangway that the astronauts will walk across in order to board the rocket.
Danger area. Now, before any pad technicians, engineers, or astronauts enter that area around the launch pad, the SpaceX and NASA teams do an internal go-no-go poll to make sure everything is clear.
This storied launch pad, which has been the beginning point for so many firsts, is the perfect backdrop for today's historic launch that marks a new first and a new era in human spaceflight.
Kom till köket och prata om allt mellan himmel och jord med varsin macka, dela sorger och skratt. Jag vill ha gjort mackor till oss.
Bjud in till ett viktigt snack på snackmackan.se. Hälsningar Polarbröd i samarbete med Friends.
And here's a view from our gantry near the Launch Complex 39A. We've got another view of the convoy going by here. If I had to count up all the cameras we have all over the place for this, I'd be here all day.
That's a beautiful shot right there, looking at the Kennedy Space Center and Merritt Island and all of the nature around us. It's a big buffer from 39A so that we can be safe and launch our rockets off to space safely.
Absolutely, and a lot of people don't realize this is a national wildlife refuge. I mean, I pass turtles on the way to my car every day.
Yeah. Well, when we would run from the operations and checkout building, we'd have to watch out for snakes and for alligators, and so to be really careful about the wildlife.
We used to have one who lived at 39A.
Oh, really?
Yeah, an alligator.
Well, maybe we'll see him. We'll keep an eye out. Tweet at us if you see any.
Did you name him Worm?
Ooh, ahead of my time.
I don't know how an alligator would feel about being called Worm, Leland.
Yeah, well.
And we've got a ton of you following along on social media. Lynn says, as a fellow Missourian, we're so proud of Bob. Launch America, we will be watching from the Space Coast, cheering loud. And another comment, Godspeed and good luck, Astro Benkin and Astro Doug, hashtag Launch America. There you see the SpaceX horizontal integration facility. It's on the left of the screen now. We saw the front of it from the other angle. Or I'm sorry, no, there it is. I was getting my buildings mixed up, so it's on the right now.
Yeah,
Bigger building.
The other's the Falcon Support Building. It's where all of our offices are, and yes, you're correct.
Thank you for the correction, Laura.
There's our hangar. We process Falcon Heavy in there. There are other boosters in that hangar as well. And the rocket and Dragon that is on the pad right now was put together, or rather finally integrated inside of that hangar and then rolled out to that pad to go up vertical.
And there it is. That shot really gives you a sense of the scale of the Falcon 9 rocket. Those Teslas look teeny, teeny, tiny, making their way up there. And so as they make their way up to the pad, we're going to throw it over now to Hawthorne, where Jesse and Dan are watching the action. Hi, guys.
another pretty key upgrade is the Dragon's new life support system. As you can imagine, flying humans requires keeping a habitable environment throughout the entire flight, and that means covering everything like providing breathing air, keeping the capsule at a safe pressure, keeping it free of contaminants, removing any carbon dioxide in the air, regulating the temperature, the humidity, all of these things, and also implementing that waste collection system, aka the toilet.
That sounds pretty important. The changes to Falcon 9 were small but extremely meaningful to meet NASA's requirements for safety for human spaceflight. And specifically, SpaceX had to prove a high degree of fault tolerance, meaning that small failures in the system would not lead to mission failure. Falcon 9 was already able to handle engine failure, but new emphasis was put on making sure that a failure throughout any phase of launch would not mean mission failure. And this goes all the way down to latches, control valves, electronics, wiring, and so much more.
All right, well, with the astronauts now on location at Pad 39A, we're going to swing it right back. Marie Lauren Leland, take us through the crew making their final steps towards the Dragon spacecraft.
Sure thing. So we are looking again at Launch Complex 39A. Just a few seconds ago, we saw the Tesla carrying Bob and Doug pull up to the launch pad. This is the site of so much history, you guys. This is where Apollo and Saturn V rockets that launched to the moon took astronauts from. I mean, this pad has so much history. Leland, you launched from there. What's it like seeing Crew Dragon and Falcon 9 there with the pad? With all of the visual changes that have been made, I mean, what kind of emotions does this stir up in you?
You know, when we got out of our Astro van, we stepped out and we just looked up to see this vehicle, and it was creaking, it was groaning, it was making noises, it was getting ready for us to enter it, to take us off planet. And you know, you get a chance to take a picture. Sometimes you stand there, you look there, you think about all the training you've done, all the preparation, and again, all the people that have helped you get there. And it's just a solemn, amazing moment for all of us.
And there's another amazing drone shot. Lauren, you explained this a little bit earlier about kind of how SpaceX brings the rocket and capsule vertical. Now that we see it, can you kind of explain that again for folks who maybe missed that?
Yes, of course. Dragon is actually processed a few miles down the road at Area 59, or Dragonland as we like to call it. We then put it on a truck and drive it all the way to the hangar where the rocket is. And so what will happen is we'll then we call it break over, where the vehicle's up vertical, we'll turn it sideways because the rocket is being processed sideways or horizontal into the hangar, lift it, mate it to Falcon 9, and then roll up those hangar doors and essentially pull the vehicle in the transporter erector, which is the big white truss structure that you see there. Mm-hmm. All the fluid lines, electrical lines, and everything are connected to the vehicles via the TE, transporter erector. And they basically roll it up those rails. You can't really see them. You kind of see them in the screen, those rails. Mm-hmm. Roll the entire TE rocket Dragon assembly up to the very top of the pad, pin it into the pad systems, and then roll it up vertical.
And we are about T-minus 2 hours, 57 minutes, 44 seconds, and counting. In just a couple of minutes, we are expecting to hear a formal announcement that the crew is at the pad. Of course, we saw them pull up in the Teslas, and there they are. Looks like they've already gotten out of the car, and they are walking up to the elevator that will carry them all the way up to the 255-foot level, and then they'll have a couple of steps to get up to the level where the crew access arm is.
I have the AC/DC song in my head as I see them walking up.
You know what I was kind of jamming out to on my way in was ZZ Top, Sharp Dressed Man.
Oh, nice.
I was like, I don't know, that might be on my playlist if I was in there. There they are, taken in the sight, craning to see the top of the Falcon 9 rocket. It's 230 feet tall if you round up, and then Crew Dragon is another 27 feet from the bottom of the trunk to the top of the nose cone. So when you're out there in person, it's really hard to describe just how large it is.
Look at them getting excited. They're ready to get in the vehicle, get in the elevator, and make it to the top. There's some FOD. He's picking up foreign object debris.
Appreciate that. They're also wearing FOD covers on their shoes, by the way.
Oh, really?
Yeah. We want to make sure that they don't, track the outside inside of Dragon when they go in. And so right before they enter the vehicle, they'll remove the FOD covers off of their boots.
You take for granted, all just the little details like that, all of the thought and preparation that has to go into literally every single piece of this operation.
I love the makeover of Pad 39A with the sleek black with the white ticking and the lines, and it's a very futuristic look for this iconic launch pad. And to think what's been there before with Mercury, Gemini, Apollo, shuttle, and now the SpaceX Crew Dragon getting ready for a launch to the International Space Station. Rocket fuel still going through my veins.
And we feel so honored to be able to launch from here. Oh, here they are. That's a really fast elevator.
Yeah.
I know, it really zips. That took them up to 255 feet in just a matter of seconds.
They were removing their FOD covers?
Looks like they were just maybe checking something on his boot or leg.
We should hear a call any moment that the crew has arrived at the pad as they make their way up the stairs, and they're headed to the crew access arm now. There's the worm again, popping.
You know it.
Meatball.
Don't worry, there's a meatball on Crew Dragon.
Those white arrows you see there are essentially illuminating the way for anyone who's up there to find their way to the escape baskets in the event of an emergency that would require them to get far away from the rocket and the pad.
And it's hard to tell from this angle, but there's actually a phone right here, and I can't tell if it's Bob or Doug that's using the phone right now. But Leland, can you explain the significance of that? It's the same phone that was there during the shuttle days.
Yeah, you get a chance to talk to maybe friends or family that you haven't maybe couldn't come to the launch. In this case, it's quite a few people. But just to have that last moment to talk to someone before you get in the vehicle. A beautiful view.
And we're watching the crew when they're done using the phone there. We expect them to be making their way into the crew access arm. And coming up at about T-minus 2 hours and 35 minutes, the astronauts will ingress, or that's a word we use to describe climbing into Crew Dragon. And we saw Doug do it a couple minutes early on Wednesday. They were a little bit ahead of schedule, so that time could be a little bit flexible. But that's going to happen with the assistance of the suit techs, and they will get strapped into their seats. And so with that coming up, we're going to head over to Hawthorne for a preview of what's in store for the future in space travel. Jesse?
We've been listening to NASA's feed of narrating what is going on the swing arm, on the pad at the moment. They will eventually be throwing out to Hawthorne, California, the headquarters of SpaceX, to show some of what's going on out there. At the moment, we see Bob Behnken removing the foreign object debris shoes from his boots that prevent them from tracking any foreign object, any dirt into this pristine new spacecraft. It's sort of like taking off your galoshes before you come into the house. The astronauts are about to cross that swing arm and then enter the spacecraft. You can see over that NASA meatball logo on the wall what looks like a little bit of graffiti. That is where the astronauts signed their names, Bob Behnken and Doug Hurley, before boarding last Wednesday. This is the beginning of a new crew tradition in this new White Room. And this, by the end of SpaceX's at least 6 missions to the ISS, that wall is going to be pretty full of signatures. You saw something similar in the walkout scenes when they were leaving through the double doors during the walkout to the vans that take the astronauts to the launch pad. You could notice over the doors dozens and dozens of crew stickers, crew patches, each one indicating a crew, whether from the Mercury, Gemini, Apollo, or shuttle eras, that have walked through those doors and gone to the launch pads. This marks a new tradition, autographing the walls of the White Room before boarding the spacecraft. the spacecraft they're getting into now, the Dragon, it's a young machine. It's a machine that's carrying humans for the first time, but it has a pretty robust history. There have been 22 Dragon launches so far, with 21 visits to the International Space Station. The spacecraft is capable of seating up to 7 people, which was the capacity, the maximum capacity of the much larger shuttle. It stands almost 27 feet tall and 13 feet wide. That's about the same width as the Apollo crew vehicle, but it's 2.5 times the height and the habitable capacity that the Apollo had. It is maneuvered in space by 16 Draco thrusters. Those are the thrusters that allow it to change its orientation and attitude in space. On the way back down, it descends under the power of 2 drogue parachutes and 4 main parachutes, as you can see in the footage here. It is a pretty adaptable system. We see it right now configured for just 2 astronauts, but again, it can hold as many as 7. The Falcon 9 rocket, on top of which the Dragon will launch today, stands 229 feet tall. It's fueled by 9 Merlin engines. SpaceX has an interesting technique for building rockets. Basically, they go by the more is more philosophy. Their very first rocket, the Falcon, had a single Merlin engine. The Falcon 9, as the name suggests, has 9 engines. The Falcon Heavy, which is one of the heaviest lift rockets flying today, has 3 clusters of 9 or 27 Merlin engines. Each one of those engines is capable of producing 125,000 pounds of thrust. So for this rocket that'll be launching today, it will be exerting the equivalent of 1,125,000 pounds of thrust overall. It runs on RP1 rocket fuel, which sounds very fancy, but is in fact simply a highly technical way of saying refined kerosene. And it also uses liquid oxygen as the oxidizer. This will be the 84th launch of a Falcon 9 rocket since the very first launch on June 4th, 2010. And one great innovation of the SpaceX design system is that first stage is not expendable. The first stage of the rocket can be reused when it is jettisoned from the rest of the spacecraft after its fuel has been spent. It doesn't simply tumble into the ocean. Instead, it lands on a barge in the ocean to be refurbished and used again. So far, there have been 44 successful landings of a Falcon first stage on an ocean barge, and 31 of those stages have been refurbished and reflown. This is one way of keeping costs down and keeping the production lines moving quickly.
Findus wokgrönsaker. Nu med förbättrade recept och ny design. Smak för livet.
Today's launch is the result of more than 10 years of development of the Commercial Crew Program. The initial idea was to allow NASA simply to purchase services of private companies that would fly crew to and from the International Space Station, freeing the space agency up to focus on its longer-term ambitions to explore deeper space, going to the moon, going then later on to Mars. Here we're seeing when the first commercial crew announcements were made, the crews were introduced. There are two companies that will be flying crews to and from the International Space Station. SpaceX, and unmentioned so far today, but very much in the game, is Boeing, which will be flying its Starliner spacecraft. It has one more uncrewed test sometime in the next 2 or 3 months. And then it has another crewed test sometime early in 2021. The astronauts and SpaceX have been through a lot of stages to get to this point. They successfully flew a pad abort test, which is what we're seeing right here. A test of the launch escape system that pulls the capsule away from a booster that may be flying awry or may be about to explode. The Gemini, old Gemini spacecraft used ejection seats. The Apollo and Mercury spacecraft used something very much like this. What you're seeing here is what would happen if a rocket began to blow up and the SpaceX crew compartment or the Dragon crew compartment would simply separate and then descend into the Atlantic safely for a quick recovery. This was one of their bigger successes, this pad abort test. They similarly flew a launch abort test in which they actually deliberately destroyed a Falcon 9 on the way up in order to test whether the spacecraft could safely get away from a rocket that was in danger of exploding. The company did ace that test as well. The escape system was proven. It showed that the astronauts could indeed be pulled safely away from an exploding vehicle. We see that happening now. That small dot toward the center of your screen is the crew compartment escaping. Now, not all has gone well. This explosion right here was deliberate. That was supposed to simulate a rocket that had gone awry. Not all has gone well. There have been some stumbles. During one of the pad abort tests in 2019, the spacecraft itself exploded on the launch pad, which is a very bad sign. And there was no denying the fact that that was a setback. Here is another setback from 2016 when one of the rockets was being fueled on the launch pad and exploded. We just saw that's a crash of one of the first stages as it was trying to land on a barge, failing to land. There were no injuries in any of these cases, fortunately. And as recently as yesterday in Boca Chica, Texas, where the SpaceX Starship is being designed, the 120-foot tall stainless steel rocket that Elon Musk hopes to use to get to the moon and then later on to Mars, there was a static fire test on the launch pad just yesterday, and there was another explosion. It was a poorly timed accident one day before Elon Musk and SpaceX are set to send astronauts to space. It does not necessarily inspire confidence, but these are two very different spacecraft. Starship, which exploded yesterday, is very much an in-development prototype spacecraft that is nowhere near ready to carry humans. The Falcon 9 is a highly proven vehicle with its 88 launches and its overall highly successful safety rating. So what we're seeing today is the result of multiple successes and a handful of failures, and that basically is how rocket engineering is done.
SpaceX Dragon, loud and clear.
Core, loud and clear. Teacher's comm check complete. Standby with comm checks with MD and LD in the launch configuration.
Dragon, MD on countdown 1. Comm check.
SpaceX Jason, loud and clear.
Copy, loud and clear. Glad to have you guys on board. Stand by for comm check on Dragon aground. Dragon, MD, Dragon aground, comm check.
MD Dragon, loud and clear.
MD, loud and clear. Stand by for comm checks with LD.
Dragon, launch director on countdown 1, comm check.
Good afternoon, Mike. Loud and clear.
I have you the same, and good afternoon. Stand by for my comm check on Dragon ground. Dragon SpaceX on Dragon ground, comm check.
SpaceX Dragon, loud and clear.
I have you the same. Back to core.
Dragon SpaceX, this concludes our launch configuration comm checks. Report when ready for seat rotation per section 2 of 4.100.
Dragon will put that in work.
Copy.
All right, so all those communications checks were done successfully, and you could even see, and it's so cool when we get these views right inside the cabin.
SpaceX Dragon in 2.2, we are ready for seat rotation.
Copy. We will report when initiating.
But you can see Doug Hurley using his right hand. He has the talk button built into the seat itself. So just, again, showing you all of the different systems, how the suit is integrated into the seat, and it's all just one big circle for this whole spacecraft. So really cool to see those comm checks live. Jessica, thank you so much for walking us through some of the really cool updates, the upgrades. Did you have any other cool stuff besides?
Let's see. So I don't know if you guys can see, but we have the Dragon clean room here. And one of the coolest things is it is right on the main floor of our main building. So thousands of employees walk by here all the time and get to see Dragon in its final processing before it goes to the Cape. On Wednesday, the Crew 1 capsule was in here. It looked almost done. It looks a little empty right now, but that's because that capsule went off into our separate test facility for its final propulsion checks. So we do leak checks and things there, and we do that in a separate facility.
Looking at Bob and Doug Hurley inside the spacecraft, let's get to know these two gentlemen a little bit. Bob Behnken is listed as the Joint Operations Commander for the mission. What that means is he's in charge of the delicate choreography of rendezvousing and docking and other exercises as the spacecraft approaches the International Space Station tomorrow. That's a very delicate system. A small 26-foot spacecraft is approaching a great flying space liner the size of a football field, and mating those two vehicles is a complicated process. Bob was first selected to be an astronaut in 2000. He has flown 2 space shuttle missions, STS-123 in March of 2008 and STS-130 in February of 2010. He is a veteran of no fewer than half a dozen spacewalks, 3 on each mission. He was born in St. Anne, Missouri. He has a bachelor's degree in physics and a master's in engineering from no less a place than Caltech, and did serve for a time as a U.S. Air Force flight test engineer. Doug Hurley is the commander of the spacecraft. He too was selected as an astronaut in the incoming class of 2000. He was born in Endicott, New York. He has a bachelor's in civil engineering from Tulane and graduated as into the U.S. Naval Pilot Test School in Maryland. He was a fighter pilot and test pilot in the Marine Corps. He flew on, like Bob, he's been on 2 shuttle flights, STS-127 in 2009, and fittingly, STS-135 in July 11th, the very last shuttle flight after 30 years of shuttle missions. Both of these astronauts get a commander designation, commander for mission operations and commander for the spacecraft itself. It is one more sign of the fact that as collaborative and as collegial a business as flying in space is, these are competitive men and women, and nobody likes to be flying necessarily under the command of someone else. So they both get a little bit of taste of command. And we have some NASA deeper profiles that we can throw to showing you a little bit more about the astronauts talking about themselves and their own experiences.
Hi, I'm Bob Bankin. I am the Joint Operations Mission Commander for NASA's SpaceX Demo 2 mission. So Doug Hurley and I are about to take NASA's SpaceX Demo 2 mission to the International Space Station. During that mission, we'll perform some checkouts, everything from a response to a fire on board to flying close to the International Space Station manually. We'll make sure all those systems are working during the test flight so that the future missions will have them available even if they don't plan to utilize them. We're hopeful that future crews on, Dragon vehicles headed to, NASA space station aren't cursing our names because we accepted some feature that was complicated and hard to train and in the end hard to operate. In the Air Force environment, flight test environment, there's always a balance of managing risk as you go forward to execute a test point and figuring out a way to collect the data and do that in the calm, cool, collected kind of test environment with experienced folks before a pilot ends up someplace a little bit more complicated with a lot less resources. My role for a space mission is very much the same. My career at NASA has kind of spanned a couple of decades at this point. I arrived with the class of 2000, went through the training program, primarily focused on the space shuttle and the International Space Station, learning those systems through the assembly process, which was a little bit like where we were with Dragon in the early days, because space station kept changing and you had to stay up with it. After that, I was eventually assigned to a series of kind of training activities, both as a long-duration crew member and then flip-flopped over and flew a couple of shuttle missions, both on Endeavour. After that, I came back and kind of worked up the leadership chain through station operations, deputy chief, and then chief of the astronaut office. One of my goals was to try to get as many astronauts off to Kazakhstan so they would appreciate the day when we got to launch again from the Florida coast. Probably two things that jump out to me as kind of big wins. One is associated with having a high enough fidelity from a training perspective. Both Doug and I can sit in a capsule, we can put on suits, and we can go through a situation or a scenario where the suits are going to inflate to try to protect us from whatever situation is developing on board the vehicle. I think one of our biggest accomplishments was a tool to be able to plan our own way out of orbit back to Earth, and we had to come up with a way that didn't break the software allocation that was out there, and we just had the big picture of, okay, how does the crew just get home if they end up in this situation? How does the crew get home if they end up in this situation? When they were able to flip that switch and not count how many failures it took to get there, but accept that let's figure out the easiest way to provide that capability, and they got on board with it. That was the aha moment. You don't necessarily have to save the mission with the crew, but you need to save the crew with the crew is kind of the mindset that we've put out there. It's really kind of designed that launch day is kind of relaxed. So we'll get up, have a little bit of exercise probably, or breakfast and then some exercise, be able to do some last minute phone calls. We'll probably have lunch, review, weather briefing of some sort to understand what our weather's going to look like. We'll hear anything associated with the vehicle, kind of technical detail-wise. We'll get a little bit of an early read on that before the formal process of getting the suit on and then heading out to the launch pad. For me, having launched a couple times on vehicles, the second time was definitely different than the first time in terms of relaxation associated with the mission. You're doing that for the first time, you can feel a little bit guilty of, hey, should I study one more thing, or is there one more piece of information I should get? So that's definitely different between where I was on my first flight and where I'm at right now. On a deeply personal level, I'm really excited that my son is going to get a chance to see me launch into space. Being an astronaut has been a little bit of an abstraction thing for him because he's seen me do it in old videos, but he hasn't seen me do it for real. I think it's important for the U.S. to continue to have these exciting things out there from a technical, engineering, science, challenge perspective, because it motivated me to go into this sort of a career, and I know that it motivates other children in. And so I'm excited to bring it back to the Florida coast, or be a part of bringing it back. I'm just one piece of a multi-thousand member team that's going to hopefully pull this off in short order. It's inspiring to me, and I'm just excited to be a part of it.
What's going on in that white room, the portion of the swing arm that connects to the spacecraft that we can see, the sort of accordion-like black structure, that is the white room where the crew technicians, the pad technicians, are helping the astronauts into the spacecraft. What's going on behind that enclosure right now is the closeout. This is the point at which the spacecraft is sealed. While the astronauts have not yet physically left the planet, they have effectively atmospherically left the planet. They are now breathing life support air. They're being sustained by the systems aboard, the environmental control systems aboard the spacecraft. They are now, in some ways, in space. This is the way they will be living for the next 1 to 3 months aboard the International Space Station. They are now, in a sense, integrated with their spacecraft. They are part of the machine. The door is closed. There is no Florida air filling their spacecraft any longer. This is all the life support system of their suits, of their seats, which are integrated into the suits, and of the Dragon 9, or of the Crew Dragon spacecraft itself, keeping the crew alive. They are now very much in the process of leave-taking. checked in on the doings on the capsule. Let's meet our second astronaut aboard, Doug Hurley, the commander of the spacecraft itself.
Hi, my name is Doug Hurley, and I'm the spacecraft commander for the Demo 2 mission to the International Space Station. This mission is the crewed test flight for the SpaceX Crew Dragon. So every portion of the flight, this will be the first time the Crew Dragon has had a crew on board. And so there's a myriad of objectives we want to achieve. Obviously, the first part is to launch the rendezvous and docking phase. And then we'll spend some time on board space station and do some docked activities with the vehicle. And then at some point, 30 to 90 days later, we will undock and do an entry and a landing in the Atlantic off the coast of Florida. It's a story. On STS-127, which was my first flight, I think we scrubbed on the order of 6 times over the course of about a month. It was literally Groundhog Day trying to get into space. And of course, it's your first flight, so you really, really want to go. We just had technical challenges for the first 2 or 3 launch attempts, and then had to scrub for weather a number of times before we finally got to go. That's why you got to go to the pad, you got to get in the vehicle, because you never know when the weather's going to clear. It's not the best of stories, but I think back so fondly on that mission. We worked really hard for 16 days, but it was a great mission once we got airborne. We first got down to Kennedy, we got every checklist out and every responsibility that each one of us had. We kind of almost tabletopped it for the first couple days. And you see that in sports teams. You see the coaches and players that spend that extra time after practice and at night reviewing film and going over films of the other teams. I think that's what you need to do in a space flight, is you need to know what you're going to do almost instinctively, if not completely by heart, and then go from there. And I think it sets you up for success. With the shuttle, you were on your back for almost 4 hours waiting to launch. So part of it was just, let's get this over with and get going. But then when the engine's light, you know you are going, and you know you're going somewhere pretty fast. And you go from, in the case of the shuttle, you go from 3 Gs to 0 Gs instantaneously, and things start floating. And I remember distinctly just thinking, what just happened? Because 8.5 minutes ago I was on Earth and now I'm in space. And obviously with Falcon 9 and Dragon, this will be the first time humans have ridden on the Falcon 9, even though it's flown many, many times. You tend to pull more Gs. The first stage is pretty similar. Like shuttle, we had about a 2.5 minute first stage. The difference is going to be with Falcon 9, the engines, you separate from that part of the rocket with the engines the first stage, and so you get kind of a weightlessness there for, or a lack of acceleration there for a split second or two. So that part of it is going to be distinctly different. We could experience somewhere on the order of 4+ Gs, whereas shuttle, we were limited to just 3 Gs. I think our concentration has mostly been on the profile, the crew vehicle interface, just how the Dragon will work for crews going forward. That's why we're going to do this flight now, is to prove out what we think it will do. Ideally, it will do exactly what we expect it to do. The first simulator where we integrated the Hawthorne mission control team and the Houston mission control team was a huge moment, to be able to just have the entire integrated team that's going to support us getting to and from space station, talking together, working through the challenges. I think that was probably for me the first big highlight, and that wasn't that long ago. It overwhelms you to think about how many people have in some way, shape, or form touched this program and this vehicle to get us to this point. We obviously, in a lot of ways, are the lucky ones that get to fly it, but we certainly not for 1 second take for granted the amount of effort that so many other people had to put into this to make it successful. And we'll do our part to make it successful and to get back here and celebrate with everybody in a few short months. Very excited. Yeah, very excited.
So today is as much about Bob and Doug and the future of the space program as it is a bit of an elegiac look back at the phase we just left behind. And that phase ended with the final flight of Atlantis. Let's take a look at Atlantis and how it got prepared for that final flight that ended the 135 flight space shuttle program. Hatch has now been officially closed. We will get back to that Atlantis footage in a moment. You can see the White Room team sealing the hatch. It is a very painstaking process. This is the doorway that separates the astronauts from the void once they get to space, so you want no mistakes with this. Hatches have a long history in NASA. They have a very dark history with a hatch that would not open during the Apollo 1 fire. And so if there's any part of the spacecraft that has gotten special attention since that tragedy in 1967, it is the hatch, the doorway that separates the astronauts from their internal world to the external world. This crew, this White Room crew, will not leave this spacecraft until they are absolutely assured that the hatch is sealed and closed and that it is crew-worthy and flight-worthy. And it's starting to look as if they are satisfied with these preparations and will momentarily be backing away and allowing that swing arm to move back. Now let's take a look at that look at the final flight of the shuttle Atlantis and how it got ready for that closeout voyage. The final mission for America's space shuttle fleet began with the shuttle Atlantis in this processing hangar. The ship was there for weeks to check and recheck its millions of parts, making sure the very last shuttle was ready to haul 14 tons of food, equipment, and supplies to the International Space Station. Once Atlantis was announced fit to fly, the next step in this final trip was the procedure known as rollover. That began with Atlantis being towed from its processing hangar to the vehicle assembly building, following a path well worn by 134 other shuttle missions over 30 years of flying. 3 photographers documented this process with time-lapse pictures shot over the course of 4 days. In all, 15 cameras captured 120,000 images. Once inside the vehicle assembly building, the country's largest building by volume east of the Mississippi, Atlantis was lifted by a halter crane. It was then attached to its giant solid fuel boosters and to its 15-story liquid fuel tank. When that was completed, the shuttle emerged to begin its 6-hour slow crawl to the launch pad. Shuttle workers gathered by the hundreds to witness the space shuttle's final rollout, and with good and sentimental reason. 355 humans flew over the course of 135 shuttle missions from 1981 through 2011. The shuttle's secret was in some ways its very lack of glamour. It was a reusable workhorse ship that got humans and equipment to and from space, and in so doing helped ensure America's future off the planet. This launch of 2 astronauts aboard a SpaceX rocket, the first such launch from American soil since Atlantis' flight, is the next big step in that future. Once again, we are getting a look at the swing arm that will soon be pulling away from the spacecraft, leaving Bob and Doug there alone at the top of the rocket with their support team finally separated from them. You can see here that there's a bit of a rain squall. It's a little bit hard to make out the rainfall itself, but it's not at all hard to make out the gray skies, so there could be a few problems there. As you can see, we're back in the White Room now, and this hatch is getting still more attention, although it's looking like these touchpads are being used to check off those final milestones, and it looks like this crew is getting ready to leave the White Room at long last and let that swing arm come back. While we're waiting for the swing arm to come back, a big part of the future of the space program obviously does involve Elon Musk, and I had an opportunity to talk to him sometime last year. Let's see a little bit of that conversation we had at the SpaceX headquarters in Hawthorne, California.
I think Apollo 11 landing on the moon was probably the most inspiring thing in history. Arguably the most inspiring thing. This level of inspiration that provided to the people of Earth was incredible. And it certainly inspired me. I kept expecting that we would continue beyond Apollo 11, that we would have a base on the moon, that we would be sending people to Mars. But the United States has been without the ability to send people to low Earth orbit since 2011 when the shuttle retired. We need to advance space beyond what has been done before, and that we need to send people to Mars, expand our horizons, to do more.
In 2002, Elon Musk founded SpaceX.
We have liftoff.
Breaking the stranglehold that governments had as the exclusive providers for access to space.
Second stage ignition confirmed.
When Musk couldn't lease facilities to launch his rockets from the continental United States, he moved a team of engineers to a small atoll in the Marshall Islands. Despite early failures, SpaceX eventually found success. In 2010, it became the first non-governmental organization to launch, orbit, and successfully recover a spacecraft. And in 2011, it was awarded its first NASA contract as part of the Commercial Crew program.
I thought starting SpaceX would be 90% likely to fail. The cost of access to space was just too high. even if we doubled NASA's budget, unless NASA had good options for rocket contractors, they would still not make progress. So I actually just funded the whole company in the beginning myself, not because I thought it would turn out well, but because I thought it would fail.
Elon Musk's sheer brazenness, his willingness to break old molds and make bold promises, has captivated space fans, giving the company and its founders something of the popular following once enjoyed by Steve Jobs and Apple. And it's not just image. The company does things differently, re-landing spent first stages on ocean barges, building its massive stainless steel Starship rocket, adding technological prowess to its popular sizzle.
The holy grail of access to space is a fully reusable orbital rocket. We cannot have a base on the moon. We cannot have a city on Mars. We cannot become a multi-planet species without full and rapid reusability. And we've made significant progress towards reusability with the reuse of the Falcon 9 boost stage. That's somewhere around 2/3 of the cost of launch, maybe 70%. And we've just recently been successful in catching the fairing, the nose cone of the rocket. And that is a crazy exercise with a boat that's basically a giant catcher's mitt. And the boat adjusts course automatically, and the two just, maneuver to touch each other.
While SpaceX is pushing the limits of rocket technology, it has also had some setbacks. A Crew Dragon spacecraft exploded during a test in 2019. The upcoming launch of a crew to the International Space Station is years behind schedule.
Any new development process, especially for something as complicated as a spaceship, that can safely fly crew, the importance focus for NASA is doing it safely, doing it right. You learn many times the most from the failures and the tests that don't go the way that you expect them to. So the incident with the Crew Dragon last year, testing the escape system on the ground, having an anomaly, and then going back and looking through the design, making sure that we fully understood everything that happened and really, upgraded the design to make sure that something like that could never happen again and be as safe as possible from beginning to end. And it really culminated in that successful in-flight abort test earlier this year.
And there you just saw the trunk jettison again.
But the Falcon 9 that will launch this week is now considered a reliable machine with a proven record. That does not say there's no risk. The rocket will use the so-called load and go approach before launch, with the fuel tanks being filled after the astronauts have boarded the spacecraft. This improves rocket performance given the dense, supercooled fuel that's used, but it's never been tried before with astronauts aboard, and there will be some tense moments leading up to the launch.
The NASA team really took, a strong look at all of the pros and cons of all the different ways to do that timing between crew integration and ingress and vehicle loading and launch. And they really came together and determined that this was the right, best approach to go do for this vehicle.
SpaceX represents a big part of NASA's future, but it also has a lyrical link to the past.
One of the sweetest spots in all the world for people who love space is pad 39A.
It's the best pad.
Best pad. I mean, Apollo 11 left from there.
Yeah.
Virtually all of the lunar landing and orbital missions left from there. And now,
I can't believe we get to use this pad.
And that's my question.
An insane honor.
What does that feel like? That is SpaceX's leased pad now.
We're not worthy.
While this launch will be historic, Musk has his eyes on the future too, already building a new rocket dubbed Starship, capable of taking humans to the moon and even Mars. This flight marks an important first step toward those grander journeys to come. We're getting a live shot here of the scene at Cape Canaveral, and if you are not seeing the launch pad clearly, that's because the weather conditions have conspired once again against this launch. Now we are still 2 hours out from launch, close to 2 hours, a minute 58 and 14 seconds. And Florida weather can be fickle stuff. It could clear and cloud up and clear and cloud up again a couple of times in the next 2 hours. But at the moment, these are not conditions in which any prudent flight director would launch a spacecraft. What we're hearing from Times reporters on the ground is the word torrential to describe the downpour. So at the moment, so far there's no launch, there's no countdown hold. There can't be a countdown hold today because there is an instantaneous launch window at 3:22. So the clock will keep running, and the spacecraft, the rocket either will or will not get off the ground at 3:22 p.m. At the moment, if this weather holds, it will not get off the pad. But once again, we rely on the very volatility and fickleness of Florida weather to perhaps clear up for us. In the meantime, that is the very short-term future of space exploration, what's going to happen in the next 2 hours. Let's take a look at something of the longer view, what the future of space exploration is going to look like after this flight does get off the ground at some point in the next, over the course of the next couple of years and decades.
Even as NASA and the rest of the world await this week's launch of 2 astronauts to the International Space Station aboard a SpaceX Falcon 9 rocket, the space agency itself has its eyes trained deeper into space, much deeper. The entire purpose of the Commercial Crew program was not just to open up space travel to the private sector, it was also to allow the agency to devote its human exploration energy to returning astronauts to the surface of the moon and later to Mars.
We're going to Mars, and in order to go to Mars, we have to use the moon as a proving ground. We need to get to Mars. That's our driving ambition as an agency and as humanity. As far as exploration, this has been on the minds of many people for generations and generations.
The new lunar program, named Artemis, after the sister of Apollo, aims to have the first woman and the next man on the surface of the moon no later than 2024. The plan is an ambitious one, but with a lot of work and a few breaks, the goal can be met. Long in development and now nearing completion is the rocket that will be used for the missions. NASA's prosaically named Space Launch System, or SLS, the 21st century's answer to the 20th century's Saturn V. Initial versions of the SLS will stand taller than a 32-story building. Later iterations will top out at 38 stories. Either one will be more than capable of setting crews off on a deep space journey.
The SLS rocket, the biggest rocket that's ever been built in history, taller than the Statue of Liberty. It's on the 5-yard line, and we're going to punch it into the end zone. If we're going to land in 2024, which we're going to do, the key is going to be SLS.
Also nearly ready for flight is the Orion Crew Vehicle, an exceedingly souped-up version of the old Apollo spacecraft, able to carry as many as 6 crew members compared to Apollo's 3. The first flight could take place as soon as 2021.
Welcome inside the Orion trainer. Right now, I'd say crew members are over here 2 or 3 days out of the week doing different tests.
One of the neatest things about the Orion spacecraft in general is that this is designed to take us to Mars. And so this spacecraft is designed to be operated autonomously by the crew. So when we are on our way out to Mars, there's going to be minutes of comm delay back to Houston. And we have to make all the decisions in here. It's really amazing. It's an impressive vehicle.
In order to land on the moon, NASA needs a new lunar lander. And on April 30th, the space agency selected 3 companies, SpaceX, Blue Origin, and Dynetics, to begin the work of developing one. The early blueprints from all of the companies are promising, and the competition will be bracing with only one company emerging as the final builder. NASA's goal for this generation of lunar landings is not to repeat the short visits of the Apollo missions, the so-called flags and footprints model, but rather to go to the moon to stay.
Now, I don't want to give any specific dates. I don't want to make any announcements, but if we're going to land in 2024, we've got to select quickly. The goal is to lead a coalition of nations to have a sustainable presence at the moon with more access to more parts of the moon than ever before. We learned that there's hundreds of millions of tons of water ice at the south pole of the moon. What does that mean? Water ice represents air to breathe, it represents water to drink, it represents rocket fuel. We are going to Mars. The moon is a waypoint. It's the place where we learn how to live and work. We learn how to make it sustainable.
Only by learning how to live off the land in a long-term encampment just a 3-day flight from home can America be sure it's ready to take the next great step, to send astronauts to Mars. After half a century of staying close to home in low Earth orbit, human beings will once again look deeper into space and will follow to the places that cosmic gaze leads them.
Well, as you can see from this shot, the weather has only deteriorated further. There is no word yet from NASA on whether this flight would scrub early if the weather conditions seemed absolutely hopeless, or whether they will continue counting down straight to that 3:22 p.m. mark. One of the determining factors will be the load and go fuel. They have not yet begun fueling this rocket. That's a complicated process. It's entirely possible that if the weather continues to deteriorate, they'll decide it's not worth even going through that, and the launch would get scrubbed early and the crew would emerge early. But the betting here and the betting in Canaveral at the moment is no matter what, we will go right up to that 3:22 p.m. mark, and the spacecraft either will or will not lift off. Whatever happens today on the launch pad, what happened before the crew got to the launch pad is part of a long history of spaceflight traditions. Astronauts are not necessarily superstitious by nature, but they are creatures of habit. The first big moment in any astronaut's day has always been the pre-flight breakfast, typically steak and eggs. That was Neil Armstrong, Buzz Aldrin, and Michael Collins having their pre-flight breakfast pre-Apollo 11. What we saw a moment ago was the traditional tree planting at the Baikonur Cosmodrome in Kazakhstan, where each new astronaut who goes aloft will plant a tree. The plush toy we saw floating in the spacecraft a moment earlier is another tradition. Astronauts will often bring along a toy of some kind, not simply as a comfort object, but so they have something that will float when they reach 0G. Remember, they're strapped into their seats. They can't float out. So when you see the plush toy beginning to fly, you know that you are in orbit. Here we see Bob and Doug continuing with their other tradition, the new tradition of signing the walls of the White Room before they take off. And one of the oldest traditions, and perhaps one of the least dignified of the traditions, is one begun by Yuri Gagarin, the first human being in space. On his way to the launch pad, he realized that he must have consumed a little bit too much coffee on his way to the pad, so he stepped out of the van and opened his spacesuit and relieved himself against the tire of the van, taking him to the launch pad. Ever since then, astronauts and cosmonauts leaving from the Baikonur Cosmodrome will stop on their way to the pad and have a similar self-relieving ceremony. It's not the most dignified, but it is one of the most enduring of spaceflight traditions. I am being told that we have one small error to correct here. Bob and Doug signing the wall of the White Room is not a new tradition. This, in fact, has been going on for decades of flights, including the Space Shuttle and other crews before them. This is simply the continuation of a long-standing tradition, this time, though, in a brand new White Room with a brand new spacecraft. Pad 39A, the launch pad from which the astronauts will leave for space today, if the weather permits, is one of the most historic spots in the history of the space program. Elon Musk, as you saw earlier, sees it almost as hallowed ground, as do a lot of people. It is the launch pad from which virtually all of the Apollo lunar missions flew, as well as all 135 of the shuttle missions. Let's take a look at the history of Pad 39A and how it came to be.
We're go, same tide, we're go. Altitude, velocity, light.
minus 10, 9, 8, 7, 6, 5. All three engines up and burning. 2, 1, 0, and liftoff. The final liftoff of Atlantis on the shoulders of the space shuttle. America will continue the dream.
Roger roll, Atlantis.
Let's take a look back at some of the history that came before today. The Great Apollo program, of course, was the one that took human beings to the moon. There were 11 Apollo launches from Apollo 7 to Apollo 17, and 9 of them went to the lunar surface, or went to at least around the moon and then on to the lunar surface. Some of the great men and women of space history worked in that room. Gene Kranz, Glenn Lunny, Chris Kraft, all of the giants of the space program. The rockets that launched from Pad 39A during the Apollo program were the largest rockets ever built. If you had been able to harness the power of that rocket taking off, it would have been the equivalent of running every river in America through a single hydroelectric turbine at the same moment. That was the kind of energy that was used to get these rockets off the ground and into deep space. The technology used was, of course, primitive by today's standards. This was slide rule technology, this was pencil technology, this was mental math technology, and yet it got these spacecraft to the lunar surface. The touchdown on the moon that was achieved here on Apollo 11 on July 20th, 1969, was the culmination of a promise President Kennedy made 8 years earlier, when he simply declared that we choose to go to the moon. We don't have to go to the moon. We choose to do this because we are a spacefaring people. We are a questing people. We are people who look at what's on one mountain and decide we have to get to the other mountain. We are people who look at one coast of an ocean and decide we have to get to the other side of that ocean in order to explore. It all began with these 7 men, the original Mercury astronauts. 6 of the 7 flew. 1 didn't because of an early heart murmur. What they went through to be qualified was not easy stuff. From the Mercury program, the one-man spacecraft, the very first launch was right here. You see it on a Redstone rocket. It was a little pop-gun suborbital flight. It's a tiny rocket. This spacecraft carrying Alan Shepard did not go into orbit. It went into what was called a suborbital flight. He had about 5 minutes above the atmosphere, about 5 minutes of weightlessness, but that was enough for America to have said it had put men in space, or it had put a man in space. There was a second suborbital flown by Gus Grissom shortly after Al Shepard's flight. The crowds that gathered to watch these launches were a sign of what this meant to the United States. This wasn't just a technological achievement. This was a geopolitical achievement. This was the United States in a bipolar world with the post-war capitalist American system on one end and the communist system on the other, and it was very much seen as a war of two ideologies. This, what we're looking at here, was views of John Glenn, the first American to orbit the Earth on February 20th, 1962. The one-man Mercury program led to the two-man Gemini program. This was the program that allowed astronauts to test the technologies they would need to get to the moon: rendezvous, docking, spacewalks, long-duration space flights. The Gemini 7 crew, Jim Lovell and Frank Borman, spent 2 weeks sealed in a Gemini spacecraft. Right here, what we're looking at is the rendezvous between the Gemini 6 and Gemini 7 spacecraft, the very first time two spacecraft met in orbit. That was considered an almost impossible feat to achieve. Spacewalking in its early iterations was not a safe thing to do. If we are looking at Gene Cernan here, and it's hard to tell, this was could be the Gemini 9 spacewalk, in which Gene Cernan labeled the spacewalk from hell. He overheated. He could not see in his spacesuit. His helmet visor clouded up. But it was one way of learning what spacewalking involved, and that it wasn't simply the happy drift that people thought it was. Going forward, of course, beginning in 1981, was the shuttle program. This was the point at which the U.S. decided that we were going to make a long-term commitment to low Earth orbit, which sounded less swashbuckling than the space shuttle or than the Apollo programs, but this was our chance to live in space. This was, the space shuttle was equal parts elegant and wonderfully simple. It was a space truck. It ran, as it said, shuttle runs to and from Earth orbit to bring crews up, to bring hardware up. It launched some of the greatest spacecraft in history. The Galileo probe that orbited Jupiter left from the body of a space shuttle. The Hubble Space Telescope left from the body of a space shuttle. 135 such missions made spaceflight routine. Since the grounding of the space shuttle, we have been a nation that has flown to space with the aid of the Russians aboard the Russian Soyuz spacecraft. The Soyuz has been flying since 1966. It's sort of the Volkswagen Beetle of the space program. It's tough, it's reliable, it's all but indestructible. It is a speedy cosmic sports car, and it's a heck of a machine going up and a heck of a ride coming down. Scott Kelly, who spent a year in space, said that landing in a Soyuz spacecraft is a little bit like going over Niagara Falls in a barrel that's on fire. And yet, here we see Christina Koch coming back from space after having spent nearly a year in space. What we are looking at here appears to be an early iteration of the constellation, the Ares 5. This is a simulation of the what was going to be America's return to the moon program. It was begun in 2004 by the George W. Bush administration, and the goal was to have human boots back on the moon as early as 2015. It was going to consist of 2 boosters, one that was a relatively small booster, the Ares 1, to take astronauts to space, and another, the Ares 5, which would take which would take cargo, rather. This was a launch of the Ares 1, the very first iteration of the very first of the constellation programs. And here again are simulations of what the lunar vehicle would have been. The Constellation program fell victim, unfortunately, to what often happens in Washington, which is that as administrations change, so too do goals. The Constellation program had gotten rather far along when the Bush administration transitioned to the Obama administration, and the Obama administration then decided to focus less on a return to the moon and more to the commercial crew program with the commercial sector, the Boeing Starliner and the SpaceX Dragon, taking over the work of getting astronauts to and from low Earth orbit so that the space agency, the space program, so that NASA could focus on deep space exploration. And this is where we stand now with the commercial crew program taking care of low Earth orbit and NASA looking forward to returning to the moon with both the Artemis program and the new lunar lander being developed for the Artemis program. 3 companies have now been chosen to build that lunar lander. Blue Origin, which is the company owned by Amazon founder Jeff Bezos, SpaceX, and Dianetics, and all 3 of them are working on building a lunar lander. Meantime, what we're looking at here is the new Shepard rocket that Blue Origin hopes to use to send paying customers into suborbital space, very much like Alan Shepard's very first flight into space. Here we're seeing the Virgin Galactic spacecraft. Similarly, Sir Richard Branson's Virgin Galactic company hopes to launch paying customers on suborbital flights that will give them about 5 minutes of weightlessness above the atmosphere. Ultimately, Elon Musk, in what the images we're seeing here, hopes to launch his 150-foot tall stainless steel Starship rocket on the surface of the moon. This looks improbable, but NASA believes enough in this that this is one of SpaceX is one of the companies that's gotten a contract to help develop a lunar lander. This is Musk's next great enterprise, and Starship is where he hopes to make his mark, landing both on the surface of the moon and ultimately on Mars. We're back now to a live picture of the pad, and it looks like things may have cleared up a little bit. We will see what NASA has to tell us about where the weather stands, but the sky looks a bit bluer, the rain looks a bit subdued, and there is still a chance that we could be getting off the ground today at 3:22 p.m. We are, like the rest of the world watching this this impending liftoff today, waiting for what NASA reports will be a weather update. Weather will be the final determinant. As we can see from this angle, it does appear that the skies are clearing. Now, those are some pretty formidable clouds through which the spacecraft would have to launch, but those are some pretty promising blue patches among the clouds. And the better news is the sky appears, the air appears generally clearer, generally less cloudy, less foggy, and generally less rainy. So we are standing by for a weather update from NASA, which we are told will be coming momentarily.
So we are here with Terry Virts, the veteran of 2 space flights, 2 weeks aboard one space shuttle mission helping to build the International Space Station, and then 200 days aboard the space station involving 3 spacewalks, 1 stint as commander of the station, a trip you made by Soyuz, the Russian Soyuz rocket. So you're a veteran of 2 very different kind of spacecraft. The space shuttle, which is just a big bruiser of a machine, and sort of a sports car like the Soyuz. What do you think it would be like to fly the Crew Dragon?
Well, I think it's going to be a lot more like the Soyuz. It's roughly the same size. I noticed when I flew on the space shuttle, it was like a muscle car. It was rumbling and lots of noise, and it kind of slowly takes its time getting into space. It's similar to a Saturn V in terms of weight and thrust, whereas the Soyuz was bam, and you're just up and gone. Of course, it was a nuclear ICBM, a Soviet ICBM, So they didn't want those things to sit around and look pretty. They wanted them to get going quickly.
Right.
So the Falcon is going to be a lot more like the Soyuz.
All credit to them if this launch goes off as we hope it will. But they are several years behind schedule, and the U.S. has been 9 years now without the ability to get astronauts to space on our own spacecraft. We're used to thinking of going to low Earth orbit as fairly routine. Why has it taken so long? Why is it so hard to get spacecraft into orbit?
Well, the easy answer is space is hard and it takes time, and you have to, work on all the technical things. But the reality is, between John Glenn's or Alan Shepard's first flight and Neil and Buzz on the moon, that was 8.5 years. And people, there were no cell phones to help do email, and we didn't have any history. So we were quicker in the 60s than we are today. And this is SpaceX, which is probably one of the fastest rocket companies ever. I mean, they get stuff done quickly.
Right.
Part of the problem happened where Congress just underfunded the program, which takes some of the air out of this is a privately funded thing, because it was really a government-funded project. And when the government didn't fund it by the full amount, that really slowed it down. Part of it is, there are problems that happened, and there's been several, serious technical problems along the way. But when I was in space, the SpaceX cargo capsule showed up a couple times and brought my underwear and food and supplies. And that program happened really, really quickly. It was basically, I think, 2008 when the cargo contract was really going. And by 2012, they were delivering stuff to the space station. So SpaceX has shown it can get stuff done much more quickly than the old government model. But it's still not a perfect system, and it's still taking us longer in the 2010s than it did in the 1960s.
There's another competitor in this race, of course, Boeing, and Boeing's spacecraft is its CST-100 Starliner, which also will be carrying astronauts to and from the International Space Station. Now, they had a bit of a setback on their last uncrewed mission. They weren't quite able to reach the International Space Station. What do you think about Boeing's chances for getting their own crews up there, and how quickly do you think they'll be able to be flying?
Well, I think Boeing is going to do this also. It's going to take them, they're many months away. This is not going to happen next month for Boeing. It's going to take some time before they do it. They had software problems. And when I was a test pilot, I mostly worked on software programs, and I would always tease the engineers, it's only software, guys. Come on, you should be able to get this done. And the reality is software is often the hardest, longest, most complicated, part of any aerospace program. But I'll ask you this question, Jeff. Do you want to check your MySpace account later on today? The reality is, MySpace was the first to market, but now everybody does Facebook, right? So just the fact that you're the first to market is sometimes good, and sometimes it's irrelevant. So Boeing is definitely a player in this market, if you will. The ISS program is a pretty small market. It's only 1 or 2 launches a year for each company. It's really not a big program. So the real marketplace is going to be if we ever get to a place where there's private space stations like the Bigelow space station, or if we ever start legitimately manufacturing in space, then companies like SpaceX and Boeing, and maybe others eventually, Sierra Nevada or who knows, then they'll be launching 4, 5, 10 capsules a year, and not just 1 a year, and then it becomes interesting. So the government is kind of seeding that market, but hopefully it will eventually grow into something bigger.
And if it grows into something bigger, if we do have private space stations in orbit being serviced by private spacecraft, will they be vacation? Will they be academic? Will they be industrial? Will they be all of the above?
I think the space station has a corner on the academic market. It's a government subsidized thing. That's the place for universities or companies to do research. The space station is the place for science projects, but it's not a place for manufacturing. So if we ever figure out how to do 3D printing of human organs, or make microelectronics and mass scale that you can make them better in weightlessness than you can on Earth, if any of those technologies actually hit, then that's going to have to go to the Bigelow or another private space. So that's one of the markets, is manufacturing. And I think the tourism is also a very interesting idea. There's several, space tourist companies, if you will. Virgin and Blue Origin are probably going to fly tourists first, maybe this year, maybe next year, but those are just suborbital. They go up and come down 5 minutes later.
That's right.
To have orbital space tourism would be amazing, but that's going to require a place like the ISS that's not exactly set up for tourists. It's a government thing. So I think that would be a really interesting marketplace. Of course, it's going to be probably more expensive than a retired astronaut or a journalist would be able to afford.
Yeah, I have a feeling I'll just be looking at someone else's vacation photos.
They're family movies.
Exactly. Elon Musk is a character. I think even Musk himself would admit that he's a bit of a character. And there's been some friction between him and NASA Administrator Jim Bridenstine in the last year or so. Are you troubled by that, or do you just see it as sort of the rough and tumble of the space business?
I'm not troubled. I thought you were going to say there's been some friction between him and everyone.
A little of that.
This is the world that we live in. I'm a lot more troubled or excited by a rocket that works or doesn't work than I am about some tweets going off. Elon has admitted that he's the kind of the king of self-inflicted wounds. If I was a shareholder, I might want my CEO to be more focused on shareholder value and not on Twitter. But that's between him and his shareholders. So the things that concern me as an astronaut, if I were flying, and I'm not, I'm retired, I don't work at NASA, I'm done. Is the rocket going to work? Is the escape engine going to work? Will the parachutes work? Will the rendezvous system work? Is the software are the computers going to work? All that's the stuff that really would concern me. And that's where I think having some transparency and making sure that you're just being open and honest with the public is more important. Some of this other stuff is just showmanship, I think.
Right. Now, before we went live here, you and I were talking a little bit about the difference between flying, say, a Soyuz and flying the new SpaceX Crew Dragon. And certainly no slur on Bob Behnken or Doug Hurley, the astronauts who will be aboard the Crew Dragon. But you said that there is a bit less flying going on with this spacecraft than there is when you're at the stick of a Soyuz or a space shuttle. Tell me a bit about that. How come?
Right. So actually, the details of it are proprietary, and I've never worked at SpaceX, or that wasn't my job back when I was at NASA. So I don't know all the details, but from what I understand, there's basically no flying involved. Everything is automated from the launch to on-orbit maneuvering. The docking is automated. During entry, there's nothing for the crew to do. The capsule does everything. There's not, from what I understand, there's not even like a control stick that you normally have to fly an airplane or a spaceship. They are going to do some manual maneuvering during docking just to prove that the system works, because this is a test flight. So, but it's like it's a touchpad. So they're going to have a screen, and they'll be, roll left, and then the shuttle will roll left, and then pitch up, and the capsule will pitch up. Flying on the space shuttle, was designed in the 70s. It was the best flying machine of all time. It was, and you could fly it, during launch. I did fly it in orbit. I flew, rendezvous, and I flew around the space station with the control stick, and back in the atmosphere, I flew it with the control stick, and like an airplane. So the shuttle, from a test pilot's point of view, there will never be anything as cool as the space shuttle, because you could really fly the thing. But this is a new era. It's the 2020s. And, You know, we're going to have self-driving cars. I think by the end of the century, you know, our grandkids are going to think back and, hey, Grandpa, what was it like to have a car that you had to buy? You know, this is just the way of things. The goal of this is not to fly it. The goal of this is to take people from Earth to the space station and back. It's just a logistical cog in the space station program. As you mentioned, we've been doing this since John Glenn and Yuri Gagarin. In the early 60s, and this is just a more modern version of that. And this is not the goal. Like I said, we got to get people into space. The goal is what they do after they get to space. That's the interesting part of it. So this is kind of it's the rental car at the airport. It's not your vacation destination.
We're talking about 2024 to have boots on the moon, the first woman and the next man. In candor, are you sanguine about that? Do you think we can make that date?
Well, the commercial crew program, if you will, was really born in 2009 when the Obama administration took over, and Charlie and Laurie Garver kind of ran the space agency. They announced Constellation was canceled the week I launched in space in 2010, and here it is 2020. So that's a decade. Yeah. And we still haven't sent people just to Earth orbit in a capsule. Right. And we're going to be on the moon in 4 years. So I just, as a realistic person, that doesn't seem realistic at all. However, in the 60s, we did do that, right? We were able to make it happen. Yeah. But it's not, you know, it's not the 1960s NASA today. So that's going to be something that's going to be very difficult. I think we also need to say, you know, why are we doing that? And I think if it's part of a strategic plan to use the moon as a testing ground to get to Mars, if it were part of a truly strategic plan, then you do the things you need to do to, you know, fulfill that strategic plan, rather than just say, here's a random thing and we have to do it. The other thing is the debt that we're racking up right now, Jeff, is staggering, and it's just changed the course of, you know, the next decade or two, what's happening in 2020. So we're going to have to be very strategic about money that we spend. Right. So I think there's just a new reality that we're in.
Right. And that brings us to the always somewhat touchy area of politics. For our viewers, you mentioned Constellation, which was, of course, the lunar exploration program that was established under the George W. Bush administration, and there was a fair amount of progress, a good amount of progress that was made on that. And then it was canceled under the Obama administration, and the Obama administration had a number of its own policies, including the asteroid redirect mission, moving an asteroid closer to Earth, and then studying it. Now, under the Trump administration, we are back on a lunar course. Do you worry that whatever happens in November, the Trump administration will either end then or it will end in 4 years? That's not much time either way. Right. Do you worry that we will once again shift course and start all over and have a new program that will have to be begun from scratch?
Right. One of the things, while I was an astronaut, you fly and then you go visit Congress and the White House. I've been there several times. And now that I'm retired from being an astronaut, I've spoken at the National Space Council to the Vice President. And I talk to folks often. And the one message I always have for them is, it's not about the rocket science, it's about the political science. And unless you, and the way to run a space program is not change what the last guy did because you don't like him. And that's what we've been doing now for more than a decade. So the political system's broken in so many ways. NASA is just 1% of a really messed up political system, right? Right. So I think the hope for me is that private companies can put together a plan. I think if we can figure out how to do private-public partnerships right, And I know Mr. Breinstein's been really focused on that, and that I know this is a priority for him. But let Blue Origin, just let them go. Let SpaceX go. Let Sierra Nevada go. Let these other companies, and Boeing and Lockheed, they can do things privately, and when they are allowed to do that, they can be more efficient too. So I think if we can figure out how to let these companies do things, and let the government do things like make treaties, bring in Russia, bring in Europe, bring in other countries to work. Eventually, we're going to need nuclear power. Government's going to have to do that. SpaceX is not going to make a nuclear reactor. So I think if we figure out how to do that right, that can help us moderate, attenuate some of this political ups and downs that we have. Because otherwise, it's never going to happen. And the SLS, that rocket really was born in 2005 when George W. gave his vision for space exploration.
Right.
It was going to use cheaper engines. It was going to be, they weren't going to have a capsule on it. It was going to just be the cargo ship. It was part of an integrated plan.
Yeah.
And then that got canceled and changed. And that was 15 years ago. And it's still years and years away from launching people. So.
Yeah, I remember at the time in 2005 when it was announced, the target date was footprints on the moon, maybe as early as 2015. Well, that's 5 years ago. We're still not back in low Earth orbit.
I think Air and Space Magazine did an article. I was one of the next astronauts on the moon. I was one of the guys they featured, along with some of the, I think Megan Bankin and Karen Nyberg, actually.
Yeah.
Bob's wives, I think they were in there too.
Would you suit back up to go to the moon?
You know what? To go to the moon, yes, of course. The one, I had this do I stay or leave calculus that I went through at NASA, and I had kind of done everything there was to do. I was the station commander and shuttle pilot and blah, blah, blah. So there was other things I want to do in life. But I always said if I could go make a film in space, that's something I would like to do.
Yeah, yeah. Well, now there's talk of that happening. There's talk of Tom Cruise shooting aboard the International Space Station. So. Right. So maybe you can co-star with Tom Cruise. Well, is there anything else that I have neglected to ask you that you think our viewers would want to know about what the stakes are this week and what it feels like to be Bob Behnken and Doug Hurley climbing into this machine?
I can say that when I flew on both of my flights, it was really exciting. The very first time I suited up for my first flight, it ended up being canceled for weather, and we launched again the next day. And that first time it was like I was out of my element. I was nervous. I was in this big suit. Even though I practiced it, it really was kind of, okay, this is something different. But the second night I went out, I felt a lot more comfortable, and it was almost like I'd already done it, even though I hadn't. So the nerves were better that second time. Bob and Doug aren't going to have that because they've both flown, they've flown several shuttle missions. It's been a decade since they've flown.
Yeah.
But I don't think that's going to be a problem. Also, on my first flight, my first 2 days were miserable. I had the worst headache of my life. I was taking ibuprofen, and it was on my third morning. I remember Steve Robinson said, "Hey, how are you feeling?" And I was like, "God, I feel like crap." And then literally a few minutes later, it was like a light switch, and all of a sudden I was fine. Yeah. And then I was fine the rest of the time. On my second flight, even though it was 4 or 5 years later, I felt fine. Like your body just needs a couple days to figure out what the heck just happened.
Right.
Your inner ear fluids and everything.
Yeah.
For some reason, your brain figures it out. And at least for my case, and I've heard others say the same thing, I felt okay. And so my guess is that they're going to feel okay because this isn't their first space flight.
Right. You told me something once, speaking about spacewalking, about what it's like to step out into that void, and every one of your rational brain cells tells you that you cannot fall. You are in orbit. Physics is keeping you up there.
Right.
But look down, and there's nothing below you but a planet 250 miles below you. Describe that experience a little bit.
So on my first spacewalk, when I went outside, it was nighttime on Earth, but the station was up in the sunlight.
Right.
So that actually helped because when it's daytime on Earth, you see the Earth going by, and several of my colleagues had said, "Man, I got vertigo when I went outside." I I didn't think I would, but I wasn't sure because it was my first time. So I went outside. The very first thing I did, there's a waist tether on the side. I pulled it off. I clipped it on a handrail, and I let go. So I was in outer space, floating above Earth, and I just looked down. I looked around. I went, okay, I'm fine. I just wanted to make my brain behave and make sure it was okay.
Yeah.
Personally, I don't like ledges. I hate standing on the edge of a building or something like that. I hate it. And so whenever I'm on a bridge or on a building, I always walk right over to the edge.
Yeah.
Just to force myself to do it because I don't like it. It's almost like I'm just having to beat my brain into submission, and but I still feel I'm like, ugh.
Yeah.
If I'm in a fighter jet flying upside down, I'm fine because I'm strapped in and it's okay. If I'm standing on a ledge, so that was it. That was my way to try and get my brain, like as you so well described it. Every rational brain cell knows you're okay, but it's the emotional brain cells that don't necessarily know that.
You've got a book coming out soon. Tell me a little bit about that.
I do. Well, we both do. But my next book is going to be called How to Astronaut. It's a collection of 51 short essays. The goal is to laugh and to say, wow. Those are the two things that I hope to get by it. I wrote it myself, no ghostwriters. And it's some basic stuff like, how do you learn how to be a doctor? How do you learn how to launch in a space shuttle? It's some crazy stuff like, what do you do if the engines don't light and you're stuck in orbit? Or what do you do with a dead body if your crewmate dies? Or are there aliens? And so it's some stuff that is expected, some stuff that's not expected. You can pick it up and read it. Any chapter, it doesn't have to go in order. It's just a collection of essays, and I think it's going to be pretty fun. It's a good beach read when you go to the beach this summer. Coming out September 15th, so they've started doing pre-sales now.
Terrific. Congratulations on that. And thank you very much for spending time with us, Terry Virts, veteran of 2 space flights and former commander of the ISS. Not bad.
Thanks, Jeff. Looking forward to this launch.
Thank you. So am I. And welcome back. For those of you who are just joining us, we are now T-minus 1 hour, 1 minute, and 40 seconds from launch. We are awaiting a weather update from NASA. At the moment, the skies look clear. It appears that the torrential downpours of earlier in the day have ended. The winds do not seem too challenging. So the hope is that we will see that swing arm, the access arm that connects the spacecraft to the gantry, move back soon. There will be at 2:25 in about 5 minutes an Air Force One flyover carrying the President and the First Lady, who will be here to watch the launch and later to make some comments in the vehicle assembly building. The Vice President, who was here yesterday, will not be here, or who was here on Wednesday rather, during the first attempted launch, will not be here today. President Trump will not be the first president to watch a launch live, though he will be one of the first. The only other two were President Nixon, who in November of 1969 watched the Apollo 12 crew launch for the second lunar landing, and much later in October of 1998, President Clinton watched John Glenn on his great return to flight. Here in this shot, we see former President Lyndon Johnson and then Vice President Spiro Agnew at the launch of Apollo 11, but President Nixon, who had been in office for just 6 months at that point, did not attend. He did, as you can see, attend the return of the crew. He was on board the USS Hornet when they were recovered. This, you can see here, President Clinton and First Lady Hillary Clinton watching the launch of Senator Glenn. And here is President Michelle Obama visiting the space station or the Space Center
earlier in the decade. Once again, here is rollout footage. And for those folks who are joining us on YouTube, here we have the presidential flyover, Air Force One bringing the president and the First Lady to the launch facility where they will watch the takeoff that we hope will be coming now in 58 minutes and 52 seconds. For those of you who are joining us on YouTube, there is a comment section in YouTube. We would love to answer any questions, respond to any comments you have. One question that came in from a viewer earlier was how long it will take the astronauts to get to space. And the remarkable thing is this is just a 12-minute ride from the surface of the Earth in a 1G gravity sphere, gravity well, to low Earth orbit in 0G. The astronauts, Bob Behnken and Doug Hurley, will make that transition in just 12 minutes. Now, it will take them 19 more hours inside their spacecraft to catch up with the International Space Station, but only 12 minutes to go from Earth to orbit. It is a hot, fast sprint. Once those engines light, these guys are truly hauling the mail. The astronauts' day is a complicated one. We're looking at some scenes here from Wednesday when the launch was scrubbed. This is Bob Behnken, and that's Doug Hurley, and Bob Behnken being suited up in the same suit-up room that was used in the Apollo program, and some of that equipment, some of that off-green equipment on the back wall is the original hardware that was used back then. It's still being used now. It's relatively simple stuff. You can see those old analog meters. Once the crew is suited up, they are made ready to get to the launch pad. They are carrying, as you can see, the umbilicals here. They have air conditioning systems. Since these spacesuits are essentially self-contained spacecraft, they need their own kind of coolant system. We see here the two astronauts speaking to both Elon Musk and on the right, and Jim Bridenstine, the administrator of NASA, on the left. These are the two men who are most responsible for what will happen today. The walkout happened on Wednesday very nominally. This is how it's supposed to look. A lot of waves and blown kisses to friends and family. The backup crew is there with them as well. Typically, backup crews are there until the very last moment, always ready to be available in the event an astronaut would not fly. Here they were climbing into the Gull Wing Tesla, getting ready to go out to the launch pad, saying goodbye to their wives and children. Again, you notice they are standing behind a yellow line, and it's only pantomime hugging going on here. This was the case even before the COVID pandemic. Astronauts have always been put into some kind of pre-flight quarantine to keep them from carrying any pathogens up to the International Space Station, but particularly in the age of COVID, we do not want this new virus making it off the ground and into space. One correction from earlier, that was not today's Air Force One flyover that we showed you. That was footage from Wednesday. Apparently there will not be a flyover today. The President and the First Lady are coming in via Air Force One, but there won't be the same kind of flyover for the press and the spectators. The crew plugged in their environmental control systems from their spacesuits into a similar environmental system in the Tesla on the way out to the launch pad. We are told they listened to a mixtape on the way out that included the Blues Brothers, AC/DC, and the Star Spangled Banner to get them in the mood for this most American of missions, the first time American astronauts will be launching aboard an American rocket from American soil since July of 2011, when the shuttle Atlantis made the final trip to the into orbit to service the International Space Station. We are now at T-minus 51 minutes and 55 seconds, and we just got word from NASA that the escape system, the rockets that would pull the spacecraft away from an exploding Falcon 9 in the event of an emergency, are being armed, which is a good sign. That means they are preparing for launch. Much more important, the fueling that will take place about 30 minutes before launch, loading on those 76,000 gallons of liquid oxygen and kerosene into the spacecraft, or into the rocket rather, are also on track to proceed on time. So these are both good signs. Again, we are still close to an hour away. Weather can do a lot of funky things in an hour, and we have no way of knowing with any certainty if this mission will get off on time. But those are two very promising signs that they are going ahead with these two very important milestones, arming the escape system and fueling the rocket in anticipation for launch.
White room, which was the last place we saw them standing up before they climbed inside Dragon. And again, a wider shot there of Launch Complex 39A, where we are inside of an hour from liftoff, and I think we're just a couple minutes away from the pull we're going to hear before they start propellant load. Again, a 2-stage rocket there. Gosh, you guys, the weather looks not that bad. I mean, obviously that is not an official forecast, but it doesn't look quite as bad as it did Wednesday. We've got a little bit better odds. So there's the countdown clock. We're going to pause to listen to that comm.
We've gotten a number of questions from viewers about how we keep space coronavirus free. An important lesson was learned in 1968 when the Apollo 7 astronauts all caught head colds on a miserable 11-day mission. COVID is much more serious than a head cold, but protocols that were put in place back then are still in place today to keep any spacecraft disease-free. So let's take a look at how space is being kept COVID-free in this time of pandemic.
There's no better way to escape the coronavirus that's stalking the world than to leave the world altogether. Astronauts Bob Behnken and Doug Hurley will be doing that when they take off aboard a Crew Dragon spacecraft for a flight to the International Space Station. But before leaving, they had to ensure they weren't carrying the virus aloft with them. That meant quarantine, or crew health stabilization, as NASA calls it. For decades, NASA astronauts have quarantined before traveling to space, but that's not the way it always was. In the early days of the Mercury and Gemini programs, the idea of isolating the 1- and 2-man crews before flight was considered ill-advised and even impossible. There was just too much work for them to do to indulge any worries about colds and flus. All of that changed after the flight of Apollo 7, when astronauts Wally Schirra, Don Isley, and Walt Cunningham came down with severe head colds early in what turned out to be a miserable 11 days in space. By the time of the Apollo 8 lunar orbit mission, a 21-day pre-flight quarantine protocol was put into place. The crew was scheduled to launch December 21st, 1968, which should have meant quarantining from December 1st on. But President Lyndon Johnson had other ideas, and on the evening of December 9th, he held a dinner at the White House honoring the crew and the rest of NASA. That meant a late start on quarantining, with the 21 days cut to just 12. For the first 3 of the 6 successful lunar landing missions, Apollos 11, 12, and 14, there was not only a pre-flight quarantine, but 3 more weeks of isolation afterwards to ensure that the astronauts were not carrying any lunar pathogens back with them. By the time of Apollos 15, 16, and 17, NASA, reassured that lunar pathogens didn't exist in the first place, lifted the post-flight part of the lockdown. The 3 crews that flew to Skylab, America's first space station in the 1970s, had a longer 3-week pre-flight quarantine period in keeping with the longer stretch they'd be spending in space. The shuttle crews got a break. Just a week of pre-flight quarantine, 3 days spent at crew quarters at the Johnson Space Center in Houston,
and 4 spent in similar accommodations at the Kennedy Space Center in Florida. With the coronavirus at large, Benkin and Hurley were assigned a longer 12-day quarantine period, 5 days in home isolation and 7 at Cape Canaveral. They and the few technicians and medical personnel who have come into contact with them during quarantine were also required to have 2 negative coronavirus tests in order for the crew to be certified fit to fly. Where humans go, at least some germs hitch a ride with us. The key is to ensure as few as possible accompany us to space. And here we are at last seeing that swing arm moving away from the spacecraft. Bob Behnken and Doug Hurley are now very much on their own, with the exception, of course, of the tens of millions of people in the world watching their mission and the hundreds and even thousands of controllers on the ground around the country and around the world who are helping to keep them safe. So in that sense, they are not at all alone, but physically they are there without their support team, without their White Room crew. It's just 2 men in that spacecraft getting ready to take off. We are now at T-minus 39 minutes and just 7 seconds. We are awaiting a shot of the presidential motorcade. The president and the first lady departed the White House at 12:10 p.m. today and arrived at the shuttle landing facility at 2:25, just 20 minutes ago. So they will be moving over to the operational support building next, where they will be, from which they'll be viewing the flight. Meantime, the skies continue to clear. The weather continues to look as if it is going to cooperate, and it only needs to cooperate for another 38 minutes and 25 seconds, after which Florida is free to do what Florida does, which is for the weather to become turbulent again. We just need these skies, these conditions to hold for now under 40 minutes. And as we see this rocket and this spacecraft on the launch pad, it's worth mentioning again just how extraordinarily well designed and engineered the machines are. The Falcon 9 rocket itself stands 229 feet tall. It's fueled by 9 Merlin engines using RP-1 rocket fuel, which sounds pretty glamorous, except RP-1 rocket fuel is pretty much just high-intensity kerosene, and that's mixed with liquid oxygen as the oxidizer. Each of the 9 engines produces 125,000 pounds of thrust for an overall 1.125 million pounds. The Falcon 9 first flew on June 4th, 2010. It's been an operational vehicle for a decade now. This will be the 84th launch of a Falcon 9, and significantly one of the things that distinguishes the Falcon 9 from virtually every other, or actually every other expendable rocket that does fly, is that when its first stage is spent, it's not simply dumped in the ocean as a use once and throw away piece of hardware. Instead, the first stage lands on a barge near the Space Center, and there have been so far 44 successful such landings, and 31 of these first stages have been successfully refurbished and reflown. The Dragon spacecraft itself that the astronauts will be flying in is sort of, think of it as the Apollo-era spacecraft on steroids. It's about as wide as the Apollo was, about 13 feet wide, but it's twice the height at 26.7 feet tall. It has significantly more habitable space than the Apollo did, which carried 3 men and something close to moderate comfort and moderate discomfort. This spacecraft is capable of carrying a crew of up to 7 men and women, although there will only be 2, obviously, this time. There are 16 thrusters arrayed around the spacecraft that allow it to perform the delicate choreographic maneuvers it will need to perform in order to dock with the International Space Station, to reorient itself for re-entry, and to do all of the other maneuvering that is necessary during space flight. There have been 22 launches of a Dragon spacecraft, the cargo version of a Dragon so far, and 21 visits to the International Space Station. It is almost all automatic. Obviously, the astronauts are highly trained in order to take over at any point. The instrument panels are all touch screens, very different from the mechanical toggle switches and dials of the old Apollo era. And the crew is perfectly capable, eminently capable of flying the spacecraft on their own if any of the automatic systems fail to work. When they come home, they will land under the power of 2 small drogue parachutes and 4 main chutes. The Dragon, like the first stage of the Falcon rocket, is reusable. This is all in an attempt to ensure that that prices can be kept down and assembly can be complete. And what we just saw here, what we're seeing here, is a test of the escape system that was conducted last year to prove that the Dragon could successfully separate from a rocket that was threatening to explode. So we're working with 2 reliable machines today, 2 machines that have a very proven track record. The one thing they have not done until today, we hope, is carry human beings, and we are inside of 33 minutes now until the point at which that important milestone may at last be crossed. The presidential motorcade is now approaching. We should be able to see that soon. The weather looks calm, as you can see from the inset image on the left. The sky is rather blue, and as you can see in that top right corner, that windsock, that orange windsock at the top of a light pole does not seem to be getting pushed by much wind at all. So we have what appear from these decidedly non-scientific measures here, clear skies and low winds, and this is what you would want to see. The president and the motorcade should be arriving momentarily around this bend that we can see in the image here. The president will view the launch. He will arrive just about 8 minutes before launch time at 3:25 for the, or rather at 3:17 for the 3:22 launch, and will then go to the vehicle assembly building at 5 p.m. to address NASA workers and a number of the people responsible for what we hope will be today's launch. You see the motorcade arriving now. This is part of a long tradition of presidents making sure that they are present either at launches or at recoveries in order. There's politics involved, certainly. There is nothing wrong with doing the touchdown dance when something momentous like this happens under your administration. But also all presidents, going back to President Eisenhower, who was the president who founded NASA, have known that space travel is as much about technology and exploration as it is about politics and funding. And it's important for presidents, for any administration, to be there, to wave the flag, to show the colors, to make it clear that they are behind this enterprise. Traveling in space is expensive. Traveling in space is dangerous. And it's important for presidents to show that they are in support of this program and that they are backing it. And President Trump is there very much today to enjoy what looks like it could be a successful launch which is now just 29 minutes and 15 seconds away. And it appears as if fueling of the rocket has now begun. You can see some of that condensation from the liquid oxygen that is part of the fuel mix subliming out of the spacecraft. This is the first crewed launch that it uses what is known as the load and go process. Typically, the rocket is fully fueled, and only then does the crew climb aboard. That was considered a safer way to go. But with the design of the Falcon 9 rocket, the supercooled and highly condensed fuel cannot sit in the tanks too terribly long before it begins to lose its efficiency, at least its efficiency within the system as it's designed for the Falcon 9. And for that reason, the fuel is kept in the tanks for as short a time as possible. Consider this a little bit like when horses load into the gate in any horse race. Horses will not tolerate a gate very long, which means once they're there, the race is about to begin. Fuel in this rocket will not tolerate lying idle in a tank terribly long. That doesn't mean it's going to blow up. It just means it's going to lose some of its energy potential. And for that reason, once the fuel is in the rocket, it is going to go. The astronauts boarded so long ago, hours ago now, which is very much a part of the process. It takes a great deal of last-minute work to get environmental systems up, to get crew checklists gone through, to drill what the final maneuvers are going to be. Crews are very accustomed to spending time flat on their backs in their spacecraft. As Doug Hurley said in the earlier piece we saw in NASA, for his shuttle flights, he was accustomed to spending as much as 4 hours on his back. One thing about fueling, it's interesting to think, we think of rockets as great machines that happen to be filled then with fuel, much the way your car is, 95% the weight of the vehicle, and you add a few extra pounds when you fill your tank. A rocket is quite a different thing. A rocket is something like an egg, with the shell as the rocket itself actually the lightest part of the entire assembly. It's the fuel that weighs the most. A Saturn V rocket, unfueled, weighed about 1.5 million pounds. Fully fueled, it weighed 6.5 million pounds. So you had fuel weighing more than 3 times the weight of the rocket. Think of a rocket as an empty vessel that is a machine that is used to process the fuel that fills it. The load and go process is underway now. It should complete not long before launch. It does not take all that long to pump even 76,000 gallons of fuel into a 229-foot machine. So with this fueling coming, it means we are in the final stages, just 24 minutes and 40 seconds now away from launch. And we have a question from a viewer as to why the launch time is so precise, why we have what's called an instantaneous launch. You either launch at 3:22 or you don't launch at all. Why can't we push it 20 minutes? In fact, if you were launching into any old orbit with any old spacecraft, you could do that. It wouldn't make terribly much difference. But it's a very delicate ballet between the International Space Station, which is in a 51-degree orbit relative to the equator at 250 miles above Earth. It's a very delicate dance between that spacecraft and the Dragon, which will have to launch from 28 degrees, then quickly move to a 51-degree inclination, and then orbit the Earth 13 times in order to catch up with the space station, essentially to intersect the orbit. Think of it as a series of spirals. The Crew Dragon will launch, and it has to spiral out carefully until it reaches the space station's orbit. If you launch even a second or two too early or too late, you miss that intersection point. So basically, the Crew Dragon is aiming for where the space station will be 19 hours and a handful of minutes from right now. And you cannot miss that launch by more than a second or two, otherwise you will fall short of or fly wide of the space station. And it's worth reminding ourselves and it's worth reminding ourselves and our viewers one last time about what SpaceX had to do to get to this point. This is a momentous day for the for a private company launching astronauts, launching NASA astronauts, and they had to go through a great deal to ensure that their systems were reliable, that their hardware was reliable, and that they could get crews safely away from a rocket that was threatening to explode. The two great tests that they had to go through were the so-called pad abort test, when the spacecraft was on the launch pad and fired its escape engines to prove that it could get away from a rocket that was threatening to go awry, and later a launch abort test in which a Dragon crew vehicle was actually launched atop a Falcon 9 rocket, and the Falcon 9 rocket was deliberately destroyed. An instance before it was destroyed, the Dragon spacecraft was capable of firing its escape engines and taking the astronauts to safety in the event of any kind of such eventuality today. And here we're looking now at this pad abort test. This was a test. Those engines that took that spacecraft off the ground would be the ones that would pull it away from a faulty rocket should any kind of accident occur. It would separate from the service module, and it would release its parachutes, and the astronauts would then descend safely into the ocean. This, of course, is one of the reasons also that Cape Canaveral is the place from which we launch. We launch east over the ocean, which means that any accidents with rockets will fall harmlessly into the ocean and not toward population centers. It's also the reason that Russia, which does not have the same access to the same kind of warm water coastline at a low latitude, launches from Baikonur, which is very much desert. Here it looks like we're looking at the launch abort test in which a Falcon 9 was launched and then deliberately destroyed. Let's see if that's indeed the footage we're watching. But this was one more test to prove that the spacecraft could get safely away from a rocket that was in distress. And yes, here we see the spacecraft separating. Under these circumstances, the onboard systems would have sensed that the rocket was in trouble. It would have gotten the astronauts away, and that explosion of the rocket would have happened far behind where the astronauts were. On earlier spacecraft, the Mercury and Apollo spacecraft, there were escape towers on the top of the spacecraft that would pull the spacecraft away from the rocket. On the Dragon, there are escape rockets at the base of the Dragon itself that push it away from a rocket in distress. Either way, it keeps the astronauts safe.
H2 locks load started.
And we see to the left here a lot of dignitaries on the balcony of the OSB building watching as the launch is about to take place. There are astronauts here. There are military folks here. General John Raymond, the head of the newly launched Space Force, is here. This is in lieu of the much more crowded viewing stands that would typically be the place from which launches were watched, but for the COVID pandemic. Of course, looking at this balcony, we're not seeing a whole lot of people wearing face masks. We're not seeing a whole lot of people socially distancing. This coronavirus may not be the immediate news of today, but if this launch goes successfully, in 13 minutes and 14 seconds, ignition will have happened. 12 minutes afterwards, the astronauts will be in orbit, and then all of us will have to go back to our everyday lives, which include the coronavirus. This should not be meant to diminish the success of today, but it is a reminder that we are about to achieve, it looks like we're about to achieve, may achieve something extraordinary in a time of extraordinary problems, and the launch will be a pleasant break from that, but it's a reminder also that we must continue to take the virus seriously. And if you are just joining us, we are now inside of 11 minutes to launch, T-minus 10 minutes and 54 seconds. The rocket is fueled, as you can see from the vapor subliming off the side of the rocket. That is the liquid oxygen. That is the supercooled liquid oxygen. That is one of the two fuels that's used. Supercooled cryogenics, liquid oxygen actually adds weight to a rocket, not simply because of the weight of the fuel. It actually causes the humid Florida air to condense against the side of the rocket and form a thin ice shell. The Saturn V, in the time it would sit on the launch pad, used to gain about 1,200 pounds just in ice forming on the side of the rocket. There's probably a little bit of that happening on the Falcon 9 rocket today. The fueling is complete. The astronauts are in what is effectively the terminal countdown now, just awaiting ignition and awaiting for the precise moment when the International Space Station, orbiting 250 miles above at about 17,150 miles an hour, moves into precisely the right position for the SpaceX Falcon 9 rocket to light its engines and begin what will be a 19-hour chase between the two astronauts in the Dragon and the station itself. That will culminate tomorrow morning, shortly before noon, in a docking at the station.
Enjoy those views of our beautiful planet.
Thanks, Jay. It is absolutely our honor to be part of this huge effort to get the United States back in the launch business. We'll talk to you from orbit. Thank you.
Copy all. Thanks for those words. those views of our beautiful planet.
Starting TVC hydraulic press. Stage 1 and Stage 2 engine chill has started. Engine hydraulics at pressure.
And on the viewing stand, it's hard to see in the image we have, but President Trump and Vice President Pence are both there, along with NASA Administrator Jim Bridenstine. It's unclear if Elon Musk, head of SpaceX, is with them, but the President and Vice President are present. The First Lady is there as well, and Jim Bridenstine, a former congressman, appointed as NASA Administrator by President Trump in 2017, replacing previous Administrator Charlie Bolden. It is Administrator Bridenstine who has been charged now with the job of overseeing the Commercial Crew program, as well as the much more ambitious Artemis program, which is intended to land the first woman and the next man on the surface of the moon in 2024. But today their minds are less on the moon and more on this immediate launch, which is now inside of just 4 minutes away.
Vehicle tanks pressing for strong back retract. Strong back retract has started. Stage 2, RP1 please. Stage 1, RP1 please. The FTS final setup started. I'm back igniter purges. We'll go bleed. Dragon has transitioned to terminal count and is on internal power. Stage 1, locks load, close out. Vehicle is transitioning to internal power. Stage 2, lock float is closed out, propellant fills are complete. Dragon is in auto idle.
Gas closeouts is starting.
Falcon 9 is in startup. Dragon is in countdown. FTS is armed for launch. Dragon, SpaceX, go for launch.
SpaceX Dragon, we're go for launch. Let's light this candle.
T-minus 30 seconds.
Stage 1 tanks pressing for flight.
T-minus 15 seconds. 10, 9, 8, 7, 6, 5, 4, 3, 2, 1, 0. Ignition. Liftoff of the Falcon 9 and Crew Dragon. Go NASA, go SpaceX, Godspeed, Bob and Doug. Vehicle pitching downrange.
1 Alpha.
Copy, 1 Alpha.
Stage 1 propulsion is nominal.
Falcon power and telemetry nominal.
M1D throttle down.
Vehicle is supersonic.
M1D throttle up.
Max Q.
1 Bravo.
Copy, 1 Bravo.
start of MVAC engine chill. M1D throttle down. Go.
2 Alpha.
Falcon stage separation confirmed.
Copy, 2 Alpha.
MVAC ignition.
Acquisition signal lost.
Stage 2 propulsion is nominal.
Dragon SpaceX, nominal trajectory.
Signal Bermuda.
SpaceX Dragon nominal trajectory.
We've seen separation of the first stage booster, which should now be on its way to recovery on the ocean barge for reuse. On the left, we're seeing a view inside the spacecraft. To the right, we're seeing, looking back toward the end of the spacecraft,
Stage 2 propulsion is still nominal.
the tail end of the spacecraft, as that second stage engine continues propelling the astronauts to space. They are in a much smaller and much lighter vehicle than they were when they left the ground. The first stage is now gone. What is happening now is all about increasing acceleration. The crew is going to feel a maximum of 3 Gs on this flight, which is not terrible to the average person. That would be quite a lot. The average 150-pound person would feel like he or she weighed 450 pounds, but these astronauts are accustomed to eating 8 and 9 Gs in a simulator. What we should be seeing on the right now is the scene from the first stage, which is descending from midway toward space back toward the ocean. That appears to be what we are seeing. To the left is the view that you would see if you were behind Bob Behnken and Doug Hurley, looking toward the instrument panel and the windows in the front of the spacecraft. The first stage on the right is in something close to controlled freefall now. It will not reignite its engines for landing until it gets closer to the ground, but attitude control thrusters along the flank of the booster keep it aligned and keep it moving steady. When you hear nominal trajectory, that is all good news. Nominal in this case means exactly as you want it to be. right, you can see the thrusters now beginning to fire on that first stage as it slowly descends toward Earth. It is falling at a speed at this point, of course, that would not allow it to survive reentry, but it will.
Stage 2 propulsion is still good.
It will reignite its engines. S2 propulsion, as they just said, that's stage 2 propulsion. That means the second stage.
SpaceX nominal trajectory.
That means the second stage of the rocket is still proceeding to fire.
Nominal trajectory.
Position signal, New Hampshire. Stage 2 FTS is saved.
And now we can see those first stage engines have reignited as the first stage descends toward its landing barge. It is just about to penetrate through the cloud tops, and landing on the barge should be less than a minute away, though it's a little hard to tell from this perspective. It all depends on the exact height of that cloud ceiling.
And back throttle step.
Shannon.
Copy, Shannon.
Back throttle step. Back shutdown.
November 2019. Jag satt i ett samtal med Roger. Han berättade hur han hade gått från att vara stressad och pressad, vd för de 2 företag han drev, till att ha hittat.
Just about to penetrate through the cloud tops, and landing on the barge should be less than a minute away, though it's a little hard to tell from this perspective. It all depends on the exact height of that cloud ceiling.
And back throttle step.
Shannon.
Copy, Shannon.
Back throttle step. And back shutdown.
Again, SpaceX nominal orbital insertion.
Launch escape system is disarmed.
Dragon copies. Nominal orbital insertion.
Those are some sweet words, nominal orbital insertion. The Dragon spacecraft is in orbit.